Okay. When we broke last night, we're on day 4 of the hearing in WQCC 25-74 relating to surface water permitting programs. When we broke last night, we had begun commission questioning of the second NMAD panel, had not yet completed it. I'll return to Commissioner Thompson. But first this morning, in some of our pre-hearing conferences with Council, we had discussed a few commitments we were extending to a few of the parties based on witness availability. So this is the first of those accommodations for SWAG, Sportsmen and Wildlife Advocacy Groups, represented by Ms. Udall. Ms. Udall, I believe you reserved your opening statement. Please go ahead.
There we go. Good morning, Madam Hearing Officer, Mr. Chair, and members of the Commission. My name is Tarn Udall, and I'm an attorney with Western Resource Advocates. In law school, you have a lot of stressed dreams, but a real one came true this morning, which is the hotel I stayed at had a fire, and so I exited at 5 a.m. and been scrambling to find clothes and other things. So appreciate both the accommodation of our schedule today and any bumps in our road as we figure out our plan. But great to be here. I represent Trout Unlimited. Thank you. Audubon Southwest, Theodore Roosevelt Conservation Partnership, New Mexico Wildlife Federation, and Western Resource Advocates. We refer to these organizations as Sportsmen and Wildlife Advocacy Groups, or SWAG. SWAG support the rulemaking and the legislature's direct Governor Lou Hirsham, legislative leadership, and the department to protect New Mexico's waters and aquatic resources. SWAG's testimony focuses on amendments to 20.6.2 NMAC and the rules governing the discharge of dredge and fill material. In 2021, the New Mexico legislature recognized the importance and vulnerability of New Mexico's surface waters and aquatic resources when directing the Commission to adopt rules that will avoid and minimize adverse impacts to wetlands, streams, and other aquatic resources. Senate Bill 21 is clear that in regulating the discharge of dredge and fill activities, the final rules must protect all aquatic resources, which encompass New Mexico's wildlife and habitats. As SWAG's expert witnesses will testify, the draft rules and the proposed revisions in the department's Exhibit 79A go a long way towards achieving that mandate. SWAG seeks amendments to achieve two key outcomes. First, SWAG proposed streamlined permitting for voluntary restoration projects that improve the environment through restoration of degraded aquatic and riparian habitat. These projects help New Mexico's waters be more resilient to the increasingly severe impacts of fire, flooding, and drought. Our expert witnesses will outline the need for these proposed amendments and why projects that benefit streams, floodplains, wetlands, and fish passage should not face the same permitting requirements as activities that degrade those resources. Second, SWAG proposed amendments to ensure strong protections for New Mexico's most sensitive wildlife species and habitats. As our experts will testify, these species depend on state surface waters and are vulnerable to the impacts of dredge and fill activities. SWAG's recommendations, which were developed in conversation with the state's expert wildlife agency, the New Mexico Department of Wildlife, focus on ensuring the department and applicants coordinate with the Department of Wildlife at key moments to inform the department's review of permits. We appreciate the hard work and dedication of the department and commission thus far in what is a monumental undertaking. We urge the commission to adopt final rules that will ensure restoration projects can proceed at the pace and scale needed, and that will protect New Mexico's surface waters, wildlife, and habitat. With that, I'd like to call our first panel of witnesses, Dan Roper and Jacqueline Corday. We're going to start with Mr. Roper.
If you would please spell your first and last name.
Good morning, Dan Roper.
And D-A-N-R-O-P-E-R.
That's correct.
Do you swear or affirm to tell the truth?
I do.
Thank you.
Good morning, Mr. Roper. Could you please describe your current employment?
Yes, I'm currently the state director for Trout Unlimited here in New Mexico. Slow down. All right, I'll do my best. Thank you. I oversee a team of 7 staff working on a variety of restoration projects and policy issues here in the state, all with the goal of protecting and restoring our watersheds and cold water fisheries.
And what is your educational background?
I have a bachelor's degree in environmental studies from the University of North Carolina at Asheville. I also have a master's degree in public policy from Oregon State University.
Would you briefly describe your professional background?
Sure. Most of my professional background is in the natural resources. I've worked for state, federal agencies, and nonprofits in several Western states. I've worked for Trout Unlimited for just over 7 years, and before my current role as state director, I led our policy and advocacy work in the state.
Did you provide direct testimony on behalf of SWAG?
I did.
Is that written testimony, which was included as SWAG Exhibit 5, accurate to the best of your knowledge?
Yes.
And do you adopt it today?
I do.
Did you prepare a presentation for the commission?
I did.
And was it uploaded as a demonstrative?
I believe it was.
Let's then proceed with the demonstration, or sorry, the presentation.
Okay, great. Slides?
They are, yeah, you're in slide 1.
Okay, awesome. Well, good morning, commissioners. I'd like to start by thanking you for the opportunity to speak today on behalf of Trout Unlimited and our sportsmen and wildlife advocacy partners, referred to collectively in this rulemaking as SWAG. I know you all are in the midst of a long and highly technical rulemaking, and it is my hope that while important, this issue will be one of the easier matters that you deal with throughout this hearing. Next slide, please. My intent is to discuss the importance of how New Mexico will permit voluntary restoration projects and our rationale for why NMED should create a streamlined process for qualifying projects. I will also describe the benefits of such projects and provide 2 quick examples. I'll close by describing why the pace and scale at which we undertake this work, the voluntary restoration of stream and wetlands, is essential to achieving the goals and objectives identified in statewide plans like the governor's 50-year water action plan. Next, you'll hear from my colleague, Jackie Corday, who will elaborate more on the specifics of our proposal, what has been adopted by the department in their most recent draft rule, now referred to as Exhibit 79A, and 2 simple but important components that we feel are necessary and still missing. At a basic level, our red lines recommend the creation of a voluntary restoration general permit within 6 months of rule adoption, and included language to provide NMED with the necessary flexibility to adopt a streamlined permitting process for those projects. Essentially, we are asking for permitted projects undertaken solely to uplift and restore streams and wetlands to be treated as distinct from other permitted activities. And that's because they are distinct. These are projects that improve ecological function rather than cause harm. Next slide, please. There are many reasons why entities that include landowners and tribes and soil and water districts and state agencies undertake voluntary restoration. They include improving water quality, mitigating the impacts of fires and floods, elevating water tables and increasing aquifer recharge, improving habitat for fish and wildlife, reducing sedimentation and improving downstream water delivery, and important, making sure our rivers and watersheds are more resilient to drought and a changing climate. If we as a state are concerned about climate change and drought, and I think we are, this is the work we have to undertake at scale to counter those impacts and make New Mexico more resilient for what to come. There's no way around it. Regarding permits, the restoration community is familiar with the federal 404 dredge and fill permitting program. For example, the nationwide Permit 27 was created over 30 years ago for aquatic habitat restoration, and it applies to many types of stream and wetland restoration occurring today. Recently, that program underwent major revisions at the urging of organizations that do this work. This was because too often the permitting process was cumbersome and costly. It slowed projects down, it increased costs, and it took up important time and capacity for both permitting agencies and people on the ground. The The newly issued Nationwide 27 addresses many of those issues by no longer requiring a pre-construction notification or a wetlands delineation, for example. These changes represent what we would like to see in the new statewide permitting program, and our red lines were presented to provide the department with the flexibility to do that. Again, Ms. Corday will elaborate on those specifics. When it comes to doing restoration work, budgets are often tight, and it's not uncommon to cobble together funding sources to get a project off the ground. Often, each funding source has a unique timeline and requirements associated, and combined with the permitting landscape, the effect is overall a process that hinders the speed at which we accomplish this work at a time when we really need to be doing more. By adopting a streamlined permitting process for these projects, we can increase the pace and scale at which we restore rivers, streams, and wetlands, benefiting our communities and our wildlife. And we can do this while ensuring we have the proper regulatory framework in place to protect these resources. Note that we did not ask simply for all of these projects to be exempt, but we are asking for the department to have the flexibility to approach restoration permitting differently, and this rulemaking presents an opportunity to do that. Next slide, please. To illustrate the type of work I'm referring to, I will quickly highlight two examples of trout unlimited projects that would qualify as voluntary restoration under a statewide program. The first is on Little Turkey Creek in the Gila National Forest. Many of you may remember the Whitewater Baldy fire of 2012. At the time, it was the largest wildfire in state history. It severely impacted this area, as did the post-fire flooding that followed. This 1-2 punch of fire and flood really degraded the stream system. Notably, it removed native riparian vegetation, it incised the stream channel, and it eliminated a population of native Gila trout, an ESA-listed species. This project was funded through a grant from NMAC's River Stewardship Program and led by Trout Unlimited's local chapter. The objective of the project was to restore the stream to its pre-fire condition by installing low-tech wood and rock structures and planting native vegetation like willows. I'm happy to share that just a couple of years after the initial work was done, we literally see a stream coming back to life. Riparian vegetation is taking root, water quality and habitat diversity are improving, and Gila trout have been documented in the stream again. Next slide, please. Moving to the north, another project we undertook with support from both NMED and the U.S. Forest Service is the restoration of Chihuahueños Creek on the north end of the Jemez Mountains. This is a small tributary stream in the Rio Chama Basin that contains a core population of Rio Grande cutthroat trout, our state fish. It's also an important water source for downstream acequias and local ranchers. The project area consists of 4 miles of high elevation meadows and forest habitat that at the time when the work began was characterized by an incised stream channel, a disconnected floodplain, and a loss of riparian and wetland vegetation, all of which resulted in increased water temperatures and turbidity. Through the installation of literally hundreds of low-tech hand-built structures created using on-site materials to slow and spread the water and utilizing support from local youth corps, this project enhanced fish habitat, it improved water quality, it created more robust natural fire breaks, it reduced the risk of high flow events that could exacerbate issues like sediment plugs and reservoir capacity, all while increasing the recharge rate of adjacent shallow aquifers. Next slide, please. While each of these projects is beneficial on its own, they also exemplify the kind of work that needs to be done at scale to accomplish statewide goals for our watersheds, water resources, and wildlife. For example, watershed restoration is the first strategy identified in the 2020 New Mexico Forest Action Plan, and the importance of healthy streams, wetlands, and riparian areas is recognized throughout. The State Wildlife Action Plan includes goals focused on conserving and restoring aquatic, wetland, and riparian habitats across all of the state's 6 major ecoregions. And the governor's 50-year Water Action Plan calls for the acceleration of watershed restoration to reduce the risk of catastrophic fire, flooding, and large-scale erosion, all of which are necessary to protect our most important resource, clean water. I'd like to close with 3 quick things. First, I want to thank NMED for its work on this important rulemaking and for the inclusion of several of our suggestions to date. We view the department first and foremost as a partner in protecting and restoring New Mexico's watersheds, and we're grateful for the work that's been done to date to stand up this program. Next, I want to state that we remain committed to working with the department to get restoration permitting right including after this rulemaking concludes. We support an approach that protects our surface waters from small and ephemeral headwater streams to main stem rivers because they are all important, while ensuring we don't slow down important restoration work. Last, I want to stress again that two important things are not yet incorporated into the revised rules in Exhibit 79A. First, we need the final rule to include our recommendation providing NMED with greater flexibility for issuing a voluntary restoration general permit. And this is only for projects that are narrowly defined to meet the criteria and are solely for ecological lift. Second, we're requesting that the final rule requires NMED to issue such a permit within 6 months of the close of this rulemaking. This is important because it ensures that entities that do this work can proceed with regulatory certainty needed to keep these projects moving forward. Often, for example, a component of receiving grant funding is having the necessary permits in place or being able to obtain them. A prolonged period without a permit could lead to situations where New Mexico entities are ineligible or less competitive for funding and projects are delayed. These are simple changes, and we have provided the department with precise language to incorporate them. In the end, I will just say that we, as a community, as a restoration community, we engage in this work because we care about the people, the places where we live, work, and play. It really is that simple. How we permit restoration projects does matter, and it impacts all of us, even if we feel disconnected from that work taking place. And we ask for your support on this issue. Help us ensure we get it right when it comes to restoration permitting in New Mexico. Thank you.
That concludes Mr. Roper's summary of his direct testimony. Madam Hearing Officer, we have very brief rebuttal from Mr. Roper. Can we proceed?
Yes.
Thank you. Mr. Roper, have you reviewed New Mexico Natural Resources Partnership witness Tom Shelley's rebuttal testimony, which is labeled NRP Exhibit 60?
Yes, I have.
And on page 9 of that testimony, Mr. Shelley opines that SWAG's proposals regarding the need for a streamlined permitting process for voluntary restoration projects highlight that the department's proposed rules tend to increase regulatory burden on everyone in New Mexico. What is your response?
With all due respect to Mr. Shelley, I would disagree with that opinion. We are asking for voluntary restoration projects to be treated as a distinct category of permitted activities because they fundamentally are different than other dredge and fill activities. Again, these are projects intended solely to improve ecological function. They're not degrading these systems. They're not causing permanent harm. They are a distinct class of permitted projects, and for that reason, we're asking for them to be treated differently, not because we feel like the program overall is some kind of burden on the restoration community.
Thank you, Mr. Roper. I'd like to then turn to Ms. Corday.
Would you spell your first and last name, please?
Good morning. Yes, it's Jackie, Jackie, Corday, Corey.
Do you swear or affirm to tell the truth?
I do.
Thank you.
Good morning, Ms. Corday. Could you please describe your current employment?
Yes, I am a consultant, Corday Natural Resources Consulting.
Thank you. And what is your educational background?
I received my bachelor's in environmental biology at Humboldt State University and my law degree at University of Oregon School of Law.
Could you also briefly describe your professional background?
Yes. I'm going to focus on things that are most relevant to my testimony. So I call myself a land and water conservation lawyer with over 20 years of experience collaborating with numerous local, state, and federal agencies and nonprofits on natural resource issues, particularly related to rivers. That's kind of my specialty. I obtained I already told you my degree. I work at the intersection of science, policy, and law with a focus on synthesizing the latest stream and wetlands restoration research to help inform watershed policy. I previously led Colorado Parks and Wildlife's State Water Resources section, where I oversaw water resource engineers, water quality scientists, and attorneys to serve CPW's needs in relation to almost 500,000 acres of parks and state wildlife areas, in addition to a very large water portfolio that CPW holds. I supported our water quality specialist as she prepared for Water Quality Control Commission meetings to provide testimony on annual water quality rule amendments. Together, we prepared public comments during changes to the Clean Water Act 404 permit program, among other Clean Water Act sections. In 2020, I established my own consulting company in Montrose, Colorado. I work statewide, but I also work nationwide. And mainly I'm working for nonprofits to help inform on watershed policy. In 2022 and 23, I did extensive research on which types of stream restoration methods are leading to the most beneficial ecological outcomes, which led to authoring an American Rivers report in 2024 entitled Restoring Western Headwater Streams with Low-Tech Process-Based Methods, a review of the science and case study results, challenges, and opportunities. This report included synthesizing published research on the hydrological effects of restoration to downstream flows, which ended up providing key information for a legislative solution to allowing stream restoration to move forward in Colorado without having to apply for a water right or maintain an augmentation plan. The legislation, SB 23-270, resulted in an exemption for restoration with a somewhat complex list of criteria that restoration project managers must follow in order to qualify for the exemption. There became a huge need for training practitioners, agencies, and nonprofits who were involved in stream restoration so that they would know how to comply with the new law. I worked with Audubon to help develop a 3-hour training program that we presented to over 800 different attendees via webinars and in-person trainings in 2024. The training included identifying and understanding the ordinary high water mark as one of the criteria for working in a perennial stream to not impact water rights downstream. In 2025, I worked with conservation partners to provide extensive input throughout the 15-month-long rulemaking progress for Colorado to adopt a new state dredge and fill program known as Reg 87. Once again, there became a huge need for training anyone involved with stream restoration on complying with those new rules. My Audubon partner and I began doing that in 2025, and I've continued to do that in 2026.
Thank you. Did you provide both direct and rebuttal testimony on behalf of SWAG?
Yes, I did.
Is that written testimony, which was included as SWAG Exhibits 6 and 14 respectively, accurate to the best of your knowledge?
Yes, it is.
And do you adopt it today?
Yes, I do.
Did you prepare a presentation for the commission that was uploaded as a demonstrative exhibit?
Yes, I did.
Wonderful. Let's proceed with your presentation, starting with your direct testimony. Could you please summarize your direct testimony?
Yes. For the first part of my presentation, I will review the highlights and explain the basis for our direct testimony, proposed red lines to the rule. The 3 main points I'll cover are: first, SWAG recommends NMAC issues a general permit for voluntary stream restoration projects within 6 months of the rule effective date. Second, why a restoration general permit is needed and appropriate. And third, why our proposed red lines are needed to accomplish issuing a streamlined general permit for restoration projects. Okay, so are we on slide number 3?
We are.
Okay, thank you. In the next 7 slides, I'll be highlighting the key points of our proposed red line pertaining to the creation of a voluntary stream general permit, which I'm going to abbreviate as GP, so I don't have to keep repeating general permit, which, if adopted, would direct NMAC to develop and issue a voluntary restoration GP within 6 months of New Mexico's new surface water protection rules becoming effective. So three bullets here on why it's needed and appropriate. As Dan mentioned, over 30 years ago, the Army Corps issued nationwide permit 27 for aquatic habitat restoration to streamline permitting for restoration projects. The Corps has issued over 55 GPs at this point. They're now up to 60 GPs for the 2026 issuance. For all types of construction and infrastructure projects, only one of those is specifically for stream restoration, which is nationwide 27. Restoration practitioners count on having a streamlined permitting process, as often restoration budgets are tight, as Dan mentioned. A more complex and expensive permit process would essentially eliminate many projects that are on small budgets. So the second real main point is something that you may or may not be aware of, but New Mexico has thousands of miles of incised degraded streams. And I'm going to show you some pictures of that throughout my slides so you'll understand what I mean by incised. As do all Western states, unfortunately. And this is due to historic and continuing impacts of mining, logging, intensive grazing, moving and channelizing rivers, dams, and other water infrastructure, and the removal of beaver. Fortunately, over the course of the past 40 years, and the past 10 years in particular, stream restoration projects and case studies are showing the damage can be reversed. Stream natural processes can be restored, and such work can be highly beneficial to improving ecological and ecosystem services, as Dan was showing you in his examples. Including those services include improving resilience to drought, flood, and wildfire impacts. I'll address this further in my next two slides. And the third point is that agencies and organizations need a streamlined process to help ensure the critical restoration work moves forward. Next slide, please. During my introduction testimony about what I do as a background, I mentioned that I worked previously for Colorado Parks and Wildlife. In 2018, we had drought conditions that resulted in the Division of Water Resources receiving complaints from water users about wetlands, river restoration projects, and beaver dams. They were concerned these things were reducing flows to downstream users. It is important that any state action and policies be based on science, and thus I began researching what are the hydrologic effects of healthy, functioning floodplains versus degraded incised streams. Published papers indicated that connected, functioning floodplains are vital to maintaining water quality, nutrient cycling, aquifer recharge with each snow melt and monsoonal events, reduced sedimentation of water infrastructure, drought, and fire resilience. Next slide, please. So this graphic, I hope you can see it well, really helps people visualize what an incised degraded stream looks like. So when I'm talking about that is what I'm, if you can visualize that. And I also have a lot of photographs to show you that as well. But you also get to see that beautiful stream on the other side of the graphic, what it looked like previously before the degradation occurred. And most importantly, what it could look like again with restoration. All of the research done by many academic and agency scientists and restoration practitioners over this past decade in particular has helped inform why healthy functioning floodplains are so important, which has led to many beneficial laws, policies, and funding changes across the West to support restoration work moving forward. Slide 6, please. Okay, so now focusing back on our proposed red lines, the next thing I'll address is our criteria that we recommend to ensure the voluntary restoration general permit will only apply to projects intended and designed solely for restoration. We note that the federal nationwide general permit has criteria to ensure any permitted activity results in net increases in aquatic ecosystem functions and services. So that's quote out of Nationwide 27. Likewise, our red lines propose criteria that the voluntary restoration GP only apply to projects intended and designed solely for restoration by requiring: 1, the project must be a voluntary stream restoration project; 2, that does not require compensatory mitigation; 3, it's designed solely for ecological lift; and 4, they're working in a degraded surface water. So those 4 criteria help focus in on the qualifications for what projects could qualify for a restoration permit. These site boards help ensure projects focused solely on ecological lift will not qualify if they don't focus on that. They may qualify for some other type of general permit, but not the restoration permit. The definition of ecological lift, as well as the criteria, were borrowed from the Nationwide 27 and from Colorado's new dredge and fill program, Reg 87. Next slide, please. Okay. In New Mexico's rules, section 2305.b sets forth the categories of general permits that the department may issue. To effectuate the development of a GP for voluntary restoration, our red lines propose adding the new voluntary restoration GP category. The new subsection 7 cross-references back to section 2302B to define what qualifies as a voluntary restoration project, as I just had walked you through those 4 criteria. This ensures, again, that the department has the authority to consider which provisions would be most helpful. Okay, we are on slide number 8. All right. So since I filed my testimony last week, the department made numerous changes in Exhibit 79A. In response to our recommendations to develop the voluntary restoration general permit, I have reviewed these amendments in Exhibit 79 and thank the department for recognizing the need to create a voluntary restoration permit. Their changes are shown on the left of the slide, adopting a definition of voluntary restoration projects and a definition of ecological lift. However, there are 2 critical pieces of our recommended red lines that are still missing from Exhibit 79, as Dan had mentioned. And that's what I'll go over now and why we're still asking for them to be adopted. First, we are concerned that the language they added to section 2305B does not meet the key objective of creating a streamlined permit for such projects. The 6 criteria listed for the voluntary restoration GP are exactly the same as for all dredge or fill projects. So that means restoration project GPs will be treated the same as a GP developed for installing utility lines or oil and gas pipelines or linear transportation projects, among other construction or development. Even though GPs will have conditions and BMPs, best management practices, required to minimize impacts, development projects will still have adverse impacts on streams and wetlands, but restoration projects will improve the ecology of the streams and thus should not be treated the same. They should receive a streamlined GP as compared to development projects. And that was why we provided language in our red lines in our direct testimony that showed exactly how you could give the department flexibility to achieve a streamlined permit. Again, for comparison to the 60 nationwide permits that the Army Corps has issued for 2026, the requirements for projects utilizing, for example, Nationwide 57 to install or maintain utility lines, or Nationwide 14 to install linear transportation projects, require a pre-construction notification, otherwise known as a PCN, to the Corps, and they must provide more detailed information than what project managers have to under the Nationwide 27. So the nationwide 27 is more streamlined than all those other 60 or 59 nationwide permits on the Army Corps. This is the type of streamlining that would be very helpful for a New Mexico voluntary stream restoration GP to facilitate it happening across the state. So that was the first point of what we're still asking for. Second, the department did not adopt our recommendation that the voluntary stream restoration be issued within 6 months of the effective date of the new rules. The current version of the rule under section 2302 requires the department to adopt at least one GP within 6 months, but we were asking them to adopt one, keep that language of the one per GP, but also adopt in addition the voluntary stream restoration general permit, so that we were asking for 2 to get adopted within 6 months. So it's possible that the department could choose for the one general permit that they adopt within 6 months to be the voluntary stream restoration, but there's no guarantees of that. And so that's why we're asking for it to still be the red line that we asked for, which is they adopt within 6 months the voluntary stream restoration general permit. Okay. Slide number 9. Thank you. This one we can go over fairly quick. This one is 2306. It lists 8 different situations in which the department will require an applicant to obtain an individual permit in lieu of a general permit if there's certain things happening that are going to be of greater concern to the department for adverse impacts on the environment. And one of those situations is if a project is going to happen in a designated outstanding national resource water, or ONRW. So of the 1,700 miles of stream, rivers, and wetlands designated as ONRW, even though most are located on public lands, many are degraded and in need of restoration, and some sites are already in the process of being restored. The current language would require any type of activity in an NORW to get an individual permit, even restoration. So we asked for an exception so that if you're doing a voluntary stream restoration project in an ONRW, you would not have to get an individual permit. Hopefully there will be the voluntary stream restoration general permit that you'll be able to apply for. And so this, we are very thankful that the department did indeed in Exhibit 79A adopt our recommendations on this. That's why I'm not going to spend as much time as I had previously thought that I would. So I will go on to the next. The last thing is on the direct testimony is the proposed general permit fee table includes several types of permits that would have a fee of $0, such as minor construction, minor dredge and fill, emergency dredge or fill. The intent seems clear that the activities will either cause minor temporary impacts or the need for emergencies to act fast and not incur a fee. This rationale applies as well to voluntary restoration projects, which should be encouraged and facilitated by the state. And again, we are grateful that NMAC in Exhibit 79A has also agreed with us on that. So we're good to go on that one. Okay, slide number 11, please. All right, now I'm going to be moving on to the second part of my presentation, which is in response to rebuttal testimony in response to NRP's witness Brian Lindenlaub. The 2 main points I'll cover for rebuttal is first, offering alternatives to the definition of uplands proposed by NRP, and second, opposing NRP's red lines in 2307K to require using the ordinary high water mark for lateral stream boundary. Okay, next slide, please. So first, uplands. We agree that a definition of upland could be included in the rules. but we do not agree with adopting NRP's proposed definition of upland, as it does not comport with how the word upland is used in NMED's proposed rules, nor does the definition align with the common use or understanding of the word. In the draft rules, the word upland is used as follows. First, to define the riparian area as lying between the edge of the stream channel or wetland and the adjacent upland area. And I'm going to have a graphic to show you what that means. Second, it's included in the best management practices listed in the rule. And, oh, I'm sorry. Oh, there we go. Which says dewatering discharges. Appropriate dewatering BMPs include discharging to a sediment basin within an uplands area behind a vegetation buffer. The whole purpose of doing that is to make sure your landing pad for your construction that you're going to be doing, your dewatering practices, those should be in the upland away from the stream corridor. That is how uplands are doing that kind of work in the uplands is going to protect the stream. And the second bullet there is erosion control. This is a quote from the rule. Establish and maintain upland buffers between upland construction and all surface water and aquatic resources. Again, that is a best management practice to protect the river corridor from the construction that's happening. These examples show how the word upland is being used in the customary understanding that upland refers to the elevated land areas located outside of the boundaries of the floodplain and the riparian area, the most precious of the resources that you want to protect. While the floodplain is the low-lying area prone to periodic inundation, uplands are defined by their higher elevation and not routinely flooding. In the photograph, oh, I'm sorry, since I can't see this.
Now?
I'm on the graphic now.
Okay, great.
Yeah. Okay. So this slide, for those of you who may not be as familiar with the ordinary high water mark, maybe it's not something that you've had to work with in other regulations. So I just wanted to spend one slide on defining and showing what does that mean, really. The ordinary high water mark is most equivalent to the top of the active channel, as shown in this the graphic from the USACH. The ordinary high water mark is usually not adjacent to the upland, as you can see in this graphic. Instead, ordinary high water mark typically marks the inner edge of the floodplain, which then transitions to upland on the outer edge of the floodplain, with greatly varying widths depending on the topography and the river size. Uplands in the graphic begin on the outside edge of the floodplain. This graphic is also useful to illustrate NMAC's definition of riparian area as lying between the edge of the stream channel and the adjacent upland area. So in the graphic, everything you're seeing in the green is that riparian area, which then transitions to the upland. Okay. And this, thus, while it is true that uplands do not lie below the ordinary high water mark, that wording is misleading. That the definition that NRP has recommended, as it can lead to infer that uplands could be interpreted as anything above the ordinary high water mark, which would be inaccurate and conflict with how the term is used in the draft rules, as shown in the previous slide. So what we recommend is considering other definitions. If you're going to, you can either not adopt an upland definition, there's not currently one in the rule, or you could adopt one that is more in comports with how the word upland is used in the rule. And so we offer two suggestions here. Uplands means the elevated lands that are not regularly inundated, with water located outside the boundaries of a floodplain and riparian area, and that under normal circumstances are not wetlands. And you can see on the other side of the slide an example from the Army Corps of Engineers manual, their 2025 delineation of ordinary high water mark manual. And you can see that they also offer another definition. Okay. Slide number 15. Okay, next I'll address our rebuttal testimony regarding NRP's red lines for 2307K, which you can see here on the slide. They are basically asking for a definition of ordinary high water mark that comes from the 2025 Army Corps of Engineers manual, which that's not a problem, but it's how they're trying to use it that is problematic. So they're trying to say basically that for every decision that NMAC has to make to decide the lateral extent of the surface water, they want them to use the ordinary high water mark. And so the problem is, one of the biggest shortcomings of the 404 permit rules is that the lateral jurisdiction of waters of the United States, WOTUS, is determined by the ordinary high water mark, which is a term developed over 100 years ago to construct a legal way to determine where the lateral extent of the river ends and dry land begins. For the Rivers and Harbors Act of 1899, that's when that was first developed. 125 years later, that metric no longer reflects the condition of the majority of our rivers, nor the knowledge we've gained about the importance of healthy, functioning floodplains to clean water. This is very important consideration for New Mexico, New Mexico's new program, because unfortunately, as I had mentioned previously, the majority of streams in New Mexico have experienced some degree of floodplain alteration. Thousands of miles of intermittent and ephemeral streams are incised to varying degrees. And again, the main causes being current, historic and current stressors, alterations to flows, channelization, developments, removal of beaver, and unmanaged grazing. Another critical consideration is that the vast majority of New Mexico's streams are classified as intermittent and ephemeral. As you heard from NMAC previously, about 96% of New Mexico's rivers are ephemeral and intermittent. And so therefore, the vast majority of them are going to fall under this new permitting program. Perennial streams, of course, will definitely still be managed under the Army Corps of Engineers 404 program. But the unknown, the gray part, is intermittent. That's what's still a little bit up in the air as there's new rules being proposed. Okay. So slide number 16. Okay, again, this one is kind of to help you understand a little bit more about how the ordinary high water mark is defined and delineated by the Army Corps of Engineers. All of this information that's on this slide was taken out of their new 2025 manual about how to delineate the ordinary high water mark. So you see in the middle of the slide is language that was pulled right out of the manual. It's really about looking at markers along the edge of the stream and vegetation and transition and transitions. So it is a well-known marker, but again, the manual doesn't deal with the fact that a lot of our streams are no longer where they used to be, healthy and connected to the floodplain. They're incised. So this next slide shows the ordinary high water definition assumes a functional lateral connection between the stream and the floodplain. Here are examples of when the ordinary high water mark is relevant and useful to determining the lateral extent of the stream. On the left photo, you can see an orange line represents the toe of the slope, the beginning of the uplands, and the outer edge of the floodplain. It is also the ordinary high water mark in this example. The river on the right has a floodplain extending into the forest beyond the riparian vegetation. You see along the river edge, the ordinary high water mark isn't plainly visible because it's somewhere behind all of that healthy riparian vegetation. Okay, the next. And here is a graphic from that from the Army Corps of Engineers delineation manual, showing that the ordinary high water mark is on the valley edge or edge of the uplands when beaver are present, a natural condition of many higher elevation New Mexico streams. In the photo, the ordinary high water mark is approximately where the vegetation ends and the upland begins, as shown by those lines that I put on there. So that's when the ordinary high water mark is relevant, and we have no problem with it being used then when streams are healthy and connected. But unfortunately, in the next slide, you'll see that this is the condition, unfortunately, of many streams. They're downcut, they're incised, they're disconnected from the floodplain, and the ordinary high water mark can develop near the bottom of the trench, far below the actual now isolated formal bankful elevation, failing to reflect the true natural hydrologic extent of the water body prior to the degradation. In these instances, the ordinary high water mark moves from being at the bankful or some point on the floodplain, or even the edge of the floodplain, as I showed you in the two previous examples, to dropping downward into the incision, a very unnatural condition. Thus, using the ordinary high water mark in these situations renders the floodplain non-jurisdictional and unprotected from the impacts of dredge and fill activities, an outcome New Mexico can and should avoid by not adopting NRP's proposed language. In the next slide, this is another example of what is at stake. This stream was likely never a small ribbon of flowing water down in a trench, but formerly a valley-wide ribbon of wetland meadows, as the other picture you see. Using the ordinary high water mark could potentially condemn it forever, being in this unnatural degraded state, as everything above that orange line you see in the photograph would be outside NMED's new dredge and fill program if you adopted that language that NRP is proposing. And thus a project to fill and develop above the orange line could proceed without a dredge and fill permit. So that is why it's such a significant issue. So in this next slide are photos that were of rivers and streams in New Mexico that are incised. So just to give you examples of photographs from around New Mexico of showing rivers that are disconnected from their floodplains. But as Dan has shown you, restoration can turn that around. And the next slide, the current NMED draft rule does not limit the lateral jurisdiction of streams to the ordinary high water mark as proposed by NRP. A report from the National Association of Wetland Managers compares all 50 states' streams jurisdiction and mitigation programs and indicates that although ordinary high water mark is used by some states to determine the lateral jurisdiction of streams, many states use other methods such as top of bank to top of bank, bankful being fairly common. The report indicates these other methods can include a wider area than the ordinary high water mark, especially in cases when the stream is incised, and hence are more protective of natural stream systems. Under SB 21, New Mexico is not hemmed in by that limitation and is not obligated to adopt the Army Corps jurisdictional limitation that condemns streams to a degraded condition if development occurs in that former stream footprint. Adopting the red line carries on inadequate federal 404 metric that leaves incised streams unprotected. There are other possible approaches as outlined in this report that NMED could develop guidelines on this topic post-rule adoption. As Shelley Long indicated in her testimony on Tuesday, There are some permit program details that will be worked out post rule as guidance. And that concludes my testimony.
Thank you. Ms. Corday, the panel now stands for questioning.
Thank you very much, Ms. Corday and Mr. Roper. We'll be questioning for NRP, Mr. Boutsier.
Good morning, Mr. Roper and Ms. Carday. Am I saying your names correctly?
Good morning. Yes, thank you.
I'd like to start by thanking you for your work in river restoration activities. I feel that's a very, very important and laudable activity you're engaged in. And as far as the voluntary programs you described and the streamline improvement, I'm not sure that there would be much opposition to that from the Natural Resources Partnership. My name is Stuart Boutsier. I'm with the Model Sperling Law Firm in Albuquerque. I'm one of the lawyers representing the Natural Resources Partnership. One thing that I did notice is that
oh, thank you. I apologize. The one thing I did notice before we get to the ordinary high water mark in one of your slides relating to the voluntary restoration concept, I did notice that for zero fees, general permits for zero fees, you had stricken some of the language and replaced it with voluntary. And I think the language you struck was something like minimal or minor. And I wondered if you could sort of explain the basis for that.
Yeah, we just did that because we didn't see the definition of minor anywhere. So it was very unclear to us what is a minor. And so that's the only reason we struck it and replaced it with a voluntary.
Okay, thank you. Let me just back up. I think, Ms. Carday, that you had indicated that you're sort of currently operating at the intersection of law and policy, and I think there might have been a third thing in there.
Science.
Science. Okay. Let me explore that a little bit. Are you currently a member of a bar of any state?
No, I practiced law in Oregon after I graduated and passed the bar there. I moved to Montana, took the bar again, practiced law there. And then when I went to work for CPW in 2013 and I moved to Colorado, I did not need to be licensed to work in the capacity in the job that I was going to be doing for CPW. So I decided I didn't want to take a third bar. And so since then, I have not been practicing law. And of course, that's why I'm a consultant and not representing as an attorney.
Okay, thank you. And so I guess can I assume from that you're not offering any legal opinions in today's proceeding?
That is correct.
So to the extent that you consider yourself practicing at the intersection of law, policy, and science, the law part of that is not a part of what you're testifying.
That is correct.
Yeah. And you're not obviously admitted to practice law in New Mexico.
That is correct.
I noticed that you had, as part of your voluntary program proposal, that SWAG, the party that you represent, is proposing certain criteria as part of what you showed on one of your slides. And can I take a step back and just talk about criteria and the importance of criteria in regulations of the kind that are being considered by this commission? What is your view of the importance of having clear criteria built right into a rule?
So of course it's just opinion, my opinion. I feel like there should be enough clarity so that applicants, future applicants should be able to understand the basics of does their project fit into the basics of the rules I also feel it's important for the department to have some flexibility to develop things post rulemaking as guidance. Because if you locked everything in to the rulemaking process, then anytime that there is a change that needs to be made based on actual experience of applying the law, new science that comes up, you're locked into coming back and having to do a rulemaking process. And so there is good trying to find that balance, you know, so that there is enough clarity in the rule, but then also being able to have flexibility to do things in guidance. That was what was clearly what happened with Reg 87. There were certainly things that needed to be developed post-rule as guidance.
Okay, thank you. And I want to get to Reg 87 in a little bit, but so if I understand your testimony, it's although you believe there should be an opportunity for an agency such as NMED to develop guidance for a program, you believe there's sort of a minimum amount of criteria that really needs to be in the rule itself so that parties can read the rule itself and understand how it applies to their project. Is that a fair statement?
Yeah, I would say that. Of course, it would depend on each particular thing, but in the case of the stream restoration, I wanted there to be clear, established criteria that could then be later fleshed out in guidance. And I think those 4 elements that I went over gives enough clarity for folks to understand the basics of what a project would need to be in order to qualify for a voluntary restoration EP.
Okay. And when you use the term guidance, I assume that you're referring to something that's not non-binding. In other words, it doesn't have the effect of being part of a rule of law. Is that correct?
Yeah, to give an example, again with Reg 87, the voluntary stream restoration, it was actually an exemption for just ephemeral streams that we borrowed from with those 4 criteria. There was the need for guidance to flesh that out more. The guidance is not have the same legal binding effect as what's actually in the rules.
Okay, thank you. And so that the guidance that you're talking about might be guidance that is useful internally with the agency that's administering the rule. Is that correct?
Both the agency staff that are administrating the rule and applicants, you know, applicants who want to do that particular thing, the voluntary stream restoration.
And again, it's guidance, helpful information and guidance, and not necessarily, would not be binding per se.
Yes.
As law. Okay, thank you. Let's do talk for a minute about Reg 87. Am I correct in my understanding that Reg 87 in Colorado is somewhat similar to what is being contemplated in the surface water permitting part of the rulemaking that we're involved in this proceeding?
The dredge and fill, only the dredge and fill.
Okay, and that's a reg that is similar to what's being proposed in this case. Is designed to protect waters that are no longer after the Sackett decision, waters of the United States. Is that correct?
Let me explain a little bit further on that. So similar to New Mexico, the state of Colorado defines waters as state waters. Here it's surface waters. In Colorado, it's state waters. And the definition of state waters is comprehensive, just like the surface water definition is for New Mexico. So during the legislative process, certainly there were folks that say, hey, this is just going to be a gap program, right? And then there were folks that were like, no, this needs to be cover all of state waters, just like the other rules, Clean Water Act rules that Colorado enforces. And so they did adopt a continue to adopt a comprehensive, let's say, how the rule is applied is comprehensive. So they have jurisdiction over all of state waters, and then there are exclusions and exceptions.
Okay, and in that answer, you refer to surface waters of the state here in New Mexico, and in this rulemaking as being similarly comprehensive as Colorado.
Right.
But actually, have you reviewed the newer definition offered by NMAC that excludes WOTUS from the definition of surface?
I have read that.
Okay. Do you have an understanding of?
Madam Hearing Officer, I would object. This is outside the scope
Yeah.
of Ms. Corday's direct testimony.
Okay, I can move on. Okay. Back to Reg 87. Can you sort of generally describe that for me in terms of the, how many pages of
Similar
Reg
objection, to the extent that Ms. Corday testified about Reg 87 is quite narrow.
Well, Madam Hearing Officer, that Ms. Udall may be correct that it was a fairly narrow reference, but it was related to Reg 87, and I think it's appropriate to explore that.
Yeah, Ms. Corday, to the extent you have testimony to offer that relates to the testimony you gave, you can give that. Otherwise, I don't know, is a finding.
I believe it's about 120 pages.
Okay, thank you.
Comprehensive.
And is that because it's fairly detailed in the description of the criteria that is actually part of the rule to determine what may be a state water in the case of Colorado?
That I don't feel comfortable testifying on. It's a little bit beyond.
Okay, thank you. Now, the part of your testimony that takes issue with the Natural Resources Partnership's use of the ordinary high water mark, I'd like to explore that with you a little bit. First of all, let me ask you, under the scenarios you indicated where there's an incision river that may not, that may be below the floodplain and all that, that's an area that, do you have any understanding of whether a discharge outside the ordinary high water mark in the scenario that's presented by your slides, whether that kind of discharge might require another type of permit that's administered by the Environment Department here in New Mexico, and that is a groundwater discharge permit?
That would be beyond what I studied for this.
Okay, and in I guess disputing the Natural Resources Partnership's proposed use of ordinary high water mark, you're not suggesting that the ordinary high water mark, as that term has been used and developed in Army Corps, I was going to say jurisprudence, but it wouldn't actually be jurisprudence. You're not suggesting that the 404 Army Corps ordinary high water mark is what should supplant the proposed definition of ordinary high water mark for New Mexico?
I'm sorry, your question wasn't.
It was not very clear.
No, it wasn't.
So I think you acknowledge that you're not suggesting that this commission use ordinary high water mark exactly as the Army Corps of Engineers uses it as it has developed under the Section 404 program.
So I'll get at what I think you're getting at.
Okay.
So I am not suggesting that the Army Corps of Engineers ordinary high water mark isn't ever relevant. That's not what I'm saying. I am saying that, the Army Corps of Engineers ordinary high water mark and basically that 2025 manual is pretty much the Bible for how you identify ordinary high water mark. I have no problem with that being used, and the definition that NRP proposed for ordinary high water mark comes from the 404 definition. So I don't have any qualms at all with that definition or how the Corps uses it. My point is that marker, ordinary high water mark, using that for degraded inside streams is wholly inadequate to protect those streams. And that the ordinary high water mark and how it is used by the Army Corps has not evolved and kept up with the science and our understanding of what a healthy connected floodplain is, how important that is to clean water. That's what I'm saying.
And okay, thank you. And let me ask you, are you equating riparian area with floodplain?
Yes, I mean, floodplain and riparian, they're in the same, generally the same area. It's all part of it. As that graphic I showed from the Army Corps of Engineers shows it in the floodplain, riparian.
And would you agree with me that there are riparian areas outside of floodplains?
No, I wouldn't agree.
Okay, so you equate floodplains with riparian areas, correct?
Yeah, so does the Army Corps of Engineers. In that graphic that I showed, riparian area is in the floodplain.
Is it SWAG's intention to offer a particular definition change to the surface waters of the state as proposed by the Environment Department?
No, not in my testimony. That is not what we're doing.
Okay. So you're not, your testimony today is not intending to include the term floodplain or riparian area in the definition of surface waters of the state.
I'm not offering any definition changes. That is correct.
All right, thank you very much. That's all the questions I have. And I think one of my co-counsel will have some questions for you, Mr. Roper. Is it Mr. or Dr.?
Mr. Rope?
Mr. Roper, yeah, thank you.
Thank you, Mr. Boutsier. Who's the next questioner? Ms. Saluha.
Hi, Mr. Roper. My name is Serafina. It's nice to meet you. And I'll only have a few questions for you.
Sure.
So to be clear, your testimony proposes a special streamlined permit for restoration projects. Is that correct?
It does.
And one of the reasons is because restoration projects often operate on limited budgets.
I would say that's correct. That's one of the reasons, but that reason I think should be considered within the full scope of why we think this is important, including primarily just the dire need to uplift these systems.
I think you said another reason is because delays can cause projects to miss seasonal construction windows. Is that right?
Yes, that can and does happen. We do see projects delayed for reasons around permitting.
Okay. So we can agree that your proposal is based, at least in part, on a concern that the proposed permitting process could delay projects and increase program costs.
I don't think I'd go that far. From our take, I think our position is simply that we're asking for voluntary restoration projects to be treated differently because they are different projects from other permitted activities. I'd probably leave it at that unless there was a part of your question I didn't get to.
No, I think that answered it, and I have no further questions. Thank you.
Thank you, Ms. Saluha. Anyone else from NRP? No? Thank you, Mr. Boutsier. Mr. Stump, do you have questions for the Water Utility Authority?
Again, Madam Leader, and after I waited for everybody waiting for me to walk up here and say, you know.
Thank you very much. Mr. Stump declined. Ms. Taylor. Thank you, Ms. Taylor. She declined. Mr. Parkamenko, are you on the platform?
I am Madam Hearing Officer, but I have no questions. Thank you.
Thank you. Let's see, Mr. Brooks.
No questions on the
Okay, are there any other council from the ag districts with questions? Oh, all righty. Ms. Richards.
I just have a few.
All right.
Good morning, members of the panel. My name is Dory Richards. I represent the Department of Energy. I'm pulling it closer. Mr. Ripper, I have just a couple of questions for you. Does your entity have a banking or credit program?
Could you elaborate on the question? I'm not sure what you mean by banking or credit
A
program.
restoration banking or credit program, something similar to like
Mm.
the ESA mitigation credit program.
Yes, we, to my knowledge, have no such program that we operate independently. It is very possible, though I couldn't speak to the particulars today, that as an organization that has a presence in 30 plus states across the country and nearly 400 employees, that we have been involved in restoration work that is somehow tied to, say, banking of some form, but we have no program internally that I think is wholly ours, at least not to my knowledge.
Do you think it makes some sense to have a restoration banking or credit program to, I guess, get the biggest bang for your buck? And what I mean by that is to restore an area in a watershed that would have a lot of positive returns versus spending money and effort on an ephemeral stream that has very little flow and very little advantage to that watershed?
Ms. Richards, I have not spent much time, that's outside the scope of my testimony. I haven't spent much time thinking about the particulars of how restoration banking would work in this state, though I will say I would disagree with your characterization of the importance of ephemeral streams. I mean, we see many of our ephemeral and intermittent streams are incredibly important to the ecological integrity of our rivers and watersheds, and including many of our native trout streams don't flow year round or are only perennial in segments. So yeah, just want to point out that the restoration of ephemeral waters, intermittent waters, to me, it has to be part of the strategy here in New Mexico.
And I wasn't saying that ephemeral streams aren't important, but I am saying that some have no flow and they're hydrologically have been studied to demonstrate that. And what I was suggesting based on your work in restoration is if you have a water body that could benefit very quickly, increase flow and quantity, as well as quality, would it make sense to have that significant improvement versus perhaps a ephemeral reach that is very sandy, has flow maybe once every 3 or 4 years, and it doesn't flow more than, very slight period? Which restoration project would you folks prefer to focus on?
Well, like most organizations, we have a set of criteria and how we prioritize restoration work, and it goes well beyond how often there is water in a stream channel. We look at things like habitat complexity, threatened and endangered species, downstream benefits for acequias and landowners. So it's hard for me to answer that without kind of the full scope of exactly project A, project B, what are conditions on the ground, what are the benefits, both ecological and societal from those projects.
But there could be some benefit depending on the circumstances.
I think that's true.
And Ms. Corday, on the voluntary restoration permit, I just wanted to get a little bit of clarity. Who do you perceive as the permit holder for that general permit, since it's voluntary?
So mostly it's going to be nonprofits. Nonprofits that are usually working with the Forest Service, the BLM, or maybe even a private landowner to do a voluntary stream restoration.
And from your experience in the work that you've done, if an entity, I guess this is getting back to the whole credit, what can we do? So if you have a facility and you need to make sure your facility isn't flooded, sometimes ephemeral streams might have extra water in it during monsoon season or something like that, but it dissipates, creates a sandbank, and then you're going to have, flooding in other areas, right? So sometimes you have to clean out those channels to make sure that the arroyo stays intact. What I'm wondering is, as an offset of that, would it make some sense to have these voluntary restoration permits where you've done work in the same watershed that can enhance another water body that has more significant flow and improvement opportunities?
I'm just not clear on the
Sure.
example that you're giving,
Yeah,
so I don't feel comfortable responding.
So I'm just trying to, I'm looking at what I'm hearing is, you know, the need for restoration, improvement, water quality, and quantity. Everyone is aware of those needs out in the West, right? And so I'm trying to ascertain whether your type of program they're advocating for, the changes in this rule, if it would make some sense for some companies to be able to avail themselves to that voluntary opportunity, again, for the most significant quality improvement versus those small ephemeral reaches that are not accessible to the public, that have very little hydrology, that do not support aquatic life. Do you see that type of opportunity in a voluntary restoration permit program?
I think to object, I think this is outside the scope and invites some speculation.
Is Corday, I don't know if you have a response to the question, if you were able to follow it.
Great. I'll just say that the criteria do not require that it be a nonprofit. It doesn't require it to be a public agency. It could be anybody who meets the criteria. You use the word company. Could a company qualify for doing this work if they need to do some work on land that potentially they own and they see the benefit to themselves to do this voluntary restoration work? They can do that. There's nothing in the criteria that says you have to be a profit, but you had asked me who do you most often do these projects, and
Right.
that's the way I answered your question, is who most often does it is nonprofits and public land agencies. But again, there's no criteria that says a company couldn't do this if they meet the criteria.
Right. And my questions were really, again, kind of focused, you know, familiar with general environmental law principles, Endangered Species Act. For example, if you have a facility, you can't avoid an impact. You can do restoration projects nearby to benefit a species. And I'm thinking about your voluntary restoration permit proposal in that same vein. So that's why I was asking those questions to see if it can be used for a bigger benefit offsite. So no more questions. Thank you.
Thank you, Ms. Richards. Ms. Dolan? Are you on the platform?
Thank you. I have no questions, thanks.
Thank you. Mr. Maxwell, if you're on the platform. Louise? No. Mr. Weatherby, if you're on the platform.
Thank you, Madam Hearing Officer.
Okay, no questions. Mr. Crimsey?
No, sir.
All right, Mr. Crimsey declined. Ms. Miller might be on the platform. Nope. Okay. Mr. Micklejohn. Thank you. Mr. Micklejohn declined. Ms. Fox.
No questions, Madam Hearing Officer. Thank you for your testimony.
Ms. Fox declined. Ms. Scott or Ms. Weatherly? Let's see. No. All right. Ms. Udall, do you have redirect?
Just to thank you. Ms. Corday, can you describe your understanding of how the legislature directed the commission to adopt rules to protect riparian areas and habitat?
Sorry.
Let me say it in a different way. You received some questions around your understanding of floodplains and riparian habitat, and your understanding, or should the commission be considering rules that also protect the riparian area?
Just in my opinion would be, you know, conforming to the definition of riparian or aquatic resource that is already defined in previous law. It was wrapped into SB 21, I believe. And so that's where it's relevant. It's already in the law, the definition of aquatic resource, which includes riparian.
Thank you. And then finally, regarding the ordinary high water mark, in your opinion, what would be the impact on New Mexico streams if the commission adopted the NRP proposal?
Significant, just because as I testified, the vast majority of New Mexico streams are ephemeral or intermittent, and therefore are going to fall under this program. And unfortunately, again, a lot of them are degraded and incised. And so if you adopted that proposal, you just stand the risk of allowing for development to occur within the former area of that stream before it was degraded and incised and the ordinary high water mark went down to the trench.
Thank you. No further questions.
All right, thank you. Let's take a break to 10:40, and when we return, we'll begin with commission questions.
You clarify if needs.
Oh, thank you. Thank you, Commissioner Sloan. Let's go back from the break. Okay, thank you. All right. Alrighty, we are back after a short break, and we're going to begin commission questioning of the first of the SWAG panels. Let's start on this end. Commissioner Behill? Commissioner Sloan? No. I saw Commissioner Hall downstairs at the coffee machine. When he comes back in, I'll call on him. Let's see, Commissioner Thompson.
Thank you, and thank you for your presentation. I'd like to just interject. I went to Humboldt State College back when dinosaurs roamed the face of the earth. Humboldt State College. It's a great place. I have one question, and this is Ms. Corday. Are you familiar with NMAC's hydrology protocol?
I took a look at it online, but I just, that's all I did. You know, I just kind of tried to understand what it was. And my brief understanding was that it's a tool that helps define ephemeral, intermittent, and perennial streams. That's kind of what the tool is geared towards.
Actually, it's much bigger than that.
Okay.
But my question is, does it have a definition of original high water mark?
That, I'm sorry, I do not know.
That's fine. Thank you very much.
Mm-hmm.
Thank you, Commissioner Hall. Do you have questions of this panel?
Not at this time, thank you.
Thank you. Commissioner Chapman.
Yeah, just a few. Well, thank you for being here this morning, and thank you for the work that you do and the testimony you provided. I've got one question for Mr. Roper, and I noticed that Trout Unlimited was a participating organization in SWAP, the Surface Water Advisory Panel. Can you just briefly talk about your experience serving on that panel?
I can. Thank you for the question, Commissioner. While it wasn't that long ago, it feels like a very long time ago, but we, Trout Unlimited, served on the Surface Water Advisory Panel along with a partner organization, ECHO. I mean, I guess feel free to, if there's something more you'd like me to speak to, please ask. I'll speak at just a very high level and say I think it was a really good opportunity to be in a room with stakeholders from all across the state, from different types of permitted entities, to learn from each other, to hear from each other, and to very early in the process provide feedback and comments to the department in the early stages of this rulemaking. I don't think they had to do that, and they did that, and it was appreciated.
Yeah, thank you. And my next question is for Ms. Corday. So you outlined receptive changes that the department made to Exhibit 79, and then talk about a little bit of some amendments that you would appreciate being added. Based on the receptive nature of the department to your proposed changes, what's your understanding of the rationale of not addressing the other amendments?
I wish I knew. Sorry. We don't know why the department didn't choose those two things, the 6 month and having discretion. So we don't know the answer to that. So hopefully maybe that will be something further you guys can discuss together.
Okay, thank you.
Commissioner Fry.
Thank you, Madam Hearing Officer. So I'm going to expect that Mr. Roper can answer this question, and I'm coming from, like, I don't have any experience with this kind of restoration you're talking about. And so I'm just trying to wrap my head around what is involved. So have you been involved in the permitting process in the past?
Commissioner Frey, my role at Trout Unlimited is different than our team of project managers. So I am, while I'm not typically the person, for example, managing a project or pulling the permits, I am a part of the team. So I have familiarity with the permitting process. If we go too much into the weeds on this topic of what is involved for a particular permit, I may want to defer to Ms. Corday.
Okay, I think, you know, the general information I'm needing, you should be fine for this.
Okay.
So, once you have the permit and you're working on, I don't know if it's going to be a wetland or if it's going to be these streams that have been sized. What kind of disruption can you expect? Because I don't know. I'm thinking of, you know, you've got earth movers out there, and I don't know what you would have out there. Would you see significant degradation before you see improvement through these kinds of activities?
Commissioner Frey, it is common to anticipate a small amount of temporary impact degradation associated with a project. Just anytime you're in a stream working, moving material around, that can occur. But by and large, the result of these projects is we are making these systems better, right? Any small impairment in a project done well pales in comparison to the benefit we get from those projects. Ms. Corday could, I think, speak much more eloquently than I can about things like best management practices and other things associated with permits. But there's more to a permit than just the permit itself, right? There are a whole set of criteria and standards and best management practices that inform how you approach that work. And it's going to be different than a project on a small stream, maybe just utilizing on-site materials with hand crews, than it is when you are in a bigger river system using machinery. But all of those, I mean, I think the good part about this is there's a lot of experience collectively here in New Mexico with both those that do the work and hold the permits and the permitting agencies to kind of know what works, what doesn't. Those things have been refined over the years. As I mentioned in my testimony, organizations like Trout Unlimited have decades of experience with a nationwide 27 permit alone. So there's a lot, I'll just go back saying there's more to the permit than just the permit itself. There's the whole body of experience and the best management practices that go along with that.
Okay. But so within the permitting process, those kinds of considerations, like that would be part of the process to get to the permit, is understanding that, you know, there may be some disruption and understanding how much disruption.
Yes, both understanding it and minimizing it to the maximum extent that you can.
Great.
Yes.
Okay. Thank you very much.
Commissioner Levy.
Yes, thank you. Thank you guys for your testimony. Let me get this a little closer. I just have a few questions for clarification in part, just to make sure I understood and followed the conversation correctly. During your cross-examination with NPR, there was a statement that I was hoping I could get a little bit more clarity on. Under Regulation 87, did you suggest that the voluntary restoration projects are exempt from the regulation?
The way that we proposed and it was structured in Reg 87 was that it was an exemption only for ephemeral streams. And that was because that was to maintain the status quo. So in Colorado, as in other Western states, working in ephemeral streams generally has not been a WOTUS, so it hasn't been subject to the nationwide 27 permit. And we know that those projects in particular were really done on very small budgets. In fact, the work that is done on ephemeral streams was developed by a fellow named Bill Zedek, who was a former U.S. Forest Service employee here in New Mexico. And he started doing work on New Mexico ephemeral streams to try to stop the really bad erosion gullies that happen to ephemeral streams that eat wet meadows. I have some beautiful pictures in another slideshow. I would have loved to have shown you what that work looks like. So he came to Colorado and started teaching people in Colorado how to do that work. And that was about a decade ago. And so we were seeing that that work was getting done and doing incredible beneficial things for Gunnison sage grouse. It was protecting wet meadows and rangelands. And so when the legislative process came along, the conservation partners asked for an exemption just for ephemeral streams. But here, we didn't want to ask for an exemption here in New Mexico. We thought it would be a better approach to just say all stream restoration should just get a streamlined general permit instead of an exemption. Does that make sense?
It does. I'm curious, though, why you didn't want to ask for the exemption.
Generally because there weren't any exemptions in the legislation. There was just some clear ones that were adopted from the federal rules, is my understanding. So we didn't want to ask for an exemption.
Thank you. So just a couple others. The red line document that was submitted as part of the testimony document, those are your suggested changes, correct? So under 20.6.2.2308, paragraph C, there is an addition of this language. So I can read the whole paragraph C if that is helpful. It says, an administratively complete package shall include a complete application and any required supplemental application material as specified by the department on the department's website. Each application shall include the information required by subsection B, and then it goes through all the subsections, and as applicable to the type of application, payment of the fee shall be specified in that section. And then it appears that you included applications shall also include use of the environmental review tool and submission of a summary project report from that tool. Can you explain that? Oh, okay, I'll hold it then.
Yes.
Yep, let me just note that.
Yeah.
Okay. And then my last question is just probably Mr. Roper, but it might get into the technical side, so I will leave it open for either one of you. You in your rebuttal testimony, you disputed the assertion that the regulations create regulatory burden that in RP was suggesting. Is that under the context that your amendments are used in the rule, or is that more generalized?
Commissioner, I can speak to that. I believe it was my rebuttal where that was mentioned. Again, I would point to that comment being made in the context of voluntary restoration permit, and it, because we were referenced in that testimony or in that rebuttal, I felt like our opinion, that somehow it was being alleged that what we were asking for implied more than we think it implies, right? So we were not saying that because we think voluntary restoration projects should have a permitting process, that it was implied, see, this whole thing is a burden. That's not what we think. We have a lot of experience working under existing permitting frameworks. We will continue to do our best to do this work under whatever permitting framework the Environment Department sets up. But given the importance of this work and the state of our watersheds and the state of our streams and just how many incised stream channels we have, and knowing we can restore them to a better condition, that is why we'd like to see this work streamlined, right? It's important. We know how to do it. We have decades of experience with things like methodology and best management practices. Yes, I think as a restoration community, we are still learning what works. What's the best bang for your buck? Is it better to spend $100,000 in this way or $20,000 in this way 5 times? We'll continue to learn and get better at that work, and that's what we have to do. But our challenges as a state around natural resources, wildfire and flooding and biodiversity, they're big, they're immense. And this is really the only tool we have, or one of the prominent tools to counter those impacts. And in my opinion, that is what makes it worthwhile of a streamlined permitting process.
So if the proposed amendments, I'm not phrasing that correctly. Hang on a second. If the first proposed changes to the rules, which we're working off of, were to move forward without your suggested changes, would that create regulatory burden when you are trying to do those restoration projects?
I'll speak to that, and then you can please add. If I understand the question correctly, I think if the 2 remaining things we asked for are not adopted, and let's maybe put aside the 6-month part and just focus on that discretion and flexibility for that streamlined permit. If that is not adopted, I think what we'll find is the department will not be able to treat voluntary restoration differently, or at least not to the extent that we are asking them to. But I'd like Ms. Corday to have an opportunity to speak more to that.
Please. Yes, this goes to that slide I had up that showed, instead of what we had recommended, language that allowed the department to have flexibility, instead they chose to mirror exactly what all other general permit criteria will be. And so as I had pointed out, that would be the same for a construction general permit as voluntary restoration. And so we were just concerned that they were not going to actually have the discretion to be able to adopt a more streamlined version. In particular, the PNC, the pre-construction notification, is a big thing. And it didn't appear that they were giving themselves the flexibility that they need to say that for voluntary stream restoration that meet these tight 4 criteria, you don't have to get a PCN. So then my last question is, if the Exhibit 79 better addresses the, sorry, my brain just stopped again, voluntary restoration project needs than the previous one? And the answer would be yes. Thank you. I appreciate it.
Commissioner Langer? Mr. Chair? Commissioner Barunda on the platform, do you have questions of this panel? Commissioner Barunda, I think you can unmute yourself. You may have stepped away. Is Commissioner Bayless on the platform? No, okay. All right. Anything further before we excuse this panel? No? All right. Thank you both very much.
Thank you.
Thank you. We'll call our second panel of 3 witnesses. Hayes.
It's under the ball. Oh, there it is. Nice. We're gonna start with
All righty.
1 moment. Not table. Under the table. Those are microphones. Oops, something just came out.
We're just looking for a power core.
Yes,
Thank
please.
you.
Thank you, Kim.
Yeah, those are all microphones plugged in.
Might be distracted, but we can get started while we get the text for it.
No, we can't. Kim, the court reporter has.
It's the most difficult.
Is that in? It's in. Oh, we got it. Thank you so much. Oops. Watch this.
Oh.
It's a stretch, but we got it.
All righty. Mr. Hayes, if you would spell your first and last name and make sure that that's green.
Jonathan Hayes.
Spell it.
JONATHANHAYES.
Thank you. And do you swear or affirm to tell the truth?
Yes.
Thank you. Go ahead, Ms. Udo.
Good morning, Mr. Hayes. Could you please describe your current?
Sure. I'm the executive director for the National Audubon Society over the Southwest region. So I oversee our Arizona and New Mexico program. That's about 25 plus staff, 2 nature centers, and a research ranch in Arizona.
And what is your educational background?
I have a bachelor's in science from University of Colorado in environmental population and organismic biology, and a master's of science in natural resource conservation from the University of Montana.
And we're going to keep it slow.
Yes, ma'am.
Is an accurate copy of your resume attached as SWAG Exhibit 2?
Yes.
Please describe your work and experience as it relates to the proposed rules for New Mexico's permitting program for surface water discharges.
Sure. I have 20 years of conservation experience at multiple levels in private and public service. Over the last 9 years, I've been serving as the executive director for the National Audubon Society's Southwest Regional Office. Prior to Audubon, I served as the U.S. Fish and Wildlife Service Science Coordinator for the Great Plains Landscape Conservation Cooperative, or LCC, where I was responsible for guiding multi-organizational development and implementation of applied research projects. In that capacity, I coordinated landscape-level cooperative projects in the 6-state region among federal agencies, state wildlife agencies, and nonprofit organizations, focused on improving conservation effectiveness in western grazeland and riparian ecosystems. Additionally, I served with the Texas Parks and Wildlife Department, and the Oaks and Prairies Joint Venture, working at a programmatic level to implement regional conservation efforts aimed at restoring declining grassland bird populations.
Did you provide both direct and rebuttal testimony on behalf of SWAG?
Yes.
Is that written testimony included as SWAG Exhibits 3 and 12, respectively, accurate to the best of your knowledge?
Yes.
And do you adopt it today?
Yes.
Would you please provide an overview of the opinions you provide in your summary?
Sure. So my testimony supports the Sportsman and Wildlife Advocacy Group's proposed amendments to the draft changes to 20.6.2 NMAC, addressing protections for New Mexico's most sensitive wildlife that relies on aquatic and riparian habitat. For the first part of my presentation, I will review the highlights and explain the basis of our proposed red lines to the rule that I addressed in my direct testimony. The 2 main points I'll cover are: 1, SWAG recommends consideration of species of greatest conservation need, or SGCN, and their habitats as our most vulnerable and at-risk species. 2, Department of Wildlife involvement in permit decisions. I'd also like to add that we really appreciate NMED incorporating some of our concepts in their rebuttal and in Exhibit 79. SWAG is generally supportive of the proposed rule, and as covered later in my testimony, I have a few recommendations that will ensure the final rule fully implements SB 21's directive to protect aquatic resources.
Can you please describe the importance of the New Mexico State Wildlife Action Plan as it relates to SGCN and the identification of important habitat areas in New Mexico?
Yeah. One thing I want to address before diving in is why we are discussing wildlife in a rulemaking about water quality in the first place. The answer is the statute mandates it via a requirement to avoid, minimize, and mitigate adverse impacts to aquatic resources, which includes riparian habitats and organisms, aka wildlife. Wildlife protection and water quality are inherently linked, and each depends on the other for a healthy ecosystem. Wildlife without clean water would cease to exist.
Similarly, water without wildlife would be detrimental for water quality. Based on my experience, native wildlife species spread vegetation and introduce disturbance through foraging that shapes the riparian and aquatic vegetation and alters hydrology. This is why the federal government, regional Army Corps guidelines, and states with dredge and fill programs all incorporate wildlife considerations into their water quality programs. The proposals I will discuss today do not represent an attempt to create a state Endangered Species Act or a framework to regulate wildlife. Each SWAG proposal was put forward with the intention of protecting wildlife from adverse impacts of dredge and fill activities within the statutory requirements of SB 21. With that in mind, I'm going to give a brief overview of vulnerable wildlife and habitat in New Mexico. So every 10 years, the Department of Wildlife, which is a constituent agency under the Water Quality Act, completes a comprehensive assessment of wildlife and their habitat that includes public meetings and extensive stakeholding. As a member of the working group, I can attest to what a monumental undertaking it is. The resulting State Wildlife Action Plan, or SWAP, is SWAG Exhibit 4. The SWAP is a non-regulatory document intended to inform the public and practitioners about the state of New Mexico's wildlife. This process is a requirement for all states that receive federal state wildlife grants and is intended to conserve our fish and wildlife and prevent more species from becoming threatened or endangered. The SWAP identifies what we call species of greatest conservation need, or SGCN. These are wildlife that deserve heightened attention, often because they are either in decline or we have little to no data on their population levels. But another way, the SWAP identifies New Mexico's vulnerable species, many of which rely on aquatic habitat. I'm highlighting the SWAP and the work of Department of Wildlife today precisely because this document tells us how much New Mexico's wildlife depends on clean water, far beyond just our threatened and endangered species. Of the current 505 SGCN, 208 are associated with aquatic or riparian habitats. Additionally, 148 species are specifically associated with ephemeral waters such as cienagas and springs. At least 80% of New Mexico's animal and plant species are riparian dependent for at least some stages of their life, including 80% of vertebrate species. And riparian areas support a greater diversity of breeding birds than all other habitats in the state combined. Again, the SWAP is incredibly important because it helps us understand which species and which habitats are most in need of conservation actions to prevent further listing. Both NMAC and private industry are repeatedly referenced throughout the SWAP as potential collaborators.
Thank you. Next, can you please describe how the SWAP categorizes habitat and its importance for benefiting SGCN?
In order to implement SB 21, the Environment Department needs the best available information on New Mexico's most sensitive habitats and species, and the SWAP offers a roadmap for both the department and applicants. A SWAP tool I want to highlight today are the maps for critical conservation areas in the state, known as Conservation Opportunity Areas, and Riparian Conservation Opportunity Areas. I'm going to refer to them as COAs and RCOAs. Both COAs and RCOAs are considered to have superior potential for conserving SGCN, our most vulnerable wildlife. COAs and RCOAs illustrate that in today's arid state, some wetlands and habitats are more significant for wildlife than others. Although non-regulatory, these maps are highly relevant for this rulemaking because they comprise areas where permittees should avoid adverse impacts and are also areas where conservation actions could be focused by either permittees in need of mitigation opportunities or by voluntary restoration practitioners. The 30 COAs pictured here on the left were identified through GIS analysis, included the state's critical habitat assessment tool layers, SGCN observations, mapped and modeled habitat, and other key landscape features to identify high biodiversity areas where conservation practitioners should focus efforts to maximize benefits to SGCN. COAs cover around 5.3% of the state, but account for about 50% of the state's SGCN and include all 38 different identified habitat types in the state. Our COAs, which pictured on the right, are based on the New Mexico riparian habitat map that would benefit from conservation and restoration actions to improve habitat quality, connectivity, and ecosystem services to promote healthy, functioning, environments for both humans and wildlife. These maps were developed to guide conservation measures to protect SGCN, prevent future listing of species, and promote species that have already been listed. These maps are available using Department of Wildlife's Environmental Review Tool, which is an online conservation planning tool. The ERT is a partnership between Department of Wildlife, Natural Heritage New Mexico, and NatureServe, and reflects the collective expertise and information management from those three entities. SWAG recommends that applicants consult the ERT in planning and preparing permit applications to evaluate potential impacts to species, including SGCN and federally and state listed species and their habitats.
Can you please describe the importance of fens, playas, cienagas, and springs for wildlife?
Sure. Some habitat types are simply rarer in desert states and are essential for wildlife in their rarity. I want to highlight a few that are deserving of special attention as aquatic resources. It is said that more than half of New Mexico's wetlands have already been lost. Yet any Audubon member could tell you that our birds rely on our riparian habitats for feeding, breeding, or migration. As only about 0.6% of the total land area, New Mexico's wetlands have a huge job in terms of providing hydrological function like water storage, filtration, flood protection, as well as biological functions for wildlife. Because of their importance, SWAG recommends utilizing Department of Wildlife's expertise to understand the impacts of dredge and fill activities on these essential and rare aquatic habitats. Fens, playas, cienagas, and springs are all wetland types that NMAC's Surface Water Quality Bureau has already invested in, demonstrating the need for their conservation and their importance for water quality and general ecosystem function. However, fens, playas, cienagas, and springs are also important habitats identified by Department of Wildlife and the State Wildlife Action Plan. Considering both their hydrological and biological functions, SWAG is advocating for further consideration between the two agencies that are working to conserve these aquatic resources. For example, fens play a role in water quality of headwaters that also benefit native cutthroat trout. The Department of Wildlife has funded work on fens because of their importance as a water source for big game, and works to fence out cattle and elk that damage fens and their role in their ecosystem. Cienagas and springs have also been the subject of attention and funding from both NMED and Department of Wildlife. NMED describes cienagas as an oasis in the desert, providing habitat to 23 threatened, endangered, and sensitive animals. The SWAP specifically describes the toll of losing cienagas, citing the now dried San Simon cienega that formerly provided aquatic habitat for SGCN, including birds, the lowland leopard frog, and the northern New Mexico garter snake. The SWAP addresses the role of springs for water quality and wildlife, noting their vulnerability to land use changes and recommending their restoration and protection. Playas are seasonal wetlands that are particularly important for migratory birds and are the subject of a significant public and private investment by New Mexico state agencies and private industry. I'm a board member of the Playa Lakes joint venture, which plans conservation efforts in support of 185 bird species, 450 plant species, 13 amphibians, and 37 mammal species that rely on playas at some point in their life cycle. The SWAP describes the importance of playas in a variety of ways, but I want to highlight that shrinking playa availability increases the risk of disease transmission as bird density increases, which negatively impacts water quality. As a biologist, I could go on, but I'll end this question by underscoring that SWAG's recommendations to Department of Wildlife involvement in permit decision stem from the need for special consideration of these four habitat types, particularly because of their critical importance for hydrological and biological function, which is supported by both NMED and Department of Wildlife investment in the restoration.
Could you please describe how New Mexico's wildlife is vulnerable to the individual and cumulative impacts of dredge and fill activities?
Sure. There are a number of ways that dredge and fill activities can negatively impact wildlife if not carefully regulated. As outlined in the federal 404B1 guidelines, dredge and fill impacts include directly killing listed species and destroying their habitat, including breeding and nesting areas, escape cover, travel corridors, and preferred food sources for resident and transient wildlife species. By changing the physical and chemical properties of aquatic resources, the introduction of dredged and filled materials can favor undesirable plant and animal species, reduce species diversity, disrupt the normal functions of the ecosystem, and decrease biological productivity. The discharge of dredged and filled materials also adversely impacts aquatic species through the release of toxic contaminants in suspended particulates, which can poison organisms, smother and bury eggs, debilitate and kill sedentary organisms, reduce the food supply, and favor invasive species over native species. As I noted already, migratory birds concentrated and crowded into reduced areas of remnant wetlands are increasingly susceptible to the spread of disease. Additionally, roads fragment habitat, and road construction components such as fish culverts can make or break whether aquatic species are able to meet nutritional and life cycle requirements. Essentially, when pollutants enter waters through discharges, whether intentional or runoff, native and vulnerable species suffer. The prevalence and quality of wetland and other aquatic habitats are directly correlated to wildlife's vulnerability to dredge and fill activities and pollutants. SGCN in general are especially vulnerable due to having restricted ranges and sometimes represented by only a single population, as is the case with some spring snails. In effect, this means that the loss of the lone habitat for a species from dredge and fill could wipe out an entire population, highlighting the importance of SB 21's charge to regulate these activities with regard to aquatic resources that include habitat and organism. In its rebuttal testimony, NMED acknowledged that all SGCN aquatic habitats as proposed by SWAG are encompassed in NMED's definition of aquatic resources. We concur with that opinion and appreciate their clarification.
Why, in your opinion, is it important for the Department of Wildlife to have a role in providing expertise to NMED?
Sure. So first, Department of Wildlife is listed as a constituent agency in the Water Quality Act with a role that includes adverse impacts to wetlands, streams, and other aquatic resources. So in my opinion, Department of Wildlife is indeed the state's expert on wildlife and what measures are required to protect the health of species and their critical habitats. So while NMED currently involves Department of Wildlife in decisions at their directions, it is not required. However, SB 21 does require protection of all aquatic resources, defined as wetlands, streams, lakes, rivers, and other bodies of water, riparian habitats, and the organisms that live in them, and the ecological functions, services, and values they provide. It also charges NMED with the need to avoid adverse impacts to aquatic resources. Therefore, SWAG suggests that in order to accurately assess these impacts, Department of Wildlife needs a formal role in the rule at several key junctures. I want to thank NMED for incorporating a role for Department of Wildlife in their rebuttal filing for both the general and individual permits. So at the federal level, the Army Corps coordinates with Fish and Wildlife Service as well as the state wildlife agencies. And as my colleague Drew Walker will describe in her direct testimony, most states that permit dredge and fill activities outline a clear role for their state wildlife agencies. So it seems clear to me that in order to understand what organisms and habitat are implicated in a proposed project and to thus meet these statutory requirements, coordination with the Department of Wildlife will be necessary. NMED's rebuttal testimony and Exhibit 79 include a role for a state agency with relevant expertise in general permit coverage. Applicants are encouraged to arrange pre-application meetings with a relevant state agency to assess vulnerable wildlife and habitat impacts. These revisions are responsive to SWAG's requests submitted with our direct testimony, and we appreciate and support these additions from the agency. My colleague, Ms. Walker, will address small tweaks to ensure that NMED receives sufficient information about wildlife and habitat during general permit coverage, including by expressly referencing Department of Wildlife. NMED's rebuttal and Exhibit 79 require Department of Wildlife consultation on all individual permits, regardless of where they occur. Department of Wildlife would recommend any requirements needed to address adverse impacts in that case. This rebuttal is responsive to SWAG's proposed red lines about Department of Wildlife consultation on individual permits and was formulated in partnership with NMED and Department of Wildlife. We very much appreciate the amended proposal and agree that the scale of adverse impacts that can be caused by individual permits warrant Department of Wildlife consultation for all projects. This is also a requirement in the state of Colorado, in addition to other consultation requirements by their wildlife agency.
Thank you. Can you please describe why revisions are needed to protect endangered or threatened species and critical habitats in New Mexico?
Sure. So at this point, I want to turn to the third and final point of my direct testimony, the need for additional protections for threatened and endangered species. Of the federally listed endangered and threatened species in New Mexico, 3 are directly dependent on healthy waterways and the habitats they support. Discharge of dredged or fill materials or other actions that would directly or indirectly destroy or adversely modify riparian or aquatic ecosystems and designated critical habitats would likely have an adverse impact on southwestern willow flycatcher, western yellow-billed cuckoo, and the Rio Grande silvery minnow. In their rebuttal, we appreciate that NMAD agreed with our suggestion to add state and federal P&A species as information required to be submitted with individual permit applications.
Thank you. One quick procedural question, Madam Hearing Officer. At this point, that concludes Mr. Hayes' summary of his direct testimony. He has a few brief comments regarding Exhibit 79A and further recommendations that SWAG has to those rules. I'd like to proceed with that now rather than waiting to offer it in a cerebral format.
Thank you.
Okay, thank you. Can you please give an overview of the changes SWAG suggests related to Department Exhibit 79A?
Yeah, slide 12.
We are on slide 12, yes.
So Exhibit 79 incorporated several items from the rebuttal, as well as some new language related to our direct testimony and requests for changes to protect the state's most sensitive species. So we have 2 suggestions in response to Exhibit 79. So we'll go on to the next slide. First, we appreciate the inclusion of different agencies on general permit issuance in Exhibit 79. However, we think it should be mandatory for NMAD to consult with Department of Wildlife in order to ensure that general permits have proper conditions to protect at-risk and vulnerable species. In consideration of agency capacity, we support language allowing Department of Wildlife to waive the right to participate. In our view, this is the third leg of the stool for Department of Wildlife involvement, in addition to an advisory role on general and individual permit coverage.
What changes do you suggest related to Exhibit 79A's reference to at-risk species and habitat?
Yeah, so New Mexico has many sensitive species and habitats, and these are not limited to the species that are listed as threatened and endangered. So I appreciate that NMAD's rebuttal introduced the broader concept of vulnerable or at-risk species throughout its amended petition. And for consistency and to ensure the rules are giving enough consideration to other species, including SGCN, would be our recommendation. We'd recommend including the broad, which we'd recommend including in the broader vulnerable or at-risk category in 2 places. And on this slide, I suggest adding this language to the application for individual permits along with the T&E species. So that should be showing on the slides right now. And then finally, are we on the last slide?
Yes.
Recommended changes to best management practices for scheduling. So with these changes, NMAD would provide consistent consideration of wildlife and aquatic resources throughout the rule.
Thank you. Let's now turn to your rebuttal testimony. Could you please summarize in general terms your opinions regarding the direct testimony filed by other parties?
Sure. So in response to the rebuttal from NRP, we have 4 main points that I will cover. 1, the rarity of isolated playas and wetlands and their significance for wildlife, demonstrating the critical need for their protection in order to align with the Water Quality Act definition of aquatic resources. I'll provide rebuttal to demonstrate that riparian habitat falls within the scope of the state program due to its importance for aquatic resources. I'll also outline the importance of permittees providing information on any impacts to critical habitat in line with both federal policy and Water Quality Act's directive to protect aquatic resources. I then discuss the importance of mitigation in ephemeral waters using playas as an example.
On behalf of NRP, Mr. Lindenlaub testifies that a playa lake is generally an isolated feature and would not have been considered jurisdictional pre-Sackett. And he also opines that the definition of wetlands in the draft rules is overly broad because it would include wetland features that are isolated. What is your response on these points?
Sure. So Mr. Lindenlaub's testimony suggests that playas and other isolated features should not be afforded protection under the permitting program. My colleague, Ms. Walker, addresses overall commentary on the scope of the program. However, Bureau Chief Lemon explains in her direct testimony that limiting protections to waters with a continuous surface connection means, in effect, excluding protection for 96% of New Mexico's waters. For wildlife, losing wetlands at that scale would be catastrophic and clearly conflicts with the statutory language, which intends to protect all aquatic resources. Excluding these features from regulation would have significant adverse impact on wildlife and other ecological functions. As an example, earlier I spoke about the rarity of cienagas, a type of slope wetland, and their importance both hydrologically and biologically. According to NMED's Wetland Action Plan, an estimated 3/4 of cienagas in New Mexico are isolated wetlands. If we were to follow Mr. Lindenlaub's wishes, we would be excluding the vast majority of these ecologically vital features and the organisms that depend on them from protection. Sadly, studies suggest that around half of New Mexico's wetlands have already been lost. For most wildlife species in the state, including 70% of our birds, losing additional wetland habitat will cause further resource shortages and population declines. Wildlife habitat follows the same laws of supply and demand in economics. The more scarce a resource becomes, the more its value rises. In my opinion, isolated waters like playas and wetlands are not diminished in value by their remoteness. On the contrary, it's precisely this isolation that makes them some of the most valuable ecosystems in the state. For animals like riparian-dependent migratory birds, which need to stop for food and water on journeys that are thousands of miles long, isolated wetlands and playas may provide the only sustenance for days. Isolated wetlands are among the most valuable and most at-risk habitat for New Mexico wildlife. Mr. Lindenlaub's position, therefore, would have adverse impacts on wildlife and thus aquatic resources, which runs counter to SB 21 intent.
Let's turn then to riparian areas. Mr. Lindenlaub further testifies that it's appropriate to include a definition of riparian area in the draft rules to distinguish protected surface waters from the adjoining transitional area to uplands. What is your response?
Yeah, so it seems that Mr. Lindenlaub's opinion is that riparian areas fall outside of the permitting program because they are adjoining transitional areas from the protected surface waters to uplands. So I disagree with this opinion because it ignores the clear intent of SB 21 to protect riparian habitat. It fails to recognize the critical importance to wildlife. So in statute, it clearly states riparian habitats as part of aquatic resources, which are defined as wetlands, streams, lakes, rivers, and other bodies of water, riparian habitats, and the organisms that live in them, and the ecological functions, services, and values they provide. The NMAD amended petition clearly defines riparian habitat in line with the statute as, quote, the transitional area located between the edge of stream channel, shoreline, or wetland, and the adjacent upland area, unquote. The intent of this language is clear, so I will simply add here that Department of Wildlife describes riparian areas as the most significant ecosystem for wildlife in the state, due to the fact that at least 80% of New Mexico's vertebrate wildlife use riparian areas at some point in their life cycle, and 50% are reliant on those corridors for their very survival.
Mr. Lindenlaub questions how considering critical habitat aids in filling the gaps in surface water protections post-Sackett. What is your response?
Yeah, the discharge of dredged or filled materials would directly or indirectly destroy or adversely modify riparian or aquatic ecosystems and designated critical habitats, having an adverse impact on these three species that I mentioned earlier: the southwestern willow flycatcher, western yellow-billed cuckoo, and the Rio Grande silvery minnow. So to comply with the statutory directive to protect aquatic resources, it's going to be necessary and appropriate to have the applicant identify the existence of critical habitat that could be impacted by the proposed project. Both the 404B1 guidelines and the nationwide permit general conditions specify prohibitions on discharges that would negatively impact threatened or endangered species or critical habitat. Therefore, it is appropriate and consistent for NMAD to also require permittees to provide this information to the agency.
Finally, Mr. Lindenlaub claims that ephemeral waters provide less function and values than perennial waters. What is your response?
Yeah, the opinion regarding the limited function and value of ephemeral waters is not really supported by science and ignores some of the basic facts about how these systems function. So NMAD's pre-proposal comments on the draft WOTUS definition discuss the particular impact of ephemeral waters in New Mexico, stating individual ephemeral or intermittent streams cannot be scientifically isolated because the cumulative effects of these streams impact the hydrological, biogeochemical, and ecological functioning of a watershed. Ephemeral streams carry sediment and distribute nutrients throughout the watershed. Playas allow for water infiltration that refills aquifers, and our riparian areas provide key ecological functions like providing wildlife habitat and movement corridors. Plants, animals, and entire ecosystems have evolved around the presence of this water, whether permanent or ephemeral. Because of this importance, it is critical, required by SB 21, and in accordance with the draft rules, to mitigate adverse impacts to ephemeral waters from dredge and fill activities when they cannot be avoided.
Thank you, Mr. Hayes, for your testimony. That concludes Mr. Hayes' summaries, and we will then turn to Ms. Walker.
Would you spell your first and last name, please?
My first name is Joro, Joro. Last name Walker, Walker.
Do you swear or affirm to tell the truth?
I do.
Thank you. Go ahead.
Thank you. Good morning, still morning, Ms. Walker. Please describe your current employment.
I am a senior attorney at Western Resource Advocates.
And what is your educational background?
I have a bachelor's of science, a master's, and a law degree from the University of Utah.
Is an accurate copy of your resume attached to SWAG Exhibit 2?
Yes.
Please describe your work and experience as it relates to the proposed rules for New Mexico's permitting program for surface water discharges.
So I've practiced law in the Intermountain West for 33 years, including the last 28 years as an environmental attorney with Western Resource Advocates, a regional conservation organization. At Western Resource Advocates, I focus on clean air, clean water, and wildlife habitat protection. Beginning in 2020, I represented Western Resource Advocates and our partner organizations in rulemakings before the Colorado Energy and Carbon Management Commission and the Colorado Water Quality Control Commission that resulted in regulations protecting water quality, wildlife, aquatic habitats from the individual and cumulative adverse effects of oil and gas development and dredge and fill activities.
Did you provide both direct and written testimony on behalf of SWAG?
I did.
And is that written testimony, which is included as SWAG Exhibits 8 and 16, respectively, accurate to the best of your knowledge?
It is.
And do you adopt that testimony today?
I do.
Thank you. Let's continue then with your presentation.
First, I want to thank you, commissioners. Our organization greatly appreciate this opportunity to present our testimony to you today. Our red lines are based on two factors. First, SB 21 creates a permitting program to safeguard New Mexico's surface waters and the aquatic resources they support. Included among these aquatic resources are wildlife and wildlife habitats. Second, as Mr. Hayes just established, there are wildlife species and habitats across New Mexico that rely on state surface waters to thrive and survive. In large part because surface waters are rare in New Mexico and are critical to wildlife, many of these species and habitats are highly vulnerable to the impacts of dredge and fill activities. Given these realities, we authored red lines to ensure that dredge and fill permitting decisions consider and address adverse impacts to sensitive wildlife and habitats. Our approach is relatively straightforward. We propose a regulatory framework that first provides information on vulnerable wildlife and habitats that might be impacted by dredge and fill projects. And second, that calls on the expertise of the Department of Wildlife to evaluate those impacts and to come up with permit conditions to avoid and minimize those impacts to the maximum extent practicable. In its exhibit 79A, the department responds to our red lines with revised draft rules that adopt this basic approach. The department's draft rules require applicants to provide practical information on sensitive wildlife that is needed to facilitate good permitting decisions. The draft rules also involve the Department of Wildlife in judgments on potential impacts to wildlife from dredge and fill discharges and on the ways to avoid and minimize those impacts. We appreciate and support the department's Exhibit 79A proposals and offer relatively minor but critical changes to 2 of those draft rules. The rest of my testimony focuses on the text and legal justification for specific rules the department proposes in Exhibit 79A. I also point out that the majority of states with dredge and fill programs give their wildlife agencies a significant role in permitting decisions. After that, I discussed the authoritative value of the federal 404B1 guidelines and our red lines that refer to those guidelines. Before turning to the specifics of dredge and fill permitting, I want to underscore that SB 21 designates the Department of Wildlife as a constituent agency. The statute therefore anticipates a role for the agency in New Mexico's surface water permitting program. This sets the stage for the Department of Wildlife to participate in dredge and fill permitting. Now moving on to SB 21 permitting scheme and the appropriate ways for the Department of Wildlife to be involved in it. The department's draft rules rest on 2 types of dredge and fill permits: individual permits and general permits. Individual permits cover single projects that have the potential to have more than minimal adverse impacts, including on wildlife and habitat. Because of this, review of these projects is more rigorous and requires consideration of project alternatives and the selection from among those alternatives of the least damaging one. General permits cover a category of activities that may not have more than minimal individual or cumulative adverse impacts on aquatic resources over the term of the permit, which can be as long as 10 years. Finally, when a proponent wants to proceed under a general permit, it must file a pre-construction notice requesting the department to authorize general permit coverage for its project. SB 21 defines general permit coverage as including any additional permit conditions that a constituent agency might require. As you can see, at each of these junctures, there are standards that apply to avoiding and minimizing adverse impacts to aquatic resources, including sensitive wildlife and habitat. Therefore, good permitting decisions cannot be made without information on vulnerable wildlife and habitats and the appropriate level of input from New Mexico's expert wildlife agency. New Mexico would not be alone in involving its state wildlife agency in sound dredge and fill permitting decisions. Almost all of the 20 states that have permitting programs require that their wildlife agencies play an important role in protecting wildlife and habitats from dredge and fill activities. In some states, such as California and Washington, the wildlife agencies actually make the permitting decisions. In others, like Colorado and Oregon, the permitting agency is required to consult with the relevant wildlife agency to ensure that adverse impacts to wildlife are avoided and minimized. The next 5 slides, together with slide 16, show several of the rules the department has proposed in its Exhibit 79A. Like those in other states, these create an important role for the Department of Wildlife in decisions on dredge and fill permitting. The department's Exhibit 79A proposals properly interject information requirements, specify the need to provide measures that avoid and minimize adverse impacts, and consultation with the Department of Wildlife at each of these permitting decision-making points. I'm not going to go through the specific language of these proposals, as Mr. Hayes has already given a high-level overview of the same provisions. However, the slides are available should there be a desire to delve into them more closely. As I mentioned earlier, at the close of my direct, we plan to ask for the opportunity to offer fairly minor but critical amendments to 2 of the Exhibit 79A rules that address wildlife and consultation. I plan to discuss those 2 rules more fully then. I'm now going to change gears and discuss the 404B1 guidelines. Several of our direct testimony recommendations are based on the long-standing authority of these guidelines. The guidelines were developed by expert federal agencies and have established the framework for all federal dredge and fill permits since 1980. These guidelines should inform New Mexico's final rules because they share the same basic principle as SB 21. Like SB 21, the guidelines place extreme value on surface waters and the aquatic ecosystems they support, and prioritize avoiding adverse impacts to these priceless and sensitive resources. At subpart H, the guidelines specify effective and enduring actions to avoid and minimize the adverse effects of dredge and fill activities on plants and animals. These measures include avoiding unique habitats, including the habitat of federally listed species, timing the discharge to avoid critical time periods like spawning or migration seasons, avoiding changes that would interfere with the movement of animals. Our red lines propose that the subpart H measures, including those to protect plant and animal populations, be incorporated into 2307I5. That subsection requires project proponents to select and implement all practicable and reasonable VMPs, including those listed in subsection 5. Subpart B of the guidelines carries out the goal of SB 21 to maximize all practicable steps to avoid and minimize adverse impacts to water quality and the aquatic environment. In the context of individual permits, the guidelines do this by requiring the consideration of alternatives to the proposed project and the selection of the least environmentally damaging practicable alternative to the project. This approach is completely consistent with SB 21. After all, leaving a less damaging practicable project alternative on the table is failing to avoid and minimize adverse impacts to the maximum extent. We support the department's proposal that the least environmentally damaging practicable alternative to a project be selected as part of the individual permitting process. The guidelines also presume that where a project does not need to be in or near a special aquatic site, alternatives that do not impact that special aquatic site are presumed to be available to the project proponent. In keeping with the guidelines, we also advanced a proposal that would presume that projects that avoid sensitive wildlife habitats are less damaging to the environment. To a certain degree, this approach is reflected in the Exhibit 79A draft rules, which continue to prioritize avoiding adverse impacts to aquatic resources, including vulnerable wildlife and habitats. This directive underscores that it is critical to involve the Department of Wildlife in individual permitting decisions, precisely because all practical efforts must be taken to avoid sensitive wildlife and habitats, and the state's expert agency is the authority on how to do this.
Thank you, Ms. Walker. Before proceeding to rebuttal, would you please describe SWAG's remaining recommendations based on the department's revised draft rules in Exhibit 79A?
Yes, thank you. In addition to adopting the recommendations just discussed, we recommend 2 additions to the department's Exhibit 79E draft rules, advancing the protection of vulnerable wildlife and habitats. The first change, as Mr. Hayes outlined, requires the Secretary to consult with the Department of Wildlife prior to issuing a general permit to include and respond to the input the agencies provide. We depict our proposal here. I want to add to Mr. Hayes' testimony that our red lines are warranted because of the critical importance of getting general permits right. Most dredge and fill activities in New Mexico will proceed under general permits, and the activities they authorize may not have more than minimal individual or cumulative adverse impacts on vulnerable wildlife and habitats over the term of the permit, which could be up to 10 years. Yet adverse impacts from these projects have real potential to add up and cause significant harm, in particular to New Mexico's most vulnerable wildlife and sensitive habitats. Without strong, well-informed measures to avoid and minimize adverse impacts to wildlife and habitats derived in consultation with the Department of Wildlife, there can be no assurance that general permits will meet the standards set for them by SB 21. Further, without the results of the Department of Wildlife consultation in the administrative record, the public will not have a meaningful opportunity to comment on that agency's expert recommendations, and the department will not be able to build an administrative record that adequately supports good decision-making. Our second suggestion amends the department's Exhibit 79A proposal addressing general permit coverage. As I explained already, under SB 21, general permit coverage is defined to include authorization, the discharge under the relevant general permit plus any additional permit conditions required by a constituent agency. This means that SB 21 anticipates that such conditions be considered and, where appropriate, imposed by the Department of Wildlife as a constituent agency. The department's current proposal encourages proponents to meet with resource agencies to assess whether the proponent's project will affect vulnerable wildlife and habitats, and if so, to drive any specific proactive actions, measures, or considerations that are warranted. Given the definition, however, of general permit coverage, it is critical that the Department of Wildlife be given the opportunity to recommend conditions needed to avoid and minimize adverse impacts to sensitive wildlife and habitats. To this end, we suggest clarifying that if applicants do not participate in pre-notification meetings with agencies such as the Department of Wildlife, the department may coordinate directly with the relevant agencies. It is important to remember that where a particular project proceeding under a general permit does have the potential to have more than minimal adverse impacts, SB 21 requires that conditions be included to reduce any impact to below this threshold. If no such measures are available, the applicant must secure an individual permit. Thus, where a project may adversely impact sensitive wildlife or habitats, it's critical to bring the Department of Wildlife on board to recommend ways to avoid and minimize those impacts.
Thank you for summarizing your direct testimony. Let's then turn to your rebuttal.
My rebuttal testimony shows that the red lines proposed by Natural Resources Partnership, or NRP, are inappropriate because they're contrary to SB 21. NRP consistently seeks to narrow the scope of the dredge and fill permit and limit the protections it provides to aquatic resources. But in each case, the plain reading of SB 21 shows that NRP is mistaken. To determine the true scope of SB 21 and the New Mexico surface waters to which it applies, the only appropriate place to look is at the text of the statute. The plain reading of three statutory definitions underscores the broad reach and protections of SB 21. First, SB 21 defines surface water discharge as including the addition of dredge and fill materials into a surface water. The statute then defines water as all water, including water situated wholly or partly within or bordering the state, whether surface or subsurface, public or private, except private waters that do not combine with other surface or subsurface water. The Plain reading of these two definitions means that a discharge into a surface water is a discharge into a public or private surface water situated within or bordering New Mexico, except these truly isolated private waters. In other words, for the purposes of SB 21, surface water is the subset of water as defined by the statute that is on the surface. Aquatic resources, which we have already referenced at length, encompasses the full suite of New Mexico waters and their habitats, organisms, functions, services, and values. At core, a core SB 21 provision, which we have already discussed at length, instructs the Commission to finalize rules that will, to the maximum extent practicable, avoid and minimize adverse impacts to wetlands, streams, and other aquatic resources from the discharges of dredge or fill materials. Using the plain meaning of these definitions shows the true breadth of SB 21 of the SB 21 permitting program. First, the SB 21 permitting program covers the addition of dredge or fill material into surface water situated within or bordering New Mexico, except these certain isolated private waters. Second, SB 21 requires that to the maximum extent practicable, impacts from these dredge and fill activities will avoid and minimize adverse impacts, the full range of New Mexico waters and their habitats, organisms, functions, services, and values. Based on the plain reading of SB 21, then, it is appropriate to use the definition of surface water of the state from already existing Commission rules at 20.6.4.7.S5. This definition lists types of surface waters covered by the permitting program, clarifies that surface waters also include tributaries of these waters and their adjacent wetlands, and at subpart C explains which narrow set of waters, including isolated private waters, are not surface waters of the state. Therefore, this existing regulatory definition faithfully tracks the SB 21 definition of water. I am now going to address a few of the most problematic contentions that NRP makes to restrict the reach of SB 21. I have slides that address each of the NRP assertions I address in my rebuttal in case those would be helpful, but I plan on, much to your relief probably, skipping many of them. NRP first maintains that the scope of SB 21 dredge and fill program is considerably more narrow than the plain reading of the statute indicates by suggesting that the program covers only waters of the United States as defined immediately before the 2023 U.S. Supreme Court Sackett decision. For several reasons, NRP's position has no merit. First, it conflicts with the plain reading of SB 21, which creates a permit program with broad reach and a broad protective mandate that is in no way restricted to some formulation of waters of the United States. Second, NRP cannot point to any SB 21 language to support its theory, and there is no such language. Third, the NRP theory is contrary to the principles of statutory construction in New Mexico that determine the meaning of a statute by looking at its language. Here, as we have already discussed, the text of SB 21 is clear on this point. Fourth, the New Mexico Supreme Court has soundly rejected the notion of looking to, quote, legislative history to determine the meaning of a statute. Thus, NRP's reference to department reports, comments, news stories, press releases have no relevance to determining the meaning of SB 21. Finally, trying to limit New Mexico's dredge and fill program to pre-Sackett waters of the United States would introduce a significant level of confusion. There is simply no consensus on how to define waters of the United States pre-Sackett, and all the candidate definitions are extremely complicated. Further, as the federal government is no longer bound by pre-Sackett definitions, it is certainly no longer the business of the federal government to figure out what the definition of waters of the United States was in early 2023. NRP also contends that in the name of clarity, the commission should adopt a Colorado list of 11 exemptions to the surface waters that are subject to Colorado's dredge and fill permitting program. The Colorado list was explicitly specified in Colorado statute as exemptions to Colorado's definition of surface waters. State waters, sorry, definition of state waters. There are no exemptions analogous to the Colorado list in the federal dredge and fill program. NRP claims without citation to SB 21 that in New Mexico, the same 11 categories of waters should not be considered New Mexico surface waters for the purpose of a New Mexico program, and that dredge and fill activities in these 11 categories of waters should proceed without permits. NRP's proposal conflicts with SB 21, which, is we have discussed already, covers the full breadth of New Mexico's surface waters and protects the full range of New Mexico's aquatic resources. SB 21 already explicitly states the only exemptions from dredge and fill, from the dredge and fill program, which track the exemptions also listed in the federal program. Thus, the plain reading of SB 21 indicates the dredge and fill program covers the full breadth of state surface waters. There's simply nothing in SB 21 to suggest that any state surface water should be exempted from the program, much less those on the Colorado list, that would leave significant percentages of New Mexico's waters open to development without any regulatory oversight. Ms. Giles will testify as to the significance of the Colorado list, explaining that exempting these waters from the dredge and fill program would leave significant state surface waters open to development without a permit, further underscoring the NRP proposal is contrary to SB 21. NRP further asserts that New Mexico's general permits should mimic and be no more stringent than the federal general permits called nationwide permits, or NWPs. Because it conflicts with the plain reading of SB 21, this proposal should also be rejected. First, SB 21 creates a New Mexico specific permitting program that covers New Mexico waters and protects New Mexico aquatic resources. In contrast, the federal program is a nationwide program that is of increasing irrelevance to New Mexico, as the federal program has long covered only a small fraction of the waters in New Mexico and will cover even fewer in the future. Second, SB 21 creates a program that responds to New Mexico's specific considerations and the expertise of New Mexico's agencies. Tying New Mexico's general permits to the federal nationwide permits would thwart this aspect of SB 21. For example, evidence and analysis in the record from state agencies, including the Department of Wildlife, could establish that the NWPs are not adequately protective of New Mexico's aquatic resources. Yet under the NRP proposal, New Mexico's general permits could not reflect this evidence and so would be contrary to the act. Third, SB 21 creates a program that incorporates input and response to New Mexico's public, tribes, pueblos, indigenous nations. This input would have little value if the New Mexico program were artificially constrained by the federal program and the details of New Mexico's general permits were essentially a foregone conclusion. Fourth, for all of these reasons, the NRP proposal would lead to permitting decision that would not be supported by an administrative record based on New Mexico's specific considerations, policies, facts, and analysis. Indeed, the NRP proposal would improperly dictate a particular outcome before agency involvement, public comment, and the creation of an administrative record. And ultimately, NRP would have New Mexico's general permits be based on a federal program that is more and more irrelevant to New Mexico.
Ms. Udall, we need an hour lunch before public comment at 1. Is this a good time?
This is a great time. We have 3 or 4 minutes left with Ms. Walker, and then Ms. Giles' testimony is the shortest of the bunch, so probably another 15 minutes with her.
All right, thank you. Let's come back at 1.
Thank you. Please. Let's come back from the lunch break, please. Let's come back from the lunch break, please. When we broke for lunch, we had begun hearing from the SWAG's second panel. We're breaking into that testimony in order to accept public comment. This is day 4 of the hearing in WQCC 25-74 relating to surface water quality state permitting programs. We are inviting public comment every day at 1 p.m. for up to an hour. I'll first ask if there are people in the room who would like to give public comment, and then I'll go to the platform. Just a few things about public comment. I will ask you to spell your first and last name. I will ask you to swear or affirm to tell the truth as required by the commission rules. I will ask you to offer comment just once and for no more than 3 minutes. If you have more to offer than that, please put it in writing and send it to Pamela Jones over here, the commission administrator, any time before we adjourn the hearing. We expect to be sometime next week. So let me first ask, is there anyone in the room here to offer public comment? Ma'am, to you, sir, you can be next. Either one, just turn it green. If you would spell your first and last name.
Sure, Sarah Knopp, SARAH KNOPP.
And do you swear or affirm to tell the truth?
I do.
Go ahead.
Thank you. Thank you, Mr. Chair and members of the commission. My name is Sarah Knopp, and I'm a policy specialist at Amigos Bravos and a member of and help to lead the New Mexico Mining Watch Coalition. New Mexico Mining Watch is a statewide coalition of nonprofit, public interest, and community organizations dedicated to protecting New Mexico's land, air, and water from impacts of mineral extraction projects. We represent a broad range of native and non-native communities affected by historic and current mining operations. I paid close attention to SB 21 as it worked its way through New Mexico legislature, and I applaud the state for taking on the responsibility to keep all of our waters clean. Given that so many of our waters, as in here in New Mexico and in the rest of the West, such as wetlands, arroyos, and streams and rivers that don't run at all times, have lost their federal protections. Given this, the current rulemaking could not be more timely. We need the state to be a backstop against the urgency to permit extractive projects without proper consideration for environmental degradation and proper time and care in the planning process. In order to be a backstop against the federal climate of deregulation, the rules made here need to be enforceable. We disagree strongly with Natural Resource Partners' proposed changes to the rule that would create excessive exemptions for mining companies by creating de facto exemptions from surface water permitting activities that are governed by the copper rule and have groundwater discharge permits. Surface and groundwater protections are very different. Groundwater permits don't include effluent limits based on surface water standards. Groundwater permits don't have provisions for preventing degradation of surface waters. It's comparing apples to oranges in terms of regulatory oversight. Just because groundwater is protected under a permit does not mean that impacted surface waters are also protected. This is a naked attempt to avoid the need to show that point source discharges or dredge and fill practices would not degrade our surface waters. Profit-motivated companies rushing to drill and mine have an incentive to create the lowest cost possible plan of operations and to rush to production as quickly as possible. This doesn't make companies bad actors to operate by this logic. It's simple bottom line economics. The history of this state shows disastrous effects when industry is allowed to proceed based solely on economics without taking into account the social and environmental impacts of their activities. On dredge and fill permits, for example, we hope that this rule requires applicants to first demonstrate that they're working to avoid damage or destruction to a wetland before minimization and mitigation is considered for both individual and general permits. To accomplish this, the project purpose must be clearly defined and applicants must be required to identify and select the least environmentally damaging practicable alternative before a dredge and fill permit is issued. Further, we support limitations on companies that have previously violated permit conditions and environmental laws from receiving future permits until they have remediated damage. The cumulative impact of production should be considered in each geographic area. For this reason, NMED should hold a 15-day public comment period on all general permit notices of intent and allow the public to petition for general permit coverage decision review. This public participation for general permits ensures that New Mexico residents impacted by a proposal have a voice in the process. I'd like to note, however, that public input is not sufficient to consider environmental justice concerns pertaining to disproportionately impacted communities. Considerations of disproportionate historic impact should be considered as part of regulatory and permitting decisions. Consultation is not enough. Disproportionate contamination of tribal communities, communities of color, and frontline and fence line communities cannot be corrected until cumulative impacts are a criteria for decision making. Thank you very much.
Thank you, Ms. Knope. Sir? If you would spell your first and last name.
Yes, my name is Jesse Dubell, Jesse. Last name Deubel.
You swear or affirm to tell the truth?
I do.
Please go ahead.
Mr. Chair, Commissioners, my name is Jesse Dubell, and I'm the Executive Director of the New Mexico Wildlife Federation. The New Mexico Wildlife Federation is the state's largest and oldest conservation organization, founded in 1914 by famed conservationist Aldo Leopold. The New Mexico Wildlife Federation is comprised primarily of hunters and anglers. And I want to take this opportunity today to urge the Commission to recognize wildlife as aquatic resources as directed by SB 21. I also want to take the opportunity to acknowledge the fantastic work that's currently being done by the Department of Wildlife. Right now, the Department of Wildlife is implementing the statewide wildlife action plan. There are 505 species of greatest conservation need on that action plan. And all of us have a responsibility collectively to ensure that we're keeping those species of greatest conservation need off of the federal endangered species list. To that end, I think it's very, very important that the New Mexico Department of Wildlife has a very effective consultation role to play with the New Mexico Environment Department. Another thing I'd like to mention is that I think earlier Trout Unlimited had commented on the importance of streamlining the opportunity to do water restoration projects, volunteer type projects. Trout Unlimited does a terrific job on that, as do many other nonprofit organizations. And I want to emphasize the importance of those comments, the importance of streamlining those processes. It's just so critical that as we work through the permitting processes, the impacts to wildlife are taken into account. And I think the New Mexico Department of Wildlife is certainly the ideal state agency to provide that level of consultation. Thank you all very much.
Thank you, Mr. Dubell. Anyone else in the room? Sir, like to come up? If you would spell your first and last name.
Thank you very much for this opportunity to speak. I'm Harold Trujillo, one of the founders of the New Mexico Seca Association.
Do you swear or affirm to tell the truth?
Excuse me?
Do you swear or affirm to tell the truth? Swear or affirm to tell the truth?
Okay, I'm from the Mora area.
Oh, that's fine.
Yeah, and I'm one of the co-operators at Murphy Lake Dam. So I'll be speaking about that experience also, as I'm also president of the Seca de la Isla, which is in the Dukes in Mora County. So one of the things that I experienced dealing with a fire is that, of course, fire cost, you know, and the runoff after that cost ash and water to be to go into the acequia. And we were worried that because of that, it would kill the fish, right? Because water and ash creates lime that increases the acidity in the lake and kills fish. So we diverted that water away at the beginning, but then we got reprimanded by the Corps of Engineers for doing that because part of the diversion was also an ephemeral stream or an arroyo, right? So I would like some clarification, hopefully in the rules, to deal with the many fires we're going to have and all the pollutions that are going to come primarily to acequias first and eventually also to the rivers, right? So we need to have a rule that addresses that concern because we were recommended for diverting that water away from the lake. So I hope the rule can address that. You know, also, I do have experience. I worked in state government for over 40 years. I wrote several rules, and I know that it is very important that they be concise, clear, okay, so that any future attorney in any future administration doesn't run wild with misinterpreting the rules, because I have seen that happen when administrations change. Sometimes the new attorneys will interpret the rules slightly different. Okay, so it's another comment and concern I have, and I hope that can be addressed precisely. Thank you very much.
Thank you, Mr. Trujillo. I saw your hand. If you would spell your first and last name.
It's Jacob Clemens, spelled Jacobeclemens.
Do you swear or affirm to tell the truth? Go ahead.
Thank you, Council. This is my 20th season here as a fly fishing guide. And this environment is a little different, so bear with me. But thank you for listening to my 2 cents today. Obviously, clean water is a very important part of my business, as well, it's an important part of my livelihood, as well as the guides that I employ. Let's see. As a professional working in the outdoor industry, protections for clean water are incredibly important. Water is the foundation of our $3.6 billion industry. New Mexico's watersheds are all deeply connected, from small tributaries to ephemeral streams to wetlands. The surface water permitting rule should protect all of our waters, because what affects one affects all. New Mexico's Department of Wildlife should play a meaningful role in the permitting process. The department manages our fisheries, which depend on clean water to thrive. So it makes sense to involve the state agency with the knowledge and responsibility of managing fisheries. Streamlined permits for restoration, final rules need a streamlined process for restoration permits, so the work to restore surface waters can begin without delays. Restoration work benefits the fisheries my business depends on and improves water quality for everyone. That bit is pretty self-interested, but I also want to acknowledge that the waters are all part of a greater ecology that even everyone in this roundhouse is a part of. And let's think about the birds, the bees, the flowers, and the trees, and the fishes. Thank you.
Thank you, Mr. Clemens. If you would spell your first and last name.
Greetings, commissioners. My name is Richard Schrader, S-C-H-R-A-D-E-R. I'm the director of River Source, an organization that provides.
Do you swear or affirm to tell the truth?
Thank you. Yes, I do.
Thank you. And how do you spell your last name?
S-C-H-R-A-D-E-R.
Thank you. Go ahead.
I'm the director of River Source, and it's a group that provides watershed education, planning, and resiliency services for over 30 years in New Mexico. I want to share my experience connecting through community-based approaches to land managers, water conservation work that's connecting schools and youth crews with local watershed groups and agencies doing work on this for over 30 years. My years of observing and teaching about New Mexico watersheds and how they're so intrinsically connected. So I'm hoping the rulemaking is very comprehensive, seeing how ephemeral arroyos are tied to perennial rivers, to our aquifers, to our springs. I say this because I've been able to work in this field long enough to see rivers grow dry. And I heard an NMED colleague say, it sucks when we see rivers go dry. And just want to remind people that every drop counts when we know that 70% of our body's coming from our local water supply, and that our groundwater and aquifers are connected with our surface water so much. 90% of our water in New Mexico for residents is coming from groundwater. So I know that through my travels in this work, that having a strong, comprehensive set of rules that are uniquely New Mexican and integrate the engagement of multiple agencies. I think I agree with the previous comment about incorporating the wildlife department, but perhaps even the advisory roles of the divisions of MNERD, like the forestry department, would be really important for a long-lasting and impactful surface water surveillance and protection program. I'm blessed also to do the work that gets me all over the state doing reading the landscape and developing watershed restoration projects with communities, engaging local spark plugs and doing this in a lot of ways with limited resources to try to improve our watershed health. These restoration projects often involve acequias, local nonprofit groups, entrepreneurs and schools, and just local spark plugs. People are storytellers about protecting the land for generations. And I just want to encourage that these rules support voluntary restoration work actively. And it's essential for scaling up this restoration work that needs to be happening as much as possible without delay. I really appreciate the opportunity to share and sincerely hope that you consider my recommendations. Thank you very much for doing the important work you're doing. This is crucial work for our state, and I hope you adopt strong, comprehensive surface water protection rules.
Thank you, Mr. Chair. Other hands? If you would please spell your first and last name.
Good afternoon. My name is Yolanda Jaramillo, YOLANDA JARAMILLO.
Do you swear or affirm to tell the truth?
Yes, I do.
Thank you. Go ahead.
Thank you for being here and for allowing us to come and participate and be a part of your decision making. I am a voice for clean water. I'm from Dixon. I'm a commissioner on our Acequia de la Plaza, as well as sit on the New Mexico Acequia Commission and the New Mexico Acequia Association. Recently, on the June 2nd election, I was voted as the House District 41 Democratic candidate. So I hope to join you soon and be part of your team in protection of our water. I call it sacred water. We should not ever allow it to be tainted. We speak on behalf of animals, of the birds, the bees, the trees, the beavers out there. I've seen animals on our river, pass away, die because of the shortage of water. And who knows what else is in it. We're right below the Sipapuski Lodge, which is a concern for us below that area. And I would encourage you to be sure that the rules uphold acequia and agriculture exemptions. Please keep our water clean. It's going to affect all of us. Imagine going through a day without drinking water. That could give us a headache, right? Because we're dehydrated. Now imagine drinking contaminated water, polluted water, because we're so thirsty. And then we end up with not only a headache, a stomach ache, and who knows what other long-term health conditions. We are not in a position. We've learned from the past. Please, let's not repeat. are passed. Thank you.
Thank you, Ms. Hardaway. I see a hand there. If you would spell your first and last name.
Sure. Good afternoon. My name is Laurie Uyaki. That's LaurieWeahkee.
Do you swear or affirm to tell the truth?
Yes.
Please go ahead.
Thank you. So good afternoon, Chair and members of the Commission. As I said, my name is Laurie Uyaki. I'm Diné Cochiti and Zuni Pueblo, and I currently live in Albuquerque. And today I'm here as an individual, not representing any of my tribal affiliations or organizational affiliation. But I'm here today because I'm deeply concerned about the erosion of the Clean Water Act, protections that impact New Mexico's water, wetlands, ephemeral, and intermittent streams. As you know, post-Sackett, New Mexico has a significant amount of unprotected waterways, which is why I'm in strong support of the New Mexico Surface Water Permitting Program. Ensuring water quality in our arid state is a top priority. So a few things is, first, I'm very pleased to see the broad protections for tribal water quality standards outlined in Senate Bill 21. However, I'm concerned that some parties have requested that tribes use the EPA treatment as a state TAS designation as the means for tribal engagement in this process. Acquiring the TAS designation requires a significant amount of time and capacity that many tribes do not have. Attaining the TAS designation is a big lift for tribes in the best of times, but we are not at the best of times, as EPA itself is dealing with budgetary and staffing cuts. So this will impact and burden tribes who are trying to effectuate the TAS designation. It will make it an even bigger lift. And this could mean that only tribes that already have the treatment as a state standard will benefit from the broad protections outlined in Senate Bill 21, which is not the intent, neither does it align with the plain language written into that statute. Two is I urge the Commission to adopt the tribal water quality standards, the definition of the tribal water quality standards proposed by the Pueblos of Jemez and Pueblo of Laguna. Their proposed definition provides clarity to the Environmental Department and the permittees, and it also aligns with the language in Senate Bill 21. And the third thing is that it would be important to make sure that all appropriate state agencies are included in the permitting process. I also just want to remind everyone that the New Mexico State Tribal Collaboration Act should serve as a useful guide and tool in how to work with tribes. Input from New Mexico's tribes, pueblos, and nations can be extremely useful in protecting our water quality here in the state. And so just in closing, just to say that, we must, water connects us all, and we must protect our surface waters, including the rivers, streams, wetlands, and the smaller tributaries that feed them. We need to protect the ephemeral and the intermittent streams and the aquifers, which are an important part of our landscape. Water is precious, and it sustains our communities and is the bedrock of our livelihood. For tribal communities, water is a blessing, as demonstrated in our culture, our ceremonies, and our way of life. And it feeds and nourishes us, and we owe our lives and our existence to water. I do thank you for your time and appreciate your consideration of our concerns, of my concerns.
Thank you, Ms. Weahkee. Yes, sir. If you would please spell your first name.
Yes, members of the commission, my name is Alfredo Montoya, ALFRENIO MONTOYA.
Do you swear or affirm to tell the truth?
Yes, I
Go ahead.
thank you for the opportunity to say a few words about the importance of having clean water and to express our gratitude to our legislators for having the foresight to pick up the ball for our federal leaders who dropped it. Senate Bill 21 is critically important at this time, but it can only be as effective as strong regulations are in place, at least as protective as the last protections that we've lost. I represent Las Nuevas Acequias in El Rio Grande. It's 9 acequias north of Española and south of Taos and the Rio Grande rivers. The majority of the rural villages that our acequias serve do not have community water systems. Most families have very shallow wells, private wells, 30 to 60 feet deep. Our acequias serve to recharge the aquifer where they draw their water from. It's critically important that the water that recharges these wells, that it be safe to drink. In addition, many families, including my own, raise livestock for a living or to supplement their income. These livestock all drink water that comes from our acequias as well and from our river. When we're irrigating our orchards and our pastures, our grandkids play in the water. Our pets play in the water as well. Clean water is important for all of us and for all of these reasons. And I want to commend you all on your work. I hope that you will come up with some very strong regulations. Thank you.
Thank you, Mr. Montoya. Others who'd like to offer public comment at this time in the room, we will have another session tomorrow afternoon at 1. No? I'll go to the platform. Pam or Louise? Stephen Schmidt, can you unmute yourself?
Yes, hello.
Hello. Would you spell your first and last name, please?
STEPHENSCHMIDT.
Do you swear or affirm to tell the truth?
Yes.
Go ahead.
I'm very concerned about our surface waters because, for one thing, surface waters can contaminate aquifers. I am dealing with that right now, whereas I have a well that's contaminated with PFAS chemicals that started out on the surface. And that's just my own personal account that I'm dealing with, and I've spent a lot of money trying to remediate. And this can happen with all kinds of chemicals around the country, and not just here in New Mexico, but New Mexico is our focus, and there's a lot of mining here. There's a lot of produced water that's comes from the oil and gas industry, and this is all of a big concern of mine for the rest of the public. I'm very much in favor of the strongest controls on pollution from surface, and I'm very much in favor of this proposed SB 21 controls. And that's pretty much all I need to say. Thank you.
Thank you, Mr. Schmidt. Who's next?
Next would be Cliff Villa. Cliff Villa, if you could unmute yourself, please.
Okay, can you hear me?
Yes, hello. Would you spell your first and last name, please?
Great. My name is Cliff Villa, CLIFF VILLA.
Do you swear or affirm to tell the truth?
I do.
Thank you. Please go ahead.
Good afternoon, and thank you, Madam Chair, members of the New Mexico Water Quality Control Commission, for providing this opportunity for public comment on proposed rules for implementing SB 21. I am Cliff Villa, tenured faculty at the UNM School of Law, where I teach and write in the area of environmental law. I have also practiced in this area for more than 30 years, and in fact, recently retired from the U.S. Environmental Protection Agency. I offer my comments today in my personal capacity as a native New Mexican with roots here that reach back more than 300 years to the Atrisco land grant of 1692. I suspect that life in the Southwest has always been hard, but people here learned how to steward the resources they had. They cared for the land and the water that gives us life. Justice Scalia, in his 2006 Supreme Court opinion in Rapanos, dismissed our life-giving waters, such as the Rio Puerco, the Jemez River, and the Santa Fe River, as, quote, ripples of sand in the desert, close quote. Justice Scalia was profoundly wrong, but his error carried forward to the majority decision in Sackett 2023, a decision that eliminated federal protections for most of our waters here in New Mexico, and to which New Mexicans responded proudly last year through passage of SB 21. But now is the time for us to finish the job to ensure the most protective rules for all waters of our state. We must protect all our lakes, ponds, rivers, tributaries, wetlands, and the wildlife and people who depend on them. We must ensure full protections for our water, our acequia communities, our tribal communities, and our urban and rural communities. For 10 generations, my family here has learned to live with the resources we've had. With climate change, that may become more challenging. In my lifetime, the cove at Navajo Lake, where I learned to swim, is now nowhere near the shoreline. In fact, the rocks where my kids used to dive have now been left high and dry. Some things aren't coming back, but I believe our people, our communities will survive if we adapt, if we protect everything we've got. We will need the strongest rules for that. And I thank the Commission for your consideration and support. And one more note, because we just heard about the concerns about actual contamination in water. My father was born in Clovis, New Mexico, where we now know there's a significant contamination with PFAS. My father died of a brain cancer at the age of 44. And there's a real concern that my father might have been killed by PFAS. Water pollution kills. And we need to be very, very concerned about protecting our water quality in the state. Thank you for your concern, and thank you for addressing this very important decision.
Thank you, Professor.
Thank you. Eric Jans, if you could please unmute yourself. Eric Jans.
Mr. Jans?
Thank you, Madam Hearing Officer.
Would you spell your first and last name?
Yes, ERICJANTZ.
Do you swear or affirm to tell the truth?
I do.
Thank you. Go ahead.
Thank you, Madam Hearing Officer. Mr. Chair and members of the Commission, my name is Eric Jantz, and I'm the Legal Director for the New Mexico Environmental Law Center. The Law Center supported SB 21, and we're pleased that the legislature took that important step to protect New Mexico's waters when federal regulators are stepping away from their responsibilities to do so. But in order to protect New Mexico's waters, we need regulations that actually provide protection. The guiding principles of the regulations before the Commission should be 1, protecting all of New Mexico's waters, 2, maximizing water quality protection, and 3, maximizing public participation in permitting processes. With respect to the first point, the Law Center strongly disagrees with New Mexico Resource Partners' proposed changes to the rule that would create exemptions from surface water permitting for activities that are governed by the Copper Rule and have groundwater discharge permits. Surface and groundwater protections are very, very different. Groundwater permits do not include effluent limits based on surface water standards. Groundwater permits also don't have provisions for preventing degradation to surface waters. Groundwater permits have nothing to do with dredging and filling wetlands or other surface waters. I reviewed the Natural Resources Partners' proposed exemptions from dredge and fill regulations, and I honestly can't think of any legitimate scenario where a groundwater discharge permit under the Copper Rule or really any other regulation would serve the purposes of a dredge and fill permit. As to the second point, the Law Center urges the Commission to adopt regulations that are at least as protective as the most protective version of federal regulations. And finally, to the third point, we urge the Commission to seriously consider integrating New Mexico Supreme Court's reasoning in Colonias Development Council v. Rhino Environmental Services decision into its regulations. Any regulatory framework resulting from this proceeding should provide frontline and fenceline communities the opportunity to provide their lived experience as evidence in a permit proceeding and require NMED to consider and address that evidence in its permitting decisions. Thank you, Mr. Chair and members of the Commission.
Thank you, Mr. Downs.
Thank you. Next, we'll call on Beta Sosi. Beta Sosi, if you could unmute, please.
Yeah, Ms. Sosi?
Hello, can you hear me?
Yes. Would you spell your first and last name, please?
My first name is Beata. My last name is Tsosie.
Thank you. Do you swear or affirm to tell the truth?
Yes.
Thank you. Go ahead.
Okay, thank you. Good afternoon, Chair and members of the Commission. My name is Beata Sosi. Thank you for this opportunity to provide comments today. I'm the organizational director for Breath of My Heart Birthplace, Navi Pinghaumu, and I am a member of Santa Clara Pueblo. As a traditional birth worker, I want to emphasize how multiple generations are held in one pregnancy and how we all come into this world with water as our first environment. Water is a sacred being and element that holds life, memory, and creation for humanity and this planet. If we do not respect water, we do not carry our existence forward for future generations to be born and thrive. I ask that you center pregnant families in this decision, knowing we are conceived as water beings and that what we do to our waters, we do to ourselves. I also ask that you adopt strong rules that will protect New Mexico's precious surface waters. The decisions you make in adopting these rules will define whether the strong framework put in place in SB 21 is realized or whether we leave our waters open to further environmental violence, degradation, and harm that is being perpetrated on an overwhelming scale at this moment. I also ask that you ensure all surface waters are protected in the state. This includes intermittent ephemeral waterways that don't flow year-round, as well as wetlands, playas, our natural springs, and other important waters. All these waters are critical for tribal watersheds and land-based agricultural peoples of this place and throughout New Mexico. Recognizing our symbiotic relations with our ecologies, I ask that you require permittees to avoid negative impacts to all waters first and demonstrate that they have chosen the least environmentally damaging option before the Environment Department may issue a permit. We must carry forward a culture of protection instead of permitting allowable harm to occur. Finally, I strongly urge the Commission to ensure tribal water quality protections incorporated into SB 21 are appropriately reflected in the 20.6.2 and 20.6.5 rules. The definition of tribal water quality standards, as included in the Environment Department's Exhibit 79A and 79B, sufficiently does this, and I ask that the Commission adopt this definition. Thank you for centering those most impacted and our precious living waters, our birth waters, and for creating stringent rules and regulations to protect our unique New Mexico ecologies, communities, cultural lifeways, and waters that we need for all life in our beloved state. Our communities need these strong rules for survival. Kuntawaha. Thank you.
Thank you, Ms. Sosi.
Thank you. Next, we'll call on Jana Pfeiffer. Jana Pfeiffer, if you could please unmute yourself.
Hello. Would you spell your first and last name, please?
Hello, my name is Jana Pfeiffer, Jana. Last name is Pfeiffer.
Do you swear or affirm to tell the truth?
I do affirm.
Please go ahead.
Good afternoon, honorable commissioners. My name is Jana Pfeiffer and I live here in Albuquerque, New Mexico. I want to first just introduce myself. I am currently a farmer. This is my second year farming here at the Rio Grande Community Farm. I am also a former commissioner for the Environmental Planning Commission for District 1. I used to live on the west side for 2 years. I'm no longer there, but have extensive experience in that position as a commissioner. But I'm most importantly here because I want to be the voice for clean water, because protecting sacred sites and water is an essential part of my role and responsibility as a Navajo woman. I also live along the acequias and have the privilege to walk amongst them every morning and every evening as part of my routines. My connection to this water goes beyond just as a farmer and as a city resident when it comes to our agriculture. but there have been moments in my life where I have become sick. And those moments in my life where I've had to go home to receive ceremony and help and come back and was told to walk along the Rio Grande River to offer my songs, to offer my prayers for my continued healing and my journey. And many of the times when I go back home with my own husband, in many of our ceremonies, I am asked to bring in the morning water for healing for many of our other relatives. So my deep relationship with water is important in my life and my roles and my responsibilities. The river is not just resource to be managed, it is a vital source of spiritual renewal, is what I've come to look at it. Our water is finite and is very limited today. Every day I wake up, I see news articles of watersheds that are becoming limited, cities that are migrating here to Albuquerque, amongst some farmers that I've come to know that moved here from Phoenix. I want to urge the Commission to adopt a strong, clear, and comprehensive surface water protection rules to fully implement Senate Bill 21. Listening to the testimony of my fellow New Mexican relatives here within this testimony session, there's definitely a clear consensus that has emerged across what we are hearing amongst our testimonies, our tribal communities, and our conservation communities. To truly protect our waters, the final rules must include protection for all interconnected waters. All of our watersheds do not exist in isolation. We must protect the full breadth of New Mexico's surface water, including ephemeral streams, arroyos, and small tributaries, because they don't directly feed into our major rivers and groundwaters. Second is just to make sure that we have meaningful tribal interagency consultation. I think it's important for us to integrate the New Mexico Department of Wildlife into permitting this process as well. Protecting our aquatic resources require their scientific resources, sometimes beyond even myself of what we know, really to prevent long-term damage to our ecosystems as well. And then third is to support our local watershed work. We must differentiate between polluters and those doing vital land conservation. The final rules need to be streamlined and less burdensome, permitting the process for volunteers and community-based watersheds restoration projects, so that this vital work can proceed without any delay. And lastly, just to make sure that we have strong tribal and acequia protections as well. I urge the Commission to uphold historical acequia exemptions to protect tribal waters by adopting the tribal water quality standards proposed by the Pueblos of Jemez and Laguna. And we must ensure tribal waters are protected without placing the massive bureaucratic burden of acquiring EPA treatment as states designations on them as well. Thank you so much for your time and consideration today and the vital work you are doing every day for many of our relatives here in New Mexico.
Thank you, Ms. Pfeiffer.
Thank you. Next, we'll call on Rex Myers. Rex Myers, if you could please unmute yourself.
On Rex.
There you go.
Hey, Allo, would you spell your first and last name, please?
My name is Rex Myers, Rexmyers.
Do you swear or affirm to tell the truth?
I do.
Thank you. Go ahead.
Thank the Commission for providing this opportunity. I am from Socorro. I am a member of the Friends of Bosque del Apache Board and speak on that behalf and also on my own behalf. I encourage you to fully implement Senate Bill 21. I hike over 200 to 300 miles a year in this state. I've been in every state river drainage from the Boot Hill to Clayton, from the Permian Basin to Shiprock. New Mexico needs comprehensive, strong, and enforceable rules to protect our limited water, and to protect the habitat that water creates. Birds, animals, and people need quality habitat. Bosque del Apache needs quality habitat. I urge you to fully implement Senate Bill 21 and the habitat that it protects. Thank you very much.
Thank you very much, Mr. Myers.
Thank you, Madam Hearing Officer. That concludes the hand raised on the platform.
All right, thank you.
You're welcome.
If we have come to the end of public comment, to offer to, oh, are you raising your hand? Yes, please come up to the desk.
I wasn't going to say anything, but
it's fine to change your mind.
No,
Would you spell your first and last name?
Mary, M-A-R-Y, Trujillo, T-R-U-J-I-L-L-O, Mascarenas, M-A-S-C-A-R-E-N-A-S.
Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you. Go ahead.
I come from Taos County. I come from Llano de San Juan de Pomuceno, a beautiful little village with four acequias that come out of the Rio Santa Barbara, which is Acequia Madre, Acequia de la Plaza, Acequia del Monte, and Acequia de las Joyas. And we're proud to bring this forward because our ancestors lived there. My grandparents, great-grandparents, and great-grandparents, and I don't know who else, but they've all left us something to be proud of, to care for, and that's our waters. And we need to ask you that you protect our waters, keep them clean, not only for the sake of all the wild animals that are around, but for the people that live there. There's many people that still use the river for many beneficial things, and they water their plants. We raise hay for the animals, and we want to be eating healthy food, drinking clean water. So I urge the Commission to adopt strong and comprehensive, clear and enforceable rules that fully implements SB 21 to fully protect New Mexico waters from existing and future pollution. There's a lot of companies that don't care but anything but for money, and they say they'll give us jobs. Yes, jobs that will bring some kinds of disease like cancer and other things with them. So we want to live a healthy life, and we're asking you to help us do that. Thank you.
Thank you, Ms. Mascarenas. Anything else before we return to the technical case?
I had one more hand raised on the platform, Madam Hearing Officer.
Alrighty.
Keegan Rose, if you could unmute yourself, please.
Hello.
Hello. Would you spell your first and last name, please?
Yes. First name is Keegan, K-E-E-G-A-N. Last name is Rose, R-O-S-E, like the flower.
And do you swear or affirm to tell the truth?
Yes.
Please go ahead.
Thank you. Yeah, hey, good afternoon. Keegan Rose, Yanisha, Tabahan Nisha, Touch Ini Bashichin, Kisani Dasuche, Kinyani Dashanilla. Before we had government names, my people greeted each other with our clans, because that was who they were and who we still are. In this way, Tabaha, Water's Edge, is my mother's clan and her mother's clan and their mother's clans as well. Carrying forward those who have come before me and those who will come after me, I stand here as a constant of my people, a continuation shaped by those who protected our ancestors' sacred understanding. I stand here as a future ancestor sharing that responsibility with you all today. Water has connected our people for generations through its sacredness, its memory, and its necessity. I speak to all who are here, not because I want you to listen, but because you must listen. When our sacred water is gone, so will we. As Diné, as an Indigenous person, I say this. Even if you do not identify as Indigenous, we all still come from Indigenous people. The ceremony and intention that our ancestors practiced allowed all of us to be here. By respecting our water, we honor our lineage. Remember, we are also water, and to respect it is to respect ourselves. The resiliency our ancestors engraved with us is only fulfilled when our water is left in peace. Even in that peace, the responsibility remains, and it belongs to all of us now. And so I leave you with this. The responsibility our ancestors carried is now ours to hold. What we choose to protect, we choose to become. I say with a solemn sternness, I'll go in it. Thank you. Okay.
Thank you, Mr. Rose. All right, if we've come to the end of public comment, I will return to the technical case. We have the second SWAG panel back, please.
Oh,
So we can get the slide.
Alrighty. When we broke for lunch, I believe Ms. Walker was finishing up her rebuttal. That's true.
We had just wrapped rebuttal with Ms. Walker, and she has a little bit of additional testimony regarding proposed changes to Exhibit 79A.
Thank you.
Thank you. So we propose important changes to the proposal in the department's Exhibit 79A, and I will address one of these. And this is the new proposed definition of surface waters. So in Exhibit 79A, the department proposes a definition of surface waters. A definition of surface waters. The department still properly incorporates the rule the commission adopted defining surface waters of the state at 20.6.4.7.S5. But then at section A exempts for the purposes of its surface water permitting regulations, waters of the United States. For several reasons, we recommend deleting subsection A. First, subsection A conflicts with the definition from SB 21 of waters and surface water discharge, which do not exempt waters of the United States. Second, the legislature has already determined the proper mechanism for exempting projects that have a federal 404 or 402 permit from the state permitting process. For example, SB 21 specifies that the commission rules shall not require a permit for discharges of dredged or fill materials for which a permit or authorization is issued under section 404 of the Clean Water Act, and there's a similar provision for 402. This approach, mandated by SB 21, is already reflected in the draft rules. The department draft rule, sorry about this, 26 to 2303A4 and B6 to create another mechanism for exempting projects for New Mexico's surface water permitting program is inconsistent with SB 21. Third, the proposal could leave New Mexico's surface waters unprotected and vulnerable to unpermitted development. The scheme created by the legislature is fairly simple. If a proposed discharge into a state surface water is into a state surface water and the discharge does not have a 404 or 402 permit, it must secure a state permit. Interjecting the ever fluctuating, ever litigated definition of waters of the United States into a New Mexico program would add significant complexity, uncertainty, contention, and could be resource intensive. The following scenario exemplifies this. The department discovers that a developer is discharging without a permit into what is arguably a water of the United States. Significant damage is being done to water quality and aquatic resources. Under the Exhibit 79A rule, before the department could respond to the illegal discharge, it would presumably have to establish that the water was not a water of the United States. Under the same scenario, assume the U.S. Army Corps is alerted to the illegal discharge but does not act or delays action while it tries to determine if the discharge is into a water of the United States. Presumably, the department could not act, at least under the Surface Water Permit Program, until it establishes the water is not a water of the United States. Further complicating matters, the department's determination could conflict with any determination the U.S. Army Corps may make simply because the definitions of water of the United States, the definition of waters of the United States is so swirling. Yet in both instances, under the old rule, the department has immediate recourse. If the project proponent does not have a federal permit, the discharge falls under the scope of the New Mexico's Surface Water Discharge Permitting Program. Thank you very much for your patience. That concludes my testimony.
Thank you, Ms. Walker. Now move to our last witness, Mr. Giles.
Would you spell your first and last name, please?
Ashley Giles. It's ASHLEYGILES.
You swear or affirm to tell the truth?
I do.
Thank you. Go ahead.
Ms. Giles, would you please explain your professional and educational qualifications?
I have actually the same bachelor's as Mr. Hayes, EPO biology from CU Boulder. I also have an environmental studies degree from CU Boulder and a master's in ecological restoration from the Warner College of Natural Resources at Colorado State University. My focus is on the restoration of freshwater ecosystems such as rivers, streams, wetlands. I'm an environmental consultant supporting governments and NGOs and private clients, and I'm familiar with the 404 regulatory permitting scheme. I was also a technical advisor for conservation organizations, including Trout Unlimited, Colorado Trout Unlimited, through Colorado's Regulation 87 rulemaking. I am also currently providing some expertise to similar organizations in Washington State for their dredge and fill rulemaking. And I'd also like to add that while I live in Colorado on ancestral homelands of the Arapaho, Cheyenne, and Ute tribes, I am third generation New Mexican. I am related to Aldo Leopold, and so I'm grateful to be here today.
Thank you. Is SWAG Exhibit 18 an accurate copy of your resume?
Yes.
And did you provide rebuttal testimony on behalf of SWAG?
Yes.
Is that written testimony included as SWAG Exhibit 17 accurate to the best of your knowledge?
Yes.
Do you adopt it today? Thank you. I think we have pulled up your presentation and you may proceed.
Thank you. So, my rebuttal testimony is in response to NRP's proposal to include exclusions in 20.6.2.10C, specifically letter E, the proposed exclusion for wetlands adjacent to ditches, and I'll be focusing on this today. I'm also going to speak a little bit to the proposed temporary authorization process, which was proposed by NRP in its direct testimony and later included by the department in Exhibit 79A. SWAG supports the need for a temporary authorization process, but recommends certain deadlines to ensure the process is workable and protective of New Mexico's aquatic resources. So I'll start with Mr. Lindenlaub's proposal to include a list of 11 limitations or exclusions that are taken from Colorado's newly adopted dredge and fill permitting program. One proposed exclusion, wetlands adjacent to ditches, Mr. Lindenlaub explains are features that are not to be regulated, but SWAG urges the Commission to reject NRP's proposal to include this particular exclusion for these reasons. First, wetlands adjacent to ditches are not automatically excluded from federal jurisdiction under the Clean Water Act, Section 404 program, and shouldn't automatically be excluded in New Mexico just because Colorado did it. Second, agricultural entities who maintain and operate most ditches are already exempt, such that they can conduct their normal ditch operations regardless of the existence of adjacent wetlands. In the proposal for an exclusion, if the proposal, of an exclusion were rejected, as it should, the entities needing a dredge and fill permit for impacting wetlands adjacent to ditches are not going to be farmers and ranchers. Finally, and most importantly, this exclusion, if adopted, could result in significant harm to New Mexico's remaining and critically important wetlands. Next slide. Mr. Lindenlaub does not substantively testify as to why New Mexico should consider the exclusion, which is not listed in Senate Bill 21, except to say that it was adopted in Colorado. Ms. Walker discussed in her testimony that Colorado adopted the ditch adjacent wetland exclusion in Regulation 87 because the Colorado legislature, in order to obtain some sort of consensus among various parties and interests, included it in the final bill along with other exclusions. But this is an opportunity for New Mexico to do better. New Mexico's waters, including wetlands adjacent to ditches, are unique and are rare. In Colorado, wetlands occupy 2% of the landscape, while in New Mexico, they comprise only about 0.6%. Although wetlands adjacent to ditches represent a substantial portion of Colorado's wetland resources, wetlands in New Mexico are far less abundant and continue to decline. Given the scarcity and ongoing loss of wetlands in New Mexico, the state cannot afford to weaken protections for any category of wetland resources. We therefore urge the Commission not to adopt NPR's and NRP's recommendation because Colorado has done so. What was an unfortunate trade-off in Colorado could have far more significant consequences in New Mexico, where wetlands are considerably rare. Next slide. My second point is that surface water permitting regulations do not apply to construction and maintenance of farm or stock ponds, acequias, or irrigation ditches, or the maintenance of drainage ditches, as you see here on the slide. So agricultural activities are already exempt such that farmers and ranchers can conduct their normal ditch operations regardless of the existence of adjacent wetlands. I understand that irrigating dry land by way of ditches is an ancient practice in New Mexico. If wetlands are protected, even those adjacent to and supported by water from, say, earthen acequias, agricultural practices would not change because those activities, again, are exempt. Earlier today, you heard Mrs. Corday reference in her testimony a report from the National Association of Wetland Managers that compares all 50 states' stream, jurisdiction, and mitigation programs. The report indicates that the states that regulate ditches, many have conditions and or exemptions, not exclusions, for specific types of uses, such as farming. And in New Mexico, as you see here, these agricultural and ditch construction and maintenance exemptions already in Senate Bill 21 ensure that agricultural entities would not have to get permits or be regulated for impacting ditch adjacent wetlands. Thus, the recommendation to exempt wetlands adjacent to ditches, thus, if the recommendation to exempt wetlands adjacent to ditches is not adopted, the entities required to obtain dredge and fill permits will not be farmers and ranchers. Rather, permitting requirements will apply to those conducting activities that impact wetland resources and who are appropriately subject to regulatory oversight. Next slide. Now I'd like to talk to you about these wetlands in question, ditch adjacent wetlands, just a little information about them from a scientific stance. Consider that in many cases, not all, but in many cases, ditch water is a diversion of river water into ditch systems. Especially in arid climates like New Mexico, the diversion can result in a drawdown of the main river channel from which the ditch diverts. This results in the loss of wetlands along the river itself. So many wetlands occurring along ditches, so many wetlands occurring along ditches would otherwise be occurring adjacent to rivers and streams, if not for the ditch. These wetlands that are adjacent to the ditches are essentially, in this case, surrogate wetland ecosystems, serving important services that used to be provided by the wetlands along the river. Purposes such as vital habitat, flood control, water infiltration. You've already heard today about the ecological significance of these systems from Mr. Hayes. And tomorrow you'll hear from Dr. Sultanfus about the important significance of all wetlands, including ephemeral streams. Next slide. So to illustrate how harmful a specific exclusion for ditch adjacent wetlands would be for New Mexico, Trout Unlimited assessed wetland ditch adjacency using a very similar methodology to that used by the Colorado Natural Heritage Program during Regulation 87 rulemaking. CNHP employed calculated wetlands adjacent to ditches using, and TU did the same, publicly available data sets, such as the National Hydrography Data Set of the USGS, the Geological Survey, and the National Wetland Inventory Data Set of the U.S. Fish and Wildlife Service. TU concluded that they could safely estimate that there are 30,356 acres of wetlands classified as freshwater emergent, freshwater forested shrub, and freshwater pond systems adjacent to ditches in New Mexico. These are the type of wetland ecosystems we would expect to see next to ditches. A 5-meter mapping buffer was then added to either side of the combined linear ditches, which captured vegetated wetland polygons within the data set. The polygons could, for instance, be represent about a 1/4 acre or more of continuous wetland, again, adjacent to the ditch. This 5-meter buffer approach revealed that at least 7.4% of New Mexico's wetlands classified as, again, freshwater emergent, freshwater forested shrub, and freshwater ponds are located within 5 meters of ditches. And I didn't get into the nitty-gritty about our calculus, so if the commission would like a little bit more information about the methodology that TU used, I'm happy to provide that. Next slide. So the TU analysis highlights 2 important points. That wetlands adjacent to ditches, at least within that 5-meter buffer, are a substantial share of total wetland acres in New Mexico. And many ditch adjacent wetlands are natural, historically occurring wetlands on low geomorphic floodplains where water naturally flows both above and below the ground surface. The presence of ditches in or near these natural wetlands does not mean that they are the product of the ditches, but that they are in fact the very wetlands that the state intended to protect in Senate Bill 21. Therefore, excluding 7.4% of these wetlands cannot be reconciled with Senate Bill 21, which stands to protect all of New Mexico's aquatic resources. Next slide. So in conclusion, with about 500,000 acres of wetlands remaining statewide, it would be ecologically damaging to exclude over 30,000 acres from protection from dredge and fill activities. The sheer number of acres of wetlands adjacent to New Mexico's ditches in an arid state with half of its wetlands left underscores the need to deny this. Next slide. So switching gears a little bit, SWAG appreciates that NRP offered a proposal for temporary authorizations, and I have reviewed Exhibit 79A and the department's proposed language for a temporary authorization process. There is value in having a predictable permitting process through temporary authorizations for activities that would otherwise be covered under a state general permit. However, to both be workable and protective of New Mexico's aquatic resources, SWAG recommends that the department's revision in Exhibit 79A be amended to include some tighter deadlines. Let me give you an example. In Colorado, there was a built-in deadline for temporary authorizations, which were written into statute as an interim measure to ensure that certain dredge and fill projects could proceed before the Water Quality Control Department issued general authorizations, which is in fact happening this September. After general authorizations are issued, temporary authorizations can no longer be used or issued. Project proponents must finish out their existing authorizations, and then all future project proponents must apply for either individual or relevant general authorizations. Slide. Thank you. You're good at this.
Thank you.
So we recommend these changes that you see here to the department's revisions in Exhibit 79A. That the department shall only issue temporary authorizations through the effective date of the relevant general permit and no later than December 31, 2028. And that temporary authorizations issued on or before December 31, 2028 shall be valid for only 1 year, not up to 3 years. If NMED adopts the language as proposed, there could potentially be temporary permits that extend for years that are essentially federal permits not tailored to New Mexico. Temporary authorizations remaining valid too long and the delay of issuance of New Mexico specific general permits means that the public, expert agencies, tribal governments will not be able to influence the regulation of dredge and fill activities for several years to come in some cases. So a commitment to these suggested deadlines actually gives all parties more certainty. And that's all.
Thank you very much. That concludes our testimony. I will move for admission of SWAG Exhibits 1 through 18, and then the panel will stand for questioning.
Any pause for any objections to Exhibits 1 through 18? Mr. Mullenberg, I see you're on your feet. Can you come to a microphone?
Yes.
Madam Hearing Officer, NRP does object to their admission to the extent they're offered as a legal opinion on New Mexico law, and we can explore that further in cross-examination if you wish.
Okay. Any other objections? All right, let's take up the admission after cross is completed. Mr. Mullenberg, are you going to be, Mr. Boutier? And Mr. Boutier, if you could do maybe 15, 20 minutes and then find a good stopping place.
That should be all I need. Thank you, Madam Hearing Officer, Mr. Chair, members of the commission. Thank you, panelists, for your testimony. My name is Stuart Boutier. I'm with the Modrell Sperling Law Firm, and I'm one of the lawyers representing the Natural Resources Partnership. All of my questions are for you, Mr. Hayes, and then we'll have a couple of other questioners. But Mr. Hayes, you're the Executive Director of Audubon Southwest Regional Office. Is that correct? And I apologize if I missed this in your testimony, but you're not an engineer, am I correct on that?
Correct.
You're not a hydrologist?
Correct.
Are you a lawyer?
No.
Okay. And you're not a wetland delineator?
No.
And you're not a permitting specialist, is that correct?
Correct.
Okay. Have you ever worked for the U.S. Army Corps of Engineers in reviewing Section 404 permits?
No.
Have you ever administered or been part of the administration of the state dredge and fill permitting program?
No.
And obviously, since you're not a lawyer, you're not offering legal opinions regarding statutory interpretations.
That's correct.
Nor are you offering an opinion about how the commission should interpret the Water Quality Act as a matter of law.
Correct.
In your rebuttal testimony, you responded to Mr. Brian Lindenlaub's discussion of isolated wetlands and playas. Remember that? Your disagreement was based primarily on wildlife impacts, correct?
Yes.
And you don't have disagreements that are based upon any kind of jurisdictional analysis under SACIT, is that correct?
That's correct.
Nor any analysis of federal Clean Water Act case law.
Correct.
Nor on any analysis of pre-SACIT federal jurisdiction or jurisdictional determinations.
Correct.
Have you performed any independent review of Army Corps of Engineer jurisdictional determinations for playas in New Mexico?
No.
And you're not offering testimony regarding which waters were or were not federally jurisdictional under the Clean Water Act prior to SACIT?
Correct.
Your principal point is these are resources that are valuable for wildlife.
Yes.
Okay. And the primary thrust of your testimony it is based upon general concerns regarding potential impacts to wildlife.
Yes.
Okay. You also testified that riparian habitat is important for wildlife.
Yes.
Which is a point I think we could stipulate to, and that's not something that certainly the Natural Resources Partnership would dispute. Your testimony is that riparian areas provide important ecological functions.
Yes.
And that's based on a conservation-based opinion.
A biological opinion, yes.
Okay. And let me ask you, are you offering any opinions about how one would determine the aerial extent of a riparian area as a technical matter?
No, I'm not.
Okay. And you've not proposed any kind of specific measurable boundary or indication of boundary for riparian areas, is that correct?
That is correct.
Nor proposed any sort of specific width. Obviously, they vary widely.
Correct. Yep.
Have you proposed a specific methodology for identifying the outer edge of a riparian area?
No.
And would you agree with me that different scientists can reach different conclusions about where riparian areas begin and end?
Maybe that's kind of hypothetical, kind of tough to answer.
Okay, that's fair enough. Would you agree that different scientists can differ as to what the specific boundaries of a riparian area might be?
Yeah.
And would you also acknowledge that in some locations, particularly the arid Southwest, boundaries of riparian areas can be very technically difficult to identify?
I'm not sure any more here than anywhere else. Yeah, but it can be difficult to identify, sure, where the one vegetation community starts and one another begins.
Thank you. And your testimony, therefore, does not, either in your direct or your rebuttal or today in this hearing, does not offer for the commission a particular permitting standard for determining the precise extent of regulatory jurisdiction.
Correct.
Would you agree with me that critical habitats can exist in areas outside of the types of features that you've identified in your testimony, cienagas, bends, other sorts of playas, thank you. The critical habitat for wildlife can be even including upland areas.
Yes.
Correct. And it's critical habitat is not something that has a one-on-one relationship to areas that have aquatic resources.
No, there are all types of critical habitat depending on the species.
Okay. And so identifying critical habitat does not itself answer whether the commission has jurisdiction over a particular discharge under the proposed rules, correct?
That's my understanding. Although if you're using critical habitat in terms of Endangered Species Act critical habitat, there might be something there, but you're using it as a small c critical habitat.
Well, let me ask you. That's thank you for the question. Critical habitat in the capital C sense typically comes up in T&E species issues under the Endangered Species Act.
Yeah.
And this proceeding is not involved in questions relating to endangered species, am I right?
Yeah.
Do you disagree with Mr. Lindenlaub's view about mitigation for ephemeral waters? Have you offered any testimony in that area?
Help me, could you characterize Mr. Lindenlaub's assertions, please?
Well, just probably not effectively, to be honest with you.
Okay.
But
I can't recall it direct.
But if it doesn't sound familiar, I mean,
it does not sound
okay.
Directed,
Okay. But you do believe that ephemeral waters provide important ecological functions?
Absolutely. Yeah.
And your testimony cites studies describing the ecological benefits of ephemeral waters?
Yeah, yes. Ephemeral waters where they're meant to be ephemeral are just as important as permanent waters where they're meant to be permanent.
But your testimony is general. In other words, you did not perform a functional assessment of any particular New Mexico ephemeral water, correct?
No.
Okay. And would you agree that some ephemeral features provide significantly greater ecological value than others?
Well, it depends on ecological. What's your value in ecological?
Okay. Would you agree with me that ecological value can vary significantly from one site to another when we're talking about ephemeral waters?
I mean, it depends. I mean, if there's an intrinsic value to ecology, that's hard to define. So I'm not quite sure how to put a value on ecology.
Okay. Fair enough. Your testimony, overtaken as a whole, does not provide an independent legal interpretation of the Water Quality Act. I think I may have already answered that question.
No, correct.
And nor does it instruct the commission or give the commission any guidance or advice on where the commission's jurisdiction begins and ends in the area of surface water permitting program under 20.6.2.
No, my testimony did not speak directly to that, more to the importance of the protection of those types of habitat.
Okay, thank you. That's all the questions I have. Thank you.
Thank you, Mr. Boutier. Who else will be asking questions for NRP? Mr. Mullenberg.
I don't.
Thank you, Madam Hearing Officer. Good afternoon, panel. My questions are going to be directed to Ms. Walker. Good afternoon, Ms. Walker, and thank you for your testimony. Your resume that you've offered as an exhibit for this hearing does not identify you as a member of the State Bar of New Mexico, correct?
Correct. But I am admitted pro hoc for the purposes of this proceeding.
You're admitted pro hoc for purposes of this proceeding, but you're not appearing in this proceeding as an attorney, are you? Or
I thought that would be helpful information.
fair enough. We can assess that. Because you are not admitted to practice by the New Mexico Supreme Court in New Mexico, you're not offering your testimony as a legal opinion on New Mexico law, correct?
I'm not sure that's true, actually. Because if I'm admitted pro hoc, doesn't that mean I get to practice law for the purposes of this proceeding?
Well, that's not a question for me. That's a question probably for the hearing examiner and others, but I'm asking for your position on whether you are or are not.
Yes, I definitely giving a legal opinion on interpretation of SB 20.
And as such, you would be giving an opinion on the interpretation of New Mexico law?
Yes.
So, Madam Hearing Officer, we'll take this up in the objection part. We'll come back to that and go from there. So, Ms. Walker, based on your testimony, you are familiar with Senate Bill 21 from the 2025 legislative session and the codified New Mexico statutes based on that legislation, correct?
Well, certainly SB 21, yes. I don't know what you mean by the set of.
Well, Senate Bill 21 offered changes to the New Mexico statutes, including the Water Quality Act, correct?
Oh, okay. Yes, yes. But I didn't focus on the NPDES part of it. Is that helpful?
Well, it's helpful. I mean, I don't know, this is a big distinction, but I'm just incorporating the statutes that were derived from Senate Bill 21 in my questions.
Yeah, I definitely focused on the dredge and fill parts.
Right. I'm not seeking to limit you at this point.
Yeah, I'm just trying to answer questions.
Understood. So based on your familiarity with Senate Bill 21, you're aware that it uses the phrase surface water, correct?
Yes.
However, neither Senate Bill 21 nor the Water Quality Act sections based on Senate Bill 21 contain a definition of surface water, correct?
But it does contain a definition of water.
That's not my question. My question is whether it contains a definition of surface water.
Well, I mean, arguably it does, because it defines water as as surface water, right? So water encompasses surface.
Water encompasses groundwater too, right?
Yes, but surface water is an important component of the definition.
But the statute does not specifically identify the phrase surface water, correct?
Identify it?
Define it.
Well, I think I stand by my interpretation.
If the legislature had intended to assign a specific meaning to the phrase surface water, it could have incorporated a statutory definition of that phrase, correct?
Well, pardon me for saying this again, but I feel like it did. Because it defined water and it defined surface water discharge. And so what is a surface water discharge? It's a discharge into a surface water. Then you look at the definition of water and you get your answer. I don't mean to be arguing with you, but this is definitely my take on the statute.
And I understand your argument, and I'm just asking some specific questions to the text of the Senate Bill 21 and the statute.
You know, as I say, I feel like the definition is in there.
The commission that you're here before has adopted a definition of surface waters of the state by rule, correct?
Yes.
And that definition of surface waters of the state is contained in Part 20.6.4 New Mexico Administrative Code, the surface water quality standards, correct?
Correct.
The legislature did not define surface waters for purposes of the surface water quality standards, but left that definition for this commission to define by rule, correct?
Wait, I'm sorry. Could you say that again, please?
The legislature did not define surface waters, or I would add surface waters of the state, for purposes of the surface water quality standards, but left that definition for this commission to define by rule, correct?
You mean back when the rule was finalized? Is that, are you talking about SB 21 or some former legislation?
Well, I'm talking about the Water Quality Act.
Okay, but we're talking about SB 21?
This is a fairly simple question. The legislature did not define the term surface waters of the state by statute, did it?
Sort of.
Sort of is your answer?
Well, I'm going back to this idea that I feel like they did. And I'm sorry you disagree with me, but that's definitely my interpretation of the statute.
And really, my question is an interpretive question. It's really a question of fact, but we'll move on. So with your testimony, are you intending to give an opinion that this commission has no discretion whatsoever with regard to the adoption of a definition of surface water for purposes of the surface water permit program under 20.6.2 New Mexico Administrative Code?
My testimony is offering my interpretation of SB 21 to the commission based on my understanding of what the plain meaning of the statute is.
I understand what your argument is.
Hold on, you keep talking over one another.
Oh, sorry. Sorry, that was just a preface to what I was saying. So, I mean, am I telling the commission that it doesn't have any discretion? What I'm saying is this is my understanding of what SB 21 says, and I do not think that either the department or the commission can deviate from what the legislature says.
We may agree upon the point that if the legislature has offered a definition, that neither the department nor the commission can vary from that. But my question really is where the legislature has not defined a specific phrase, whether the commission has discretion, and in fact was intended by the legislature to define that phrase.
Yeah, so I know this may seem very frustrating, but I'm going to stand by my initial interpretation of the statute, which is that it does tell the commission or the department what qualifies as a surface water for the purposes of the permit program.
Mr. Mullenberg, we need a break soon. You would find a good stopping.
Yeah, why don't we stop here? This is taking longer than I anticipated. So
alrighty, let's take 10 minutes and let's see, come back at 2:45. Too few, too short. Let's see, where were we? We were in the middle of Mr. Mullenberg's questioning. Go ahead, Mr. Mullenberg.
Sorry. Ms. Walker, in your testimony, you indicate that if questions arise regarding the meaning of the phrase surface water, the department could develop written guidance regarding the meaning of that phrase. Do you agree with that?
Not exactly. Sorry. Taking it very literally, but I think the point was is that my interpretation says that the definition of surface waters of the state from the 0.4, right? 0.4, I can't remember that number in my head, is appropriate. And then if the regulated community didn't understand that definition, that then guidance could be appropriate. But I also would add to that now there's new provisions in the department's rules that invite the regulated community to ask questions. So that's another good thing.
Are you contending that such written guidance would be binding on persons in New Mexico?
Binding guidance is typically not binding. Usually has to go through rulemaking for it to be binding.
In your written rebuttal testimony, you discuss the concept and definition of the term ordinary high water mark, don't you?
No, I think if I recall correctly, and I could be mistaken, that what I said, I just pointed out a slight contradiction in what I saw as a contradiction in NRP's testimony about ordinary high water. But I left it to Jackie and others to talk about what that really means.
Am I correct that your testimony acknowledges that the U.S. Army Corps of Engineers rules define the term ordinary high water mark, and that term is utilized by the Army Corps of Engineers in its permitting program?
I don't recall saying that.
Are you familiar with the term ordinary high water mark as defined and used for purposes of Colorado Rule 87?
No.
Apologies. Objection, I think, is outside the scope of Ms. Walker's testimony.
And she's answered that she's not familiar with it, so
okay.
I'll move on. Are you aware that in recent years, the New Mexico legislature has created a record of legislative committee hearings through video recordings?
No.
Your testimony refers to the definition of aquatic resources as it appears in Senate Bill 21 and the Water Quality Act, correct?
Correct.
The definition of aquatic resources does not incorporate the phrase surface water, does it?
It refers to surface water because it says it lists various bodies of water.
Correct. And that would be my next question.
Oh.
The definition of aquatic resources lists certain categories of bodies of water, including wetlands, streams, lakes, and rivers, correct?
Oh, may I just look at it?
Certainly.
To...
And again, my question is literal, whether, yeah.
Oh gosh, where is it? You know, you'd think I had it memorized by now, but I apologize. I do know it. Okay. Oh, let me bring it up. Ooh, yeah. Got it. Okay, I'm ready.
Right. So let me go back to my question then, now that you have the definition in front of you. The definition of aquatic resources does not incorporate the phrase surface water, does it?
No, just other bodies of water.
Correct. And the definition then separately refers to riparian habitats, correct? And by separately, I mean separate from the list of the bodies of water.
Well, it's a list for sure. It's a list.
And riparian habitats occurs in the definition of aquatic resources after that list of bodies of water, correct?
Yes.
The Senate Bill 21, in its definition of the phrase surface water discharge, which I believe you referred to in your presentation this morning, does not use the phrase aquatic resources, correct?
Correct.
And the definition of surface waters of the state in the Commission's rules in Part 20.6.4 also does not include the phrase aquatic resources, correct?
Correct.
Thank you. That's all I have.
Thank you, Mr. Mullenberg. Are there other questioners on behalf of NRP? No? All right, thank you. Mr. Stomp, do you have questions of this panel? Thank you. Mr. Stomp declined. Ms. Taylor?
Yes, Madam Chair, I also declined.
Okay, thank you very much. Ms. Taylor declined. Mr. Perkamenko?
I don't have questions. Thank you.
Okay. Go ahead. Mr. Perkamenko, it appears you've muted yourself.
No, I do not have questions. I'm sorry.
Oh, I'm very sorry. I misheard you.
I apologize. My accent sometimes is difficult to understand.
My ears are sometimes difficult. Okay, let's see. The agricultural districts. Mr. Brooks, do you have questions? Please go ahead.
I believe most of my questions are for Ms. Giles. Is that the correct pronunciation? My name is Caleb Brooks. I'm with the law firm Spencer Thane. I represent the Middle Rio Grande Conservancy District. You understand who I am and whom I represent? Ms. Giles. Oh.
Going that way. All right. I'll lean forward.
Ms. Giles, at the beginning of your rebuttal testimony, you defined ditch as including acequias and canals that divert river, stream, or snowmelt water. Is that basically your definition of the term?
In the written testimony, that's.
Yes, ma'am.
Yeah.
And under that definition, would the irrigation canals and drainage ditches operated by MRGCD qualify as ditches?
I believe so.
Did your analysis using the National Hydrography data set to identify ditches in New Mexico include ditches within MRGCD's service area?
I can't speak to that directly as I didn't do the analysis. You did.
Okay. And did you know whether TU included ditches within the MRGCD service area?
I believe so.
Okay. If ditch adjacent wetlands are included as surface waters of the state, then any dredge and fill activity that affects them would generally require a permit unless an exclusion applies. Is that right?
Say it again, please.
Yeah, so if ditch adjacent wetlands are included as surface waters of the state, then any dredge and fill activities affecting them would generally require a permit unless an exclusion applies. Is that right?
Unless the Corps decides to exclude that in that particular situation. It's not, so in Sackett or post Sackett, it's not a blanket exclusion. There are circumstances at which a ditch adjacent or a wetland, excuse me, adjacent from a ditch would be jurisdictional.
Okay. So but perhaps I'm misunderstanding. It's not your contention that dredge and fill activities in ditch and wetlands adjacent to ditches would require a state-based permit?
Not necessarily. I'm saying what my testimony was saying that
a blanket exclusion for all wetlands adjacent to ditches is not in the best interest of the state.
Okay, so under the rules as you would propose them to the Water Quality Control Commission, there are situations in which dredge and fill activities in wetlands adjacent to ditches would require a permit,
yes.
An exclusion.
Mm-hmm.
Okay. I'm sorry we got wrapped around the axle there. I just don't think we were understanding one another. And you also testified that activity-based exemptions in SB 21 and the proposed exemptions in 20.6.2.2303 would exempt many agricultural activities, even if they affect ditch adjacent wetlands. Is that right?
Yes, for instance, if an entity, let's say a farmer or a rancher or another entity chose to line their ditch, or connect or put their ditch into a tube, pipe their ditch, and the adjacent wetlands dried up, that is their prerogative. If it's an agricultural activity.
Yeah, I'm just trying to understand the limits of those exempted agricultural activities as you understand them. Would, for instance, installing telemetry devices, check gates, would that count as an exempted activity as you understand it?
I can't speak to that. It's beyond my control.
Okay. What about the lateral extent of a ditch? So a parallel roadway or access way, if maintenance is being done on one of those, do you know whether or not a state-based permit would be required under the rules as you propose them?
That in that regard, you're getting into like physical adjacency, distance.
Mm-hmm.
So I can't speak to that. That's not something that's spelled out in SB 21.
The reason I'm asking these questions is you represented to the Water Quality Control Commission here that most of the people who would need to pull permits, even without this exclusion for adjacent wetlands, would not be farmers and ranchers. Do you know if currently MRGCD pulls permits for work like telemetry stations or roadways?
I don't know.
Okay, that completes my questions. Thank you so much.
Thank you, Mr. Brooks. Any other Ag District Council have questions? No. Ms. Richards. Thank you. Ms. Richards declined. Ms. Dolan.
Thank you, Madam Hearing Officer. I have no questions.
Thank you. I don't know if we have Mr. Maxwell or Mr. Weatherby on the platform. Okay. Mr. Crimsey. No questions. Ms. Miller. You may have stepped away. Mr. Micklejohn.
No questions.
Thank you. Mr. Micklejohn declined. Ms. Fox.
No questions. Thank you, Madam Hearing Officer.
Ms. Fox declined. Ms. Scott or Ms. Weatherly?
No questions.
No questions from Ms. Scott. Do you have redirect?
No redirect, but I would like to address
The
the
exhibits.
objection if possible.
Swag exhibits 1 through 18. Mr. Mullenberg, are you still pressing your objection?
Thank you, Madam Hearing Officer. Yes, we are pressing the objection. Again, the objection is to the exhibits to the extent that they offer a legal opinion under New Mexico law. I will tell you that the apparent pro hoc vice admission, which I presume was through the state bar, as I'm not aware that the commission has a process for pro hoc admission. I was not aware that it had not been disclosed, and because I'm not aware of it, I'm not prepared to necessarily address that, other than to comment that normally a pro hoc admission would be by counsel appearing in a matter, and of course, by appearing in the matter under that authority, they would have the ability to present legal arguments. I'm drawing the distinction between legal arguments and a legal opinion under New Mexico law. And I will say, just to cut to this too, that if the testimony is being offered as a legal opinion, then we would reserve the right to submit a legal opinion as surrebuttal testimony.
So I took just a very quick look because we had a short break at the Pro Hoc Vice rule, and one related but not entirely on point ethics advisory opinion in New Mexico. And it appears that formal legal opinions and advice, so opinions and advice, are okay, so long as the admission has been made pro hoc vice. I didn't see a distinction between witness and counsel. The one limitation I saw that I don't believe applies here is if the legal opinion or advice is not related to this proceeding. And this is the proceeding in which you've been admitted, as I understand it. So if you were to take a med mal case, that would be unauthorized practice of law. But in this proceeding, as I understand it, you've been admitted for hoc vice. So I'm Mr. Mullenberg, if you want to, let's not talk about it right this second, but if you want to pursue some rebuttal that responds to the rebuttal you heard from Ms. Walker, let's have that conversation. I don't oppose it. Someone else might oppose it, but I don't oppose it.
Understood. Thank you.
All right. Thank you, Mr. Mullenberg. So swag exhibits 1 through 18 are admitted. Thank you for that. Panel, we're going to turn now from questions by other parties to questions by the commission. And let's see, I think it's that side's turn to go first. Commissioner Langer.
No question.
All right, thank you. Commissioner Laney.
Yes, thank you. Thank you for your testimony. I think I probably just have one question, and I tried to ask it earlier. I just want to get some clarification on some included language. So just to reaffirm, the red line document that was submitted as part of the testimony were the changes that you were proposing.
Yes.
Thank you. Whomever is best suited to answer this, please feel free. Okay, so then it occurs in a couple places. One place is 20.6.2.2306, which is the general permitting coverage. And section 2, it's A, which is a requirement for a summary report from the environmental review tool, including the names and any federally listed state species maps of any designated or proposed critical habitat and any SGCN aquatic habitat that might be affected by the proposed general permit activity. And then similar language exists under 20.6.2.2308, which basically for a completeness of an individual permit application, the applicant shall also include the environmental review tool. Can you explain that tool?
Sure, I can try my best. Although someone from the Department of Wildlife that works with it regularly may be able to do better. I can't say that I have regular work in that tool, but basically it's a database that's linked to the Natural Heritage Program and NatureServe, which is a national organization that compiles data on species, plant, animal species, and basically is a database of where and what exists and shows habitat maps along with probably the descriptions of individual accounts of individual species that exist in the state. And so you can query the tool and likely get data that can guide a permitting, a permitting application.
So what is the significance of requiring it as part of the permit application?
We had actually received that from the Department of Wildlife that had asked us to include that as their preferred method of gathering data to give an assessment of a permit. So okay, we're including that at their request.
Okay, and the reason that I ask is that this would go beyond the guidance document that, or any type of guidance document that may be developed to help a permittee through the permit process. This then becomes a requirement of the application. So it's no longer just a guidance document. It is a document that must be included. And I just wanted to make sure that I fully understood the scope of why it was being included.
I thought it was included.
May we confer for a moment?
Oh, yes, go ahead.
Yes, we support the use of it as guidance.
Okay, so then the red line language is perhaps a little stronger than it should be. It says in the area, the general permit area, as well as the individual permit area, that it shall also include. Shall means it must be there. It's not optional at that point. So you're putting a really hard requirement when you use shall versus may. You could say it may be included, and that would allow for there to be flexibility.
Yeah, I think honestly, I think the conversations with the department about including that language happened after those red lines were submitted, and maybe that's just reconciling the two.
Okay, thank you. I appreciate that feedback. The only other question, I lied. I said I had one question. I had two. I apologize. Is that it sounded like there is an inclusion of a review by the, let me find my notes here so I can be more direct. By the Wildlife Department when an application is being submitted. Is that correct?
Yes.
Okay. Is there any, would that delay the permitting process in any sort of way?
The hope is that the tool would enable a really quick evaluation, and also in the red lines, we're proposing that the consultation by the agency would be at the agency's discretion too. And so if they were limited in capacity, they could.
Okay, and I did not see that inclusion. That doesn't mean it's not there. I may have just missed it in my reading. So thank you. That's all I have.
Thank you, Commissioner Fry.
I have no question.
Thank you, Commissioner Chapman.
Thank you all for your testimony. I don't have any questions.
Thank you, Commissioner Thompson.
Thank you. Thank you for your testimony. It's interesting. I'd like to follow up first on Commissioner Laney's question. One of the big concerns, and we've seen it for 3-4 days, is the cost of this program that is going to be borne by the permittees. And so this is a question to Mr. Hayes. If we include a review by Department of Wildlife, will that add cost and delay to the permit process?
To be honest with you, I'm not an expert on permitting processes. I can't quite say. I'm not sure what to compare it to. But I would assume there's an additional step that's added here. But the agency is going to only take on that review if they have the capacity to do it in a timely manner. So I would assume that would be negligible, but I'm not an expert.
And then, of course, the question is, if it does add significant cost, is the Environment Department going to have to transfer some of the funds to Department of Wildlife? And that's for other people to decide. A related question is that a designated use in our stream standards is wildlife habitat. So doesn't that already include consideration of the issues that you have raised?
Go ahead.
May I answer that?
Please.
So our suggestions are in the context of dredge and fill permitting. And certainly protecting water quality is one aspect of protecting aquatic resources from dredge and fill, but not the only one. For example, we made the suggestions from subpart H from the 404B1 guidelines that talk about things like protecting wildlife by timing the discharge so it doesn't impede migration or spawn. And that's an example of a situation that isn't necessarily water quality based. It's a timing situation. Another example was avoiding habitat altogether, which isn't the same as protecting in-stream water quality standards. Does that make sense?
I'm not sure it does. How would you avoid water quality altogether?
Well, I wouldn't say that it's avoiding water quality. It's in addition to protecting. So in other words, it's not the only way that you protect, for example, wild from dredge and fill materials, or I'm sorry, the discharge of dredge and fill materials is just to look at the impact on, for example, water quality standards, right? It's a larger, there's a larger number of protective mechanisms than just protecting. I mean, one of the things that happens when you do dredge and fill activities is you actually destroy wetlands or streams altogether, right? So you know, when you're putting fill material into a wetland, that means the wetland is gone. That is not, you know, so to avoid the impacts to that wetland, you're not just saying, you know, the chemical makeup of this wetland has to be XYZ. It's basically saying we're going to sacrifice this wetland to development. Still,
well, it's kind of a fuzzy area, and I am not a dredge and fill expert, but it's complicated. So my follow-up question to that is the permit program, the dredge and fill permit program would be administered as proposed, would be administered by the NMAC, and they have environmental scientists. Are they not capable of making those evaluations?
I would say that we would trust impact. The Department of Wildlife is the experts in the state on impacts to wildlife and wildlife habitat, and would more likely to trust their opinion and their experts than who's at NMAC. There's great folks at NMAC too, but just different degrees.
Thank you. Ms. Walker, you said something that caught my attention. You said something like 20 states have dredge and fill regs. Does that imply that the other 30 states don't have dredge and fill regs, or just allowed under or administered by the Corps?
Right. Yes.
Okay. So would it be possible for us to write these new surface water permit program and separate dredge and fill and leave that with the Corps?
No. I mean, SB 21 directs you to create a program.
It's been a while since I looked at SB 21.
Yeah, I mean, again, this is my legal opinion, but I mean, that's the whole purpose of SB 21 vis-a-vis dredge and fill. I mean, there's a lot more in the statute, don't get me wrong, but it says create a program to protect or to regulate the discharge of dredge or fill material into a surface, right? So, yeah, I would say no, you couldn't. My advice, my opinion is that no, that would not be compatible with this.
Okay, thank you. My last question is to Ms. Giles. Most of our acequias and irrigation ditches are unlined, and they leak like a son of a gun. And because of that, there are many adjacent wetlands. If an owner comes in and wants to line the ditch as a water conservation measure so that he could use that water more efficiently to irrigate his fields, that would destroy the wetland.
Right.
And is there anything in this proposed reg that would impact his ability to do that?
if the activity is for agricultural purposes, as you say, to say irrigate a field. Nope. If the wetland dries up, the wetland dries up. If it's solely sourced from the irrigation, the acequia, the ditch, so be it.
Okay, thank you.
Thank you, Commissioner Hall.
Thank you for your testimony. I don't have any questions.
Thank you, Commissioner Sloan.
I think I have just a few. And I'm not just going to say them, and whoever answers. So you talked about the state wildlife action plan, and you mentioned that it's not a regulatory document. It's also subject to change, right? The agency can amend it at any time. It has to go through a revision every 10 years. So does it really make sense to reference that particular document in a formal regulation versus putting it into the guidance documents?
I think we lack for another tool that would give as sort of useful of a list and direction. So while it's not a regulatory document, it's probably the most, comprehensive collection of expert opinion on priority wildlife in the state.
By putting in a regulation, it becomes regulatory.
And the intent was we agreed not to include it as requirement to make sure it wasn't leaned on as a regulatory document.
Okay. Yeah. So to follow up on another commissioner's question, does the Environment Department have biologists on staff?
I'm not an expert on the org chart of the Environment Department. I would assume probably.
They do. Okay, I can go there. So do you know what the Wildlife Department's current role is in reviewing federal permits?
It depends. Sure, yes. Depending on whether it's an ESA permit or NEPA, there's a state consultation.
About NPDS or 404, 401 permit?
I'm less familiar with those processes.
Okay. And I think this is the last one, which is again a follow-up. How is DOW's review, Department of Wildlife's review, going to get funded? And there's going to be a cost for personnel, et cetera.
I think that's probably a question for the director and the commission, but I would think through a combination of the existing funding license and PR dollars and/or additional funding from the legislature.
And you don't think that using Game Protection Fund dollars would constitute diversion?
I'm not an expert on that. I wouldn't want to say that.
Okay, thank you.
Thank you, Commissioner Behill. No questions. Commissioner Burunda on the platform, do you have questions of the second SWAG panel?
He stepped away.
Oh, he stepped away. All right. Is Commissioner Bayless on the panel, on the platform?
No.
All right. I believe that's it then for commission questions. Commission counsel.
Thank you, Madam Hearing Examiner. I have a line of questions for Ms. Walker. So in SB 21, do you agree, you're familiar with it, right?
Yeah.
So you agree that section 1 of SB 21 had a list of definitions?
Yes.
I think there's over 30. None of those definitions is enumerated definitions is surface water.
Yes.
Thank you.
All right. Anything else?
No, thank you.
Thank you. Thank you, Ms. Udall. Thank you, panel. We'll excuse the panel. Travel safely back to your homes. We're going to return to the second department panel. So Ms. Zaki Dellett, Mr. Connolly, Ms. Lemon, Ms. Weatherly, Ms. Scott.
Madam Hearing Officer.
Ms. Weatherly.
So yesterday we all seem to have forgotten a redirect.
I kind of realized that after hours. Those are the kind of things that tickle my brain. So yes, I am sorry that I neglected to call on you for redirect, as I was in a hurry to get to commission questions. Do you have redirect of this panel?
We do have a few questions for redirect, and if we may, we would like to do that before the commission continues their questioning.
And then we'll go back to Commissioner Thompson. Thank you.
And the other matter we would like to bring up is that depending on the extent of commission's questioning, Ms. Zaki-Dellet and Mr. Connolly will be departing after today. And so I guess the department would just ask if any commissioner has a lot of questions, perhaps focusing on those two witnesses today, Miss Shelley Lemon will be available tomorrow and forevermore. Yes.
Thank you so much.
Okay. Just one redirect question for Ms. Zaki-Dellet. In the department's development of the rules, did you review and advise on the language proposed in NMAC Exhibits 79A and 79B?
Yes, I did.
Thank you.
So I'll start with Mr. Connolly. Yesterday, you discussed the permitting process regarding level of effort for drafting a permit. You had indicated that you left some parts out. Are there any other steps that you find notable for this hearing that you would like to discuss?
Yes, there are. There's at least one notable step that I want to just make sure we get on the record, and that is the public comment component of a permit when it is public noticed. There is, and I believe it's important because it illustrates again another large component of level of effort, but it also disproportionate level of effort that the department takes on from larger and more controversial permits. With a small facility, you get very few comments generally in the public comment. You might get 2, 3, 4, and they're generally very simple. With larger and more complex permits, you do get more interest from the public, and you can, with those larger NPDES permits, you can be responding to comments for weeks, meeting with legal on how to respond to those comments, and in certain parts, rewriting aspects of the permit and fact sheet. So you can take on huge level, additional level of efforts through the public comment component. Another one is, and I didn't mention this, is when you are developing water quality-based effluent limits, we have something called total maximum daily loads that have applicable waste load allocations. Those can take a lot of time to interpret. They are not always clear. And in some cases, they require a lot of work from the permit writer. I have written permits where they'll give you a load to be distributed amongst 5 facilities, for example. So then you have to figure out how much load they need and your facility needs just for writing that one permit. So that's coordinating with other facilities, other permit writers that are working on that facility, just to get a limit for a single pollutant into your permit. So just wanted to include that.
Thank you for that. Also yesterday, you were asked about program efficiency related to more permittees under the program. You had referenced program planning and administration as examples of fixed costs that could be reduced as more permittees come under the program. Can you expand on that?
Yeah, I'm gonna read this one. So yes, the 1,200 12,800 hours in related costs of program admin, rule guidance development, review, and revision, and fee administration of the program are diluted as additional permittees seek coverage. Tools and templates that cost considerable hours to develop and are constantly being updated are also distributed across more permittees. The cost of general permit development, which is estimated at 1,800 hours each, are also then distributed among more permittees. IT system development costs as well, although those IT costs may not be specific to the program funding. Training for specific program components, such as a state pretreatment coordinator, become more efficient. With more facilities, your permit writers and inspectors also get more specific in their roles and become more efficient with less training. They don't have to be trained in 7 different inspection types. You may just focus an inspector on 2 specific inspection types, so they don't have to do all the additional field work that an inspector needs to do to get up to speed on how to become an adequate inspector.
Okay, and shifting gears a little bit, can you discuss how legislative appropriations will be used?
I was asked this question yesterday, and my response was that the fees would be reduced proportionally to the legislative appropriations. And I just want to caveat that by first it would cover any funding gaps, and then the remaining would then reduce fees proportionally.
Okay, thank you. Anything else you would like to add?
That is it. Thank you.
Okay, Ms. Lemon, can you discuss the permit determination process?
So we talked yesterday and there was some questions about the department's process for determining if a permit is even required before moving down the application process. We thought that it was clear, but realized from the questions yesterday from both the parties and the commission that that may not be as clear as we thought. So we are looking at adding some language to add a permit determination step and plan to propose rule language for that. It's going to be in the section with the administrative complete section, but it's a permit determination and administrative complete. So if we determine a permit is required, it moves to the next step, which looking at an administratively complete application, and then moves on to the other steps of drafting the permit. So we're keeping it in the surface water permitting regulation section in the 2300s. So that should help to clarify some things. We're also working on amending some language so that right now the rule reads that when the applicant I guess submits their application, they also have to submit their fee. That will change. It will change after that permit determination requirement.
Okay, thank you. Definitely a shift here. Can you discuss the Water Protection Divisions and the Surface Water Quality Bureau's hiring efforts and progress made in the past few years?
Yes. So yesterday we were talking about just the program capacity building, what it's going to take, and the degrees that are going to be required. And some of the discussion was related to having a hard time as a state agency recruiting people with certain degrees because they have opportunities elsewhere. I will mention that the department has been working really hard these last couple of years to not only work on appropriate placement of employees, but also just making sure we're maintaining internal alignment within the department, and our salaries are commensurate with other industries. They have increased substantially over the past several years. We, in my bureau, in May of 2023, we had 43 technical staff and 14 vacancies. So that was a lot. Today, this month in June, we have 49 technical staff. So we've added those permitting staff that I was talking about to help
start building the program capacity, and we only have 4 vacancies. So we're really trying to move as a department, as a bureau, to help recruit and retain employees and offer competitive salaries. So I just wanted to mention that because that is part of the capacity building component, that it is a large lift. We're trying to make adjustments at the department level as well to help with that.
And anything else you'd like to add?
No, thank you.
Okay, I don't have any more questions.
Right, thank you very much. Let's return to commission questions. Commissioner Thompson.
Thank you. And thank you for your responses yesterday. I appreciate that very much. My first set of questions go to Mr. Conley. Simple question. You reported on permit backlogs. How do you measure what's a permit backlog? What are the criteria that establish a backlog? Curiosity.
My understanding is a backlog is when your permit is expired or it's passed. The state has not issued a new permit for a discharger prior to the expiration of the existing permit. Now, I will clarify that existing permit stays into effect until a new permit is issued.
Yeah. Thank you. That's my understanding too, but I could think of other ways of measuring it. So you mentioned, just to follow up on that a little bit, you mentioned the backlogs for the states in Region 6, but you didn't mention the backlog for Region 6 for issuing permits in New Mexico. Do you know what that is?
I do not know that off the top of my head. It is. I'm going to guess it's close to 20%, but that's a guess.
Yeah.
I could.
No, that's okay.
Yeah,
that's okay. Well, it's not okay if you've got it.
I don't know that I have it. But I could probably find it. But I'd have to. Oh, I don't have internet access.
We'll move on.
Yeah, I get nationally it's 21.1%. I don't know where EPA is.
So the reason I'm interested in that is that I'd like, and it goes back to the projected staff requirements that you have calculated or determined for implementation of this permit program. And so my follow-up question is, do you have any idea how many staff in Region 6 are dedicated to the permit writing?
I do not.
It seems like that might be a good piece of information to project what our needs are in the future. And so that'd be worth exploring. Let me now turn to the cost, the application costs. And I think that's in, I got too many pieces of paper. 20.6.2.235. And I didn't understand some of that. And I was hoping you could walk me through it. Let me see if I can find it.
Which one are you looking at? The 20.6.22351? For?
Oh. No, it is. I'm sorry. I misstated. It is 23551.
Sir. It might, if we can pull one of my demonstratives up, the fee calculation, I think that would be probably the best way to go
That'd
through
be fine.
it. Is that possible, sir?
While he's doing that, let me just state, and I guess this is kind of more towards Ms. Lemon, the draft in Exhibit 79A is confusing because there's 2 table 1s, there's 2 table 2s, and then there's a table that has no number. So there's some editorial issues. So while he's pulling that up, there's a formula in section 2351A. And it has a formula, and I'm an engineer, I like formulas. And the formula says that application fee is based on a base fee, which is in plus, and then parentheses, design flow times a size factor. It's a simple formula.
I think I know what, yeah. I think I know what you're getting at.
Okay, let me finish. So the application, and I was running the numbers for the Albuquerque-Bernalillo County Water Utility Authority's application, 76 million gallons per day. It's got a base fee, according to this section, a base fee of $5,000, a size factor of 0.001, 1 times 10 to the minus 4. And then the flow is 76 million gallons per day. Okay, so I run the numbers, and I did it a couple different times with and without a slide rule. And I come up with an application fee of $12,600.
The size factor gets multiplied from each flow rate. So you go through that 0.0001 only applies to the amount of discharge over 50 million gallons. So the 26 million gallons. And then you go through all of those categories to calculate and add, it's additive.
Please.
Yeah, so I think I know what you're getting at, and I think the formula needs to be clarified in there, because it is just saying the design flow times the size factor across, but the intent is that for the first 10,000 gallons, it's multiplied by the size factor of 0.0125, and then for the next 15,000 gallons, it's multiplied by the size factor of 0.0115, and so on and so forth. So the cost, everybody's paying the exact same for the first 10,000. Everybody's paying the same for the next 15,000. It's supposed to work like a tax bracket, kind of. And those costs per gallon decrease as you discharge more and more. But they're additive. So I think what you were getting at is that formula needs to reflect that each of those size factors needs to be accounted, and I would agree.
Yeah, put in a summation.
Yep.
Okay, and I assume.
Do you still need me to walk through this, or does
No.
that answer your question?
That answered my question.
Okay.
Yeah, that answered my question. If anybody else has questions, they can. And then the next one was on the annual fee calculations, and that's going to have the same clarification or revision, something like that. But now we go down to the annual fee calculation. Let me see if I can find. So it's go ahead and pick that up if you like. I'm looking for what.
Can I pick that up for you?
No.
Okay, so now I'm looking at the same section, 20.6.2.2351, and then I'm looking at B, annual fee calculations. And I'm looking at B2, industrial wastewater treatment discharge permits. Okay. Have you found it?
Yes, sir.
Okay, and it says for the industrial applications, so it's B2, small a, the fee is calculated as the number of outfalls times the base fee. So the base fee for industrial, for large industrial calculations is $7,000. Is that correct?
Yes, sir.
So for a large industry with one outfall, you would multiply that seven, and it says number of outfalls plus one. I'm sorry, times the base fee. So it's 7,000 for a let's say a power plant or something like that. Its annual fee would be 2 times $7,000. It'd only be $14,000. Is that correct?
Yes, sir. But there on the annual fee, there is a complexity factor. Like for a power plant, it would be 5 times that to account for the additional, workload for that large complex facility.
So 5 times $14,000 would be 80.
We're trying to, there's
I
the
don't see
largest
that.
part of the funds are collected through annual fees ultimately.
I'm sorry?
The largest component of the funds are collected through annual fees.
And I will also mention that the annual fee is the proportion of the fees that would be reduced based on legislative appropriations. So that would likely go down with the legislative appropriation.
Thank you. So where is the complexity factor in the section? All I see is
3A.
3.
Oh, let me make sure. That's for dredge and fill. So B. Two. Oh.
So our application.
That's right for industrial. Yeah. So those are the annual fees. So let's go back to the application fee for you're right on that. Was it for the annual fee? The application fee, because with a power plant, for example, with industrials, a lot of the work is you have to the 316A, 316B. So we really do want that application fee to help grab that, although that it's still significant on the annual. But there is a complexity factor on 2A that kicks in for something like a power plant. So it's the complexity factor times the base fee, and then you add that to the number of outfalls plus the base fee times the complexity factor again times 1.3. So it's going to be with a complexity factor of 5, it will be substantial as well.
I don't see complexity factor mentioned in the annual fee calculation. It just says.
It is not. It is not. It's in the application.
So that's in the application. I'm talking about the annual fee.
Yeah.
Yeah, it's not in annual.
It's not.
So I'm correct. A large power plant, their annual fee is only going to be $14,000.
Yeah, that is correct, sir. I just want to check my.
If they have just one alpha.
And
yeah,
most industrial, except for mine, only have one. That seems.
So my experience with, I'm sorry, I didn't mean to talk over.
Just go ahead.
My experience with power plants, and the one that we do have here has 2 outfalls. So they have, for example, an annual fee of, it's still not that much, it's $10,500. But most of the ones I've dealt with have multiple outfalls. But I understand. Yes, sir.
Seems to me the complexity factor ought to be included in the annual fee as well. Let's go back, continue on. There is a discussion of the complexity factor and I can't find it.
Yes, go ahead, Commissioner Sloan.
From that conversation, what I took from that conversation was it appears that there's a intentional reduction in cost for industrial outfit. Is that correct? And if so, why?
I wouldn't say that we did anything to reduce it intentionally. You know, we were trying to meet a revenue number that tried to be somewhat work-based, and with power plants and industrials, you know, the idea was you got to figure them out up front. So you want to try to collect, you're going to spend a considerable amount of money up front with these guys. So we added the complexity factor. And with that, we had achieved a big component of the revenue necessary to cover the industrials. Industrials have a smaller component of the overall permitting as well. So, you know, it is, I understand that it does make sense to probably reevaluate that and look at complexity into the annual fees as well.
Thank you. Commissioner Sloan? So I found the complexity factor. It's right underneath that unlabeled table. And it says the complexity, and I'm looking at 0.6.2.2351, part A, subpart 2. And it talks about a complexity factor that ranges from 1 to 5. But it doesn't say how that complexity factor is determined.
That is correct. I do believe there is one part where we mention what. Yeah, it's so there is a component. There is something in here. Where was it? The department shall consider various factors when assessing or assigning a complexity value, such as level of effort, permit complexity, type and size of the facility, volume and complexity of the wastewater, and so on and so forth. But there will be guidance also that's generated that discusses complexity factors when they're not defined. We have some ideas and tried to include examples for mines, power plants, things of that nature. But there will have to be guidance once program implementation is initiated that addresses that. And most of that, I think most of that is already somewhat determined for the NPDS side, but on the dredge and fill component, that also has a complexity factor, and that guidance is yet to be developed.
So you're not, I guess perhaps I'm asking this of Ms. Lemon, you're not intending to put the criteria that establish a complexity factor in the reg. That will be in a subsequent guidance document?
Yes, I think it would be very hard to pinpoint all of the complexities because each discharger is very unique and very different and has different complexities. So it would be very hard to say, okay, this is a score of 1. This is a score of 3. What I have seen with guidance documents is kind of like a matrix of, you know, potential complexity and the type of impacts to the surface water or aquatic resource that could result from this discharge. So it's kind of like a matrix, and you go across from like low to high and low to high, and you have different boxes to evaluate. But that guidance, yeah, I think it would be very hard to define it strictly because of the complexity of our dischargers.
I accept that. Does EPA have a complexity factor in their calculations?
They don't have fees.
Yeah. How about other states?
Off the top of my head, I don't know off the top of my head. I know when we were generating fees and looking at how we could come up with fees, we did look at many other states, and there are many approaches that are utilized by states across the country. And I don't know if complexity factor was one of the things that we had determined was appropriate or we had identified in another state. I don't recall.
Thank you. Almost done with questions. So now we go down to the first table one, individual permit fees. And I didn't understand this table. So it's got a range of, let's look at the first one, the application fee. It's got a range of values from $2,094 to $2,125. Where did that range come from?
So that range is calculated based on our, the low end, the 2,094 is the existing lowest discharger right now in our state, which is less than, I think they're 7,500 gallons per day or maybe 7,000 gallons. The top end is the 10,000 gallons per day. So because it's a calculation, we were trying to provide ranges based on different flow ranges. So a permittee, if they know they're going to be at 300,000 gallons per day, they can look and say, oh, I'm probably around 10,000 for the application fee. Or they can calculate it from using our formulas, but they can see kind of the range that they would qualify for.
So that came from that formula.
Yes.
Which will be corrected to include
cumulative
scale factors. And I assume that's the same for the annual fee?
That is correct.
Same formula? It seems to me that table's probably not needed, but if so, you might mention how it's calculated. Okay, I'm okay with that. Okay, let me go on to Ms. Lemon. And this is a question I should have asked Mr. Pettis the other day, but I realized looking out over the audience yesterday morning that there are no representatives of small POTWs. Were they contacted? Was the New Mexico Municipal League contacted? Because these are the guys that are probably going to feel the greatest pinch from this program. I mean, they may only have an application fee of $2,000, $3,000, $4,000, but for these little tiny discharges, that's a big amount of money.
Yes, we have been talking with the New Mexico Municipal League over several years about the program development, the fees. We are also considering a general permit for those smaller, less complex wastewater treatment plants. So it's still in, I think the rule still allows us to issue a general permit, but for those small municipal wastewater treatment plants to help with just getting them online. We're going to have a compliance assistance program to help. We know that they need a lot of extra help, and we've been in contact with them.
Thank you. I think it's really important because you know as well as I do. I think you may have answered this, but I wanted to ask again. There are about 110 existing individual NPDES permits. Do you have any idea how many of those will become irrelevant with the new definition of waters of the U.S.?
Those permittees, I would imagine, would come under the NMAC program, which will have that longer timeline. So they're going to have more time to get ready to come under our authority. But I don't know how many would change between federal and state jurisdiction. My understanding is after we get authorization for the NMAC program, EPA will decide which permits they will be reviewing as NMAC permits, and the other ones will be state permits. But they look the same.
Yeah. Well, we'll get to that. Yeah. I mean, it may take many years. Someone said 2030 before this thing is fully implemented. We've got a lot of work, assuming we pass this. I mean, maybe. Okay. Great. My next question, I asked this of Mr. Armstrong the other day, and he kind of waffled on it. And why are the groundwater permits so much less expensive than the proposed permit structure we've got here? And Mr. Armstrong testified we've got 700 groundwater discharge permits, and they're pretty comprehensive permits. They require monitoring and reporting, and there's enforcement. It's all of the aspects in a NMAC program or state water of the surface waters of the state, SWATs. So why is it so much less expensive?
I totally agree that groundwater discharge permits have monitoring, reporting requirements. Those permit fees, I believe, were established in over 20 years ago. They have not been updated. So they do not reflect existing resources, time, energy, whatever you're talking about. And I know the groundwater permitting program is wanting to change those fees to align with actual expenses, and that will be a big change as well. They're old.
Yes. And then you mentioned, I think there is EPA funds that could support primacy. And was it 106 funds? I think that's what you mentioned.
We do not get any more funding from EPA to administer the program. Currently, we do have they're called state assistance grant for Clean Water Act Section 106, which includes the point source regulation section. That's been how we've been paying for 401 certifications and the permitting program. So that's part of the 8.4 million. We have about 900,000 that is dedicated to out of the 106 grant that's dedicated to funding the new program. The other components are annual 106 grant is around 2 million. Doesn't change. It has not been changing. It's been going down with inflation. We've also had other things affecting it and influencing it. We get about 2 million. That's also used for our ambient monitoring program, assessment program, standards program, TMDL program, and then the point source regulation section. So we've got a whole slew of programs that are being funded through the 106 plus other funding. But that's what the grant is for.
Okay. Do other states use 106 for their permit program?
Not entirely, but they can use a portion of the 106 for funding their permitting programs. And then they use, typically it's a mix. They have maybe a little bit of grant funding through EPA, and then they have legislative funding, and then they have fees. Similar to what we're talking about.
Yes, thank you. Okay. This is my last question, but it's a zinger. Yesterday, I think it was yesterday, Mr. Mullenberg asked you a question, and almost reflexively you responded, and I copied this down because I thought it was rather remarkable. You said, for state program, we can do whatever we want. Do you want to reconsider that?
What was the question?
I don't remember. He was asking you a question about the state permit program, and you said the state program, we can do whatever we want.
The state program has to align with the regulations, right?
For NPDES.
For both. I mean, oh, the state program, okay, maybe the context was we don't have to be, we have to meet the minimum federal requirement, but we can do more. We can do whatever we want above that federal minimum requirement if we choose to.
Yes, but that's to protect waters of the U.S. What about protecting state water?
Same. We can, I mean, we're aligning with the federal program because we have to, well, as a state, historically, we've been protecting higher water quality standards for a while than the federal government and the Clean Water Act. So for state waters, we can go above. The federal regulations do not limit us as a state to regulate more stringently or have higher protections for our surface waters.
But do the federal regulations allow us to be less stringent for state waters, waters that are not under jurisdiction of EPA?
I suppose so. I don't know if there's anything in the Clean Water Act. I know there's, I think it's section 510 that says states can administer programs and standards higher or protections that are higher than the federal government requirements. I don't know if it says you can, like, it's up to the state, right, to administer its waters.
But the Clean Water Act, this is my understanding, and I am by no means a regulatory expert. Clean Water Act applies to navigable waters, which is now waters of the U.S. And it doesn't apply to state water, does it?
It does not.
So here's my question. I'm leading up to the question. Are there, so the program that's proposed in Exhibit 79 basically is the same as the NPDES program. So let me ask, are there any shortcuts we could take that would make it less expensive? So for example, and I don't know that this would be a substantial cost savings, but instead of having 5-year permit durations, we could do 7-year permit durations. And I had a couple of other ideas, maybe reduced costs or discharges that are used infrequently, something like that. So my question directly to you is, are there cost savings we could incorporate in our state water SWATs program, surface waters in the state, that we haven't explored because we've just mirrored what's going on with NPDES?
I would argue we didn't completely mirror what's going on with the the NMAC program or the NIPDES program. We do have opportunity for 10-year permit terms in here, recognizing that, you know, what you were talking about, some permittees may be in compliance and, you know, they're low risk. We can issue their permits for longer term. We wouldn't want to do that for every permit because there are different permittees and different discharges. So we tried to think of flexibilities where we can to help with the administration of the program. With respect to cost savings, we were trying to look at figuring out, I mean, without having actually driven this car and knowing the nuances of how it's going to play out and what's going to be a problem or where we can create efficiencies. We are developing a database for electronic submissions of applications, of fee payments, of data reporting, and that's making some efficiencies as far as that's concerned. You know, we're trying to create efficient tools for administering the program, which should help with that process. And Mr. Connolly and I have been talking about efficiencies when we take over the program, how to create an efficient permitting scheme with standard operating procedures and things that create a streamlined dynamic. You know, we can respond quickly, hopefully, and not get bogged down in the bureaucracy, right? Like nobody wants that. It's not what we're planning for. We're trying to think ahead and figure out those efficiencies ahead of time to help. And we've learned from other states. We're the 48th state. We're trying to look and take what's good from other state programs, from the federal program, not take what we see as things that may hinder or reduce efficiency. So that's what we're looking at. We're not trying not to reinvent the wheel, but we want to take what's good and use it for New Mexico.
I misspoke. I said there were no questions, but I do have one simple question. Discharges to Playa Lakes, they currently don't require an NPDES program.
They used to. There were NIPDES programs when I was in the Bureau to Playa Lakes. So yes, they don't now.
But they will be under the new state permit program.
We will review it for if a permit's required or not.
Okay, and my last question, and again, I appreciate your patience and your responses. My last question is actually from Commissioner Brancard. He wanted to know, and I think it's a really good question, would there be opportunities to incorporate artificial intelligence into administration of the permits? You know, we focus so much on permit application, but Mr. Connolly has testified that's maybe 25-30% of the cost of the program. For the other 75 or 65%, whatever, are there opportunities to incorporate new artificial intelligence mechanisms?
I'm not sure if I'm the best ancient person who.
But you're here.
I'm here. I'm going to ask. He knows about it.
So last time I was in New Mexico, I was right down the street at the Environmental Council of States doing a presentation. They had kind of a Shark Tank competition, and we presented the use of AI in permitting and are currently working on systems to introduce AI into permitting that would greatly increase efficiencies. And we're hoping that New Mexico will be interested in looking at that at some point in the future. And I mean, we're obviously not the only people on the street there.
Thank you all.
Hey, thank you, Commissioner Hall.
Thank you. No questions.
Commissioner Sloan.
Just have a few, I think. So you talked about a lot of spreadsheets and fees and all that kind of stuff. I'm curious if you ran the model, the EPA model, with just the defaults and how different those fees were, the default assumptions versus the ones you modified.
The answer would probably be no to that. As soon as we got in and started talking, I was probably modifying. And like, I know when I saw 3,600 hours for a general permit, I was like, if one of my permit writers took 3,600 hours. So I don't know that I ever got through the entire model with just the EPA defaults before I started modifying them. I could do that. I think it would be, if I'm going to be honest, I think it would be more expensive.
That was kind of my assumption, but wanted to see if we ran the numbers. We talked a little bit about actual discharge versus design rates. And I guess my question is, if you switched from design flow to actual rates, you still have to make $8.37 million. So the big flows are still going to pay the bulk.
That is correct. The numbers would be different, but yeah, you would have to increase it.
So you, like I mentioned, you referenced a whole bunch of EPA models and spreadsheets that you've done, including the costs for sounds like almost every permit that we've issued or that has been issued. Are those in the record? And if they're not, would you be willing to put them in the record?
They are not. The most that we've done is summarize them in my white paper with the individual components. They've been condensed, individual line items condensed into the white paper. I am a contractor and I have to defer.
Was that question for me?
It's a question about admitting the spreadsheets that are used as exhibits, I believe.
Correct.
We can.
I think it would help form the technical basis for the fees.
Do you have something to say? Okay, well, thank you.
Should I switch gears while you guys think? Okay. So we're talking about mirroring a lot of what the EPA has in their rules, and and we talked a lot of questions were asked about the specificity and why don't you tell us how to do this and who has to get a permit and the amount of discretion and all that kind of stuff. I'm curious if the proposed rule and the federal rules, is the federal rule more specific on that stuff, or does it ultimately rely on that guidance?
We were with our state program, we are trying to align it with the federal program. The federal program in our rules reference federal regulations, which have, I would have to go through and go point by point, but I believe we adopted in the state rule necessary requirements consistent with federal regulations, maybe not exactly the same language. They may be look a little bit different, but I have to go through and crosswalk it to fully answer you.
Yeah, I think I'm asking more in a general sense. Are the federal rules more specific? Can a permittee go into the rule and figure out just on the face of the rule what they need and whether they need a permit or not, versus folks seem to be saying here that you can't really do that in the proposed rule.
So in the federal program, they're similar to state programs. There's statute or law, regulations, and then a lot of guidance on how to interpret the regulations. So I know that EPA and the Corps have a lot of guidance that they use to drive their implementation of the rules. I don't know if you want to say anything else.
What I can tell you as far as dredge and fill goes, so section 404 dredge and fill applications is one of my very common lines was, if you have a question, call me. Because the bottom line is, without submitting an application for a permit, they wouldn't really know if a permit was needed or not, or submitting an application for a jurisdictional determination, which we all know is in recent times has not been super successful at getting a timely answer. So I would tell them, just call me. And this rule is extremely, like it aligns with that, where, you know, Ms. Lemon said over and over, call us. And not only that, but they've went further and said that they're willing to put in and going to put in language that talks about almost like a pre-application process to tell the applicants, the possible applicants, whether they would even need a permit or not. And I will say that the federal government has a pre-application process, but they don't have anything in their rules that really discusses this is the step before the application. So that would be my experience.
Thank you. And then I guess I just want to make sure that I kind of understand the process. So the statute spells out something, the rule spells out the next sort of level of detail, and then there's the guidance document. You can't build the guidance document till we have told you what the rule is going to say.
That is correct.
So a lot of the questions related to specificity and who's going to apply can't be answered until we get a ruling.
That's correct.
Thank you. Oh, back to can we keep that into the record? Question.
Thank you, Commissioner Behill. No question. Do we have a commissioner on the platform with a question? No. Commissioner Barundo? All right, Commissioner Bayless? No. All right. So,
Madam Hearing Officer.
yes.
Got one more question.
Actually, can I have my questions first?
Oh, I'm sorry. I was going to call on you last. That was a promise and I broke it. Please
And
go
you
ahead.
spent a lot of time. I would really like the
Yeah.
time. Okay. So follow up on the backlog. So you were saying the backlogs you're referring to are permits that have expired, correct?
They are not reissued prior to the expiration date. They are administratively extended. I don't mean to give the impression that there is no control over those discharges. When a permit is expired and the permittee has submitted an application at least 180 days in advance, their permit will be administratively extended.
So it does not, the backlog that you're referring to does not refer to a backlog of new permits that are not addressed.
I do not believe that new permits get counted in the backlog.
Okay.
They do. I'm sorry. I've been.
Oh, they do.
It's more of the time to issue a new permit. There are timelines to issue new permits, and if they don't issue that new permit within the timeline, it's considered a backlog.
Okay. Thank you. And then I don't recall the compliance assistance program being mentioned earlier. So they're in all the discussion of the expense of the permit system, there is some way to help out municipalities that are just going to suffer under it.
That's correct. And
do you have any idea how much or how many?
I do. I saw it. I'm trying to find it right now. Oh, it's down here.
But it's not something that goes in the roll, but people have this.
Yeah. There's about $500,000. Exact number I don't recall. I'm trying to look for it, but Brandon, I think it's a little.
Was it in your presentation? I just forgot.
I believe so.
Oh, okay. Yeah. Okay. Got it. Okay.
It's part of the whole $8.4 million includes permitting, compliance assistance is in that compliance umbrella, and enforcement.
Okay. I don't need to look for it if you don't want it. Okay. So again, going back to the expense of the permits. So what I'm hearing is where we've got the kind of the worst case scenario on expense of permits, and we're going to start with that, and then every year it gets reevaluated, and I think every 3 years it might have to come back to us to come up or to discuss new rates.
The way it's written is worst case scenario with legislative appropriations each year, influencing the annual fee rates. And then every 3 years, adjusting based on CPI. What has been discussed is reporting back to you our analysis of CPI, but I don't think right now that the rule requires a rule change for adjusting. We already have the adjustment in there. We just don't know what that it'll be adjusted based on the consumer price index.
Right, okay. So the annual will be based on legislative, oh, can't think of the word I want, but funds. And then the 3 years based on the consumer.
Yeah, and I believe we could also, there's also been concern about the 8.4 million. Is that really what the department is going to need? If it's less, we would adjust down. We're looking at program costs from the previous fiscal year. I mean, our budget, we have to look at what we did last year to project what we're going to need for the upcoming year. So that's part of the process too. That 8.4 million is an estimate based on the analysis that we've done. That may go down. For right now, it's not going to go up. If it needs to go up besides consumer price index, we would have to come back to you, I believe.
Okay, so this is where we get into my devil's advocate question. So if I'm the permittee is the person receiving the permit, correct?
Yes.
So if I'm a permittee and I'm in the first year of the program and I'm charged these fees and I'm a little miffed that I'm paying that much. And then next year you greatly reduce the amount that permittees are having to pay. Am I gonna get reimbursed that difference if you guys don't have a shortfall and you have an excess of funds for the program?
So everybody pays an annual fee. It's annual. So that's
But that
the
might
adjustment.
change from year to year.
One at a time.
Sorry.
Go ahead.
But that might change from year to year, right?
Right. So your annual fee would be adjusted consistent with everyone else.
But it could be lower for the next year.
The application fees are set until we do the CPI. Okay. So the application fees are set. The annual fees for all permittees would be adjusted if we get legislative appropriations and that type of adjustment. So
the application fee is pretty static.
Mm-hmm.
Okay, cool. Thank you. That helps a lot. Okay. Let's see.
Ma'am, you had asked, I'm sorry, I don't know if I'm out of procedure, but you had asked about compliance assistance and I have two spreadsheets, one for, the state and one for the federal waters, but combined it will be about 600. I just want to correct my put out.
Trying to see if I have lemon stick question. Okay. There's been a lot of, I feel like there's a lot of numbers being thrown around about how many permits are in existing programs. And I think this is gonna start with you, Ms. Lemon, are you aware, let's just use the groundwater permits. It seems like it'd be a simple system. Number one, those were established 20 years ago. The groundwater permitting program, correct?
The fees, I believe, were last updated over 20 years ago. The program, I think, has been in existence since the 70s.
Yeah. So you have the institutional knowledge to know what it was like at the program, right? So my question is, you're about to start a new program. Do you have any idea, and this gets at what happens if people object to the program as it's being started? Do you have any feeling of how much people are going to object to the program? Like if you have 100 permits and 20% are gonna object and come to us to object. Is that what's your expectation? How much is gonna come back to us because people are upset about the program?
That's always the mystery question. I would hope that as we've been working through this, we've been doing a lot of outreach and communication about this whole process. I mean, I think it's been 50 events in 2 or 3 years. It's a lot. We've talked to a lot of stakeholders. There are likely to be objections or appeals to the commission about certain permits. I'm not sure what that will look like. I'm hoping that outreach, communication, compliance assistance, helping people know like how to apply. I think the big thing that would be the fees that they're going to be upset about. I don't think they're upset about us regulating them under the NMIPTES program. What I've heard is they want state authority because sometimes EPA doesn't hear their concerns. They don't understand New Mexico. They don't understand our waters. I don't think that's the issue with the NMIPTES program. I think it'll probably be the fees because EPA does not have fees for their permits right now. For the dredge and fill, I'm assuming it'll be like the National Dredge and Fill program, which is a lot of back and forth and contentious at times.
Commissioner Frank, do you have a lot more questioning? I'm only asking because it's been more than 90 minutes since our last break, and we would need a short break.
I don't think I have a lot more. I have, let's say, maybe 3 or 4.
Kim, you okay?
Yes.
Okay.
Okay.
Go ahead.
Oh, so I was going to follow up just kind of slightly nerdy question. What would you say would be what to ask this question because it just kind of popped into my head. In terms of permittees coming to the Water Quality Commission, what percent of the permits that you guys are going to work on would you think would be a good success rate in terms of many people come to us and object?
I would think less than 5% would be a good success rate. Again, what we're attempting to do is provide reasonable, practical solutions to protect water quality. We're setting up pre-application meetings. We talk to permittees right now when they have questions. We want to keep the lines of communication open so that we're trying to reduce that probability of someone being upset with the final product. The draft permits go through a public review and comment period, including comments from the permittees. We have to respond to those comments. We have our fact sheets on how we drafted the public comments and all the reasoning and scientific and technical information we use. So we're trying to be as transparent as possible for that draft permit and the communication leading up to that to reduce the potential for appeals.
Okay, and then I want to go back to something that I was a little unclear about. So, barring permit objections coming to us, the situations where NMAD would come back to the commission is the 3-year review of the rates, I understand correctly. And are there any other situations where I think NMAD will need to come back on a planned timeline?
I'm not sure if it's a planned timeline, but if after implementing we need to, I'm assuming the rules will need some adjustment at some point, just because we didn't anticipate something's not quite working or it's confusing. I don't know what that timeline would be. We may need to come to the commission for some of the guidance documents if they fall under our water quality management plan, which is a document that you all review and approve under the Clean Water Act, but it would also include some of our state program things because it's our state water quality management plan. So that's not required to come on a regular tempo. But right now, what the Surface Water Quality Bureau does with our other regulations, the water quality standards, is we have a triennial review. It's usually it's supposed to be every 3 years we're reviewing it, maybe not every 3 years for rulemaking, but similarly, that's what we're trying to set up here is regular review and communication with the commission as we roll out the program. As the program matures, probably going to adjust and shift and change. But we would have to come to the commission for those changes, regulatory changes, or if it's in those guidance documents that have to be approved through the water quality management plan.
I have 2 more. One probably the short, longer. Continue or okay. So the initial pricing again. Let's see here. I just come back to it's like I'm gonna choose a really basic example because I have nothing better to come up with. If you have an ice cream shop and you've never made ice cream, or you want to open one and you've never made ice cream before, and you're not going to charge the highest fee you can think of. You're going to charge something lowest, in my opinion, or you're not going to have any customers. Do you have any of that sense with, like, what's the word I want? Does it bother you at all that you are starting so high for something that is going to take time to ramp up and we're going to be waiting and probably sometimes having to deal's the right word, but deal with, someone helping them do the permit process that's not done anymore? Does it seem fair to be charging more?
That's an interesting question. I appreciate the thought process. It's interesting because under the state program, we're anticipating most of the permittees will be under general permits. And we will have maybe a handful of individual permits each year, maybe not even that each year. So like the general permit is cheaper, hundreds of dollars, not thousands or tens of thousands or hundreds of thousands. It's the permittees that are already in existence under the NMAC program or the NIPD's program. That's where the sticker shock is going to be. With the new permittees, it individual permittees, it may be a sticker shock. But again, I think with the state program, what we're anticipating is most of those permittees under the state program are going to be under general permits. So it won't be sticker shock.
Okay. All right, and then just one kind of nitpicky thing. Definitely, then I gotta find it here. It was under secretary. Oh, yeah. Okay. So, if I'm reading this document and I want to know what director refers to, it's not under D, it's under F. I'm wondering if that may be something to address.
We can certainly do that. That's in existing regulations, so we didn't change it.
Okay.
So it's been like that. I don't know how long it's been like that, but I think again for decades.
And it's minor enough, maybe it's not a big deal, but it's just like the editor and me. And there was one other one like that, and I can't find it offhand. I think it was in the A's, and I'll just leave that as and that's it.
Thank you,
so
Commissioner
much.
Fry. Commissioner Brankert, I understand you've joined us on the platform. I will assure you that Commissioner Thompson already posed your question regarding artificial intelligence to this panel. Did you have other questions?
He disappeared. He was on camera then.
Oh, okay.
As you asked.
Okay. Sounds like he declined. Commissioner
Yes,
Thompson.
yes.
Oh, Mr. Chair.
Yes, I have a question or two, but
Oh,
I don't know if that is this the right time to do it?
Give me still okay. Yeah. All right, go ahead, Mr. Chair.
Madam Hearing Officer, we do have a couple of folks here who do need a break, a bathroom break.
Okay, so I'm sorry, Mr. Chair, we do need a short bio break. Can we come back at 4:45? And then I was going to give us time to move across the hall because that's where we're going to be in the morning. But I'd also like to finish this panel. All right, 4:45. Across the hall will be in room 307 tomorrow. It's larger and cooler. Commissioner Brankert, Mr. Chair, your questions to this panel, please.
All right, I'll try to keep it simple, but you know I'm a simple guy. Let me start from the beginning. The legislature enacted 2 surface water programs under 2 separate statutes. But my sense from the department's testimony, and I guess I'm addressing this to Chief Lemon, is that the department wishes to operate this essentially as one program. Is that correct?
It is a surface water discharge permitting program with different authorities, but you know, the same database, the same application process in the database. So it's aligning the programs, and both the statute and the rules were written to align the programs for NMACs and point source permitting.
Okay, well, the real question then is, when the money starts flowing in from the fees, is the fee money going into one pot or into 2 separate pots?
The fees go into the Water Quality Management Fund for use in the surface water permitting program.
So money from the NMPDS fees can be used for the state surface water regulatory program.
It's used for, yeah, I guess for both programs. Yes.
Okay. Well, my reading of the statutes 7465, 7464, I think both statutes make it clear that the schedule of fees are designed for those particular programs only. So I think we have a problem here.
I'm I'm not quite following, but I understand your concern. I know when we get funding into the Water Quality Management Fund, and again, I haven't used the Water Quality Management Fund for fees because I have not required fees for any of the program activities that my bureau currently conducts. There are ways to distribute that funding internally at the department to flag different purposes. For the Surface Water Quality Bureau, we typically, our bureau and this program is not, it's a bureau funded program. So bureau funds pay for program implementation. So I'm not, I don't know if it can get at that granular level that you're talking about, but I hear you, and I will talk with financial managers to see if I can answer that question better than I am right now.
My recollection is you can create sub-accounts within a fund. So that may be one way to deal with it. But I think the fees from each program have to support that program under the statutes. That's my reading of the statutes. They seem both quite clear in that regard. And I guess I'll just end with a reference to a case I brought up on the first day, the Old Abe case, in which the Court of Appeals actually defines what a schedule of fees is. And it might be useful for you all to look at that because the goal, according to the Court of Appeals, is that an applicant for a permit could consult the schedule and, based on the type of operation for which the permit is being sought, could determine the fee that was to be paid. Okay. It seems like we're headed toward a much more complicated calculation here that is not clear on its face how much each applicant can done. Plus, of course, we've tossed in a bunch of waivers also that make it unclear as to what an applicant has to pay. So I would keep that case in mind because somebody could sue the commission over that. Thank you.
Thank you for the comment.
Thank you, Mr. Chair. Mission Council, you had a question?
Yes, thank you, Madam Hearing Officer. So, Ms. Aguidel, I appreciate you sharing the cookies with us. Thank you for your testimony. Mr. Conley. Sorry.
You're welcome. No, I love that you got some cookies. Thank you.
Mr. Conley, one question for you. There was this discussion about the Arizona, the fees were, I think, in the $3,000, under $4,000 range. And you said something to the effect that that's not what it costs. So how are they funded then?
Well, so in Arizona for that flow range, or that, I forget how their fees, there's an application fee that has the potential to be into 54,000 or something to that effect, in addition to those annual fees. Arizona also, part of their program, I looked up Arizona like that day. How are they writing permits? So I have to look more into this. I mean, we do work for Arizona. There's not a, when you try to get in budgetary information, it's very difficult to get any conclusions on. They do receive 106 funds, and I can't say conclusively that some of those go towards their permitting, but I assume based on other states that a component does go to that. I will also let you know that they are funded through their water quality fund fee, and there, from 2023 to 2025, there were, I want to say, $23 million allocated to there legislatively. But that fee also is distributed amongst multiple programs, and I cannot with any certainty say that the shortfall was due to their NIPDs, or even that money was used for NIPD. So I can't say that. Now, I'm talking and I've forgot your question. That was not it.
Well, I wasn't sure if you had more to say, and that part was unclear with, so
Yeah.
I think the point was being made that, look, Arizona is charging this much. It's a lot less than what New Mexico is proposing to charge. And then from your experience, because I understand you work in various states in the US and you were giving comparisons to other states. And I guess I wasn't clear on what you meant by that's not what it costs them, or it costs them a lot more than that.
Yeah, well, they're not writing NPDES permits and implementing their program for like $3,500 or $3,500 a year. That is not possible in my opinion. And
okay, all right. All right, so Ms. Lemon, there's a few questions that are related to, we got public comment today from members of tribes in New Mexico. And so there's several questions related to that. And some of I heard some of this stuff for the first time, so I'm not an expert. They made a reference to the proposed language. I think that the Jemez Pueblo had provided for tribal waters or tribal water quality standards. Is that in 79A or B?
Yes, the definition for tribal water quality standards is consistent with their comments in Exhibit 79A and B.
So NMAC has been responsive to that part of it. There was a question that was made with respect to TAS, and I believe that the public commenter identified what that was, but that was a concern they raised. Is that something that NMAC has responded to?
So treatment as a state is something that is very difficult to achieve. For different tribal water quality programs, they can get treatment as a state for different Clean Water Act programs, standards, 401 certifications, NIPDES programs, etc. For our communities, our tribal nations, tribes, and pueblos in New Mexico, I believe I counted up 12 pueblos have water quality standards as treatment as a state. The rest do not, but they do have water quality that they protect. It could be not through EPA, but through their tribal council. And so that treatment of it as a state standard just makes a higher level standard that not all of our nations, tribes, and pueblos have, but they do have water quality standards that have gone through their tribal council or tribal environmental programs for their programs.
Okay. And I think this is my last question. Both of the proposed rules there's no intention that either rule will impact or affect tribal water quality standards. Is that correct?
So when we're looking at a permit and we're developing effluent limits for the permit, we have to take into account downstream tribal water quality or downstream states water quality standards. So what we would do is consult with the tribal entity, tribal government, determine which standards apply to where the discharge is, and then look at those tribal standards versus the state standard and determine which one is more stringent, because we have to protect for both, and then use the most stringent one for the effluent limit.
And that wouldn't have the consequence of altering a tribal water quality standard.
No, it's meant to protect the tribal water quality standard. So
in the event some upstream permittee would discharge something that would have an effect.
yeah, so that permittee, whatever the discharge is discharging into that surface water, when it flows downstream, it's protective of those water quality standards.
Thank you. That's it.
All right, thank you. Commissioner Thompson, while you were out of the room, the Commission Chair did ask additional questions, but you have another question?
Yeah, this is the doomsday scenario. What happens if the commission decides this is too expensive? We're not going to pass a regulation until the state provides some meaningful support. What are the consequences?
We would not have a program.
But EPA still would.
Yes, we would not be meeting our requirements under the NMAC Act or the Water Quality Act to develop a program for surface waters.
But there are other acts that we have not developed criteria for. I'm thinking of the Produce Water Act. That was 2019. We still haven't dealt.
And that's gone really well.
Exactly. Exactly. But I think it is a legitimate question that we should think about.
I think it's also something important to appeal to the legislation, to the legislators during the legislative session to request funding to offset the cost of the program, because the cost of the program is the cost of the program. We cannot have a program without funding. That is impossible, as you all know. Like, we do not have a money tree. I wish we did. We are frugal and we do a lot with not a lot of funding, but if we don't have funding, we don't have a program, and we are not protecting surface waters or surface water quality.
I understand. But if the commission elects not to pass this regulation, that would be a pretty powerful argument the next legislative session that it needs funding.
I would argue that passing the rule with these fees and having them see that and hearing from regulated community and having that advocacy could help as well.
Thank you.
Commissioner Sloan, did you have something else?
It's probably better when we deliberate on this, but I don't have an interest in violating state statute.
All right. Anything else from Commission or Commission Council?
Could I do a follow-up?
Commissioner Fry.
Very quick. Is there a penalty if we do not get this program in place with the EPA, with the federal government?
Not with EPA, but possibly the department would be scrutinized during the legislative session. Maybe additional funding for other programs in the department could be affected. It could have different impacts to the department at the state level. At the federal level, EPA does want us to take it over, but there's no need, like they don't have a requirement for us to take it over. It's only when we're ready.
Thank you, and thank you, Matt.
All right. Anything else from Commission or Commission Council? Mr. Bootsy asked for dispensation for one recross, which relates to the redirect, and it's just one question, Mr. Bootsy.
And it's a simple one, and I can wait till tomorrow or I can do it off the record. But the question is, if a permit applicant, obviously, if a permit application has a pre-application meeting, they haven't yet paid their fees. But let's say under the scenario where a permit applicant pays fees, starts consultation with the agency, and it's concluded that there's no permit needed, would that party get their fees back?
So what we are looking at including in the rule, writing some language that permit determination would happen first before you pay the fee.
Thank you very much.
Alrighty. And counsel for the department, do you want to answer now or tomorrow about whether the database will be made available?
Tomorrow would be great.
Alrighty. 9 o'clock in the morning. We're going to start with Ms. Fox and her witnesses. 3:07.